Thank you for attending the Finance Committee meeting. Today is Thursday, February 27th. I'm Senator Pam Vidal, Chair, and with me is my Vice Chair, Senator Hayes. We're happy to have you with us today. Sponsors, when you come to the table, you can have as much time as you need to explain your bill. Witnesses, please respect the 2-minute timer. I'm going to read the bill order, which could change depending on people being in other committees or people that should be here or testifying in other committees, so it could change. But we're going to start with Chair Senator Smith, House Senate Bill 928, and then 846, 914, 987, 976, 842, 691, 936, and 918, all subject to change, that being said. Senator Smith, would you like to come to the table and bring with you your panel, Secretary Tony Woods and Jason Spiegel?
Thanks. Thank you very much, Madam Chair. Would you like me to stand or stand?
Whatever you're comfortable doing, Senator. We're happy to have you here.
Excellent. Thank you very much. I guess my panel can join up. This Mr. Secretary and Mr. Spiegel. All right, thank you very much, Madam Chair, members of the Finance Committee, the distinguished Finance Committee. For the record, Senator Smith here to enter into the record Senate Bill 928. By my account, I see a couple of, well, I see one veteran here, and then obviously someone who is an esteemed member of the veteran family, Senator Guile, who's won several awards for her work supporting veterans, also supporting her husband and his many deployments overseas and CONUS. What this bill does is addresses an issue of how we, as veterans, seek out our benefits. This bill actually came to my desk, and I became aware of this issue and problem this bill seeks to solve from the Secretary, who you will hear from in just a few minutes. Essentially, especially, and this is a problem that's been exacerbated with the passage of the PACT Act, which passed a couple of years ago, which passed in 2022, which allows for easier access for members who have suffered from burn pits and have had trouble getting and garnering those benefits at the federal level. As of 2023, the Office of Service Member Affairs, that's a national organization, says that approximately 9,300 complaints about targeted scams for service members seeking these benefits. So essentially the way that this works is that if you are a service member seeking a benefit and you are having trouble collecting all the requisite information to submit your package to the Veterans Affairs, you can go several routes. Federal law prohibits under federal law, prohibits anyone who's not accredited by the VA, an organization that's not accredited by the VA, to help in that effort, to assist in collection of that information and then submitting it to the VA so you can secure your benefits. There is an industry that has arisen to help assist veterans, and I know that we've had plenty of conversations in the Veterans Caucus about this, of members who've actually availed themselves to these services, these firms that help you collect that information, assist with your package and submitting it to the VA. There is somewhat of an uncertain or ambiguous field here because federal law precludes those entities from operating unless they are accredited. But in 2006, Congress passed an amendment to a piece of legislation that stripped away some of those enforcement mechanisms, the penalties for those operators. And so now you have an industry that you have private entities and organizations that are assisting with questionable, in a kind of a murky legal field because it's of what the federal statute has said for us. And then you have, so some of those organizations act in good faith, and you'll hear some people speak to their positive experience with those organizations. In the alternative, there are several, and you'll hear from this in a few minutes, several organizations that act in very perverse ways, and there's fee structures are exploitative for the member. They take portions of the benefits that are accruing for that member, and they're charging exorbitant fees. And so you've got two sides of an industry that really can harm our veterans seeking to get the benefits that they've earned through their service. So what this bill does is, as drafted, it says that, look, if you're not accredited by the VA or otherwise authorized under federal law, then you can't assist in that. You can't enter into this marketplace. You can't help prepare or assist in the preparation of these benefit packages for the VA for consideration for your benefits. It sets forth clear penalties. So if you violate this part of the statute, then you are going to be a violative of our deceptive trade practice law here in Maryland. So because there is this ambiguous framework at the federal level, several states have moved forward with ensuring that this practice doesn't thrive here in Maryland and that our veterans are not exploited through this practice. So that's the sum and substance of the bill. The bill is only 3 or 4 pages, pretty clear. You will hear from also industry members that are attempting to act in good faith and provide services, and you'll hear amendments that set up rules of the road. I think the question for this committee, Madam Chair, is whether you want to move forward with prohibiting this practice altogether, or are you going to erect certain barriers to let certain actors enter this marketplace and perform this service in Maryland. You'll hear from the Secretary and several members of the veterans community attesting to their desire to prohibit this practice as a whole. And so with that, Madam Chair, I'll rest and turn it over to my panel, and I'll stand by for questions.
Secretary Woods, would you like to start?
Sure. Thank you, Chair Beidel, and members of the committee. For the record, I'm Tony Woods, Secretary of the Maryland Department of Veterans and Military Families, and I respectfully ask the committee for a favorable report on SB 928. No veteran or family member should ever have to pay to access their earned veterans benefits. SB 928 extends consumer protections to Maryland veterans and ensures that only accredited assistance is available for navigating the VA benefits system, safeguarding veterans from predatory practices. As VA benefits expand, so too does the need to guard against bad actors who prey on veterans with high-pressure tactics, false promises, and exploitative fees, often referred to as claim sharks or claims predators. These entities operate much like predatory payday lenders who charge exorbitant fees and exploit vulnerable individuals. Just as we protect consumers from financial traps, we must also shield veterans from those who seek to profit off their benefits. Claim Shark's lucrative enterprise allows them to make millions of dollars off veterans by operating outside the federal regulatory system designed to prevent such economic exploitation. There's nothing stopping them from becoming accredited as individuals except their own financial interest in avoiding oversight and regulation. The VA accredits individuals and organizations that assist veterans in accessing their benefits, upholding them to strict standards, including offering free assistance. Maryland meets this standard by providing accredited programs that last year alone secured nearly $45 million in VA benefit payments for Maryland veterans at no cost to them. We supported 5,100 veterans through that process and had a 94% claims acceptance rate when we supported those veterans. Trusted organizations like the American Legion, the VFW, and the Disabled American Veterans also adhere to these protections. I urge this committee to send a clear message. Maryland stands with its veterans, not with those who seek to profit off their expertise, at their expense, A favorable report on SB 928 will protect our veterans, safeguard their earned benefits, and affirm our commitment to those who have served. Thank you.
Thank you, Mr. Secretary. Who would like to go next?
I'll go next. Thank you. Thanks, Secretary Woods. My name is Andy Gross. I am an accredited attorney with my own firm assisting veterans appeal unfavorable disability benefits findings. I want to explain some basics here on how this works. In order to represent an individual before the Department of Veterans Affairs, one must be accredited. Since about 2006, and more so recently, unaccredited claims consultants, and I put those in scare quotes, have popped up, and they charge fees that are not contemplated by the CFR, that are actually illegal. In fact, these claims consultants have been addressed by the VA through cease and desist letters, which companies like Veterans Benefits Guide and Veterans Guardian have received from the VA saying what you're doing is illegal. And the reason it's illegal makes a lot of sense, actually. Their fee structure is intrinsically predatory because what it does is it charges a multiple of the increase. So let's say a veteran goes from $0 to $2,000 a month. The fee is $10,000 a month, $10,000 for that benefit. The problem is that there's no fiduciary duty to the client. There's no mechanism to go after bad actors. But the most important thing is that it doesn't actually solve the problem. When an accredited person such as myself gets into the file, we can figure out what the problems have been going on, why the veteran's been kept from their disabilities, where the VA has been making mistakes. Sometimes we find mistakes that go back 30 plus years. In fact, I'm currently working on a case where a particular mistake has left the veteran entitled to close to 30 years of retroactive benefits. And this is significant. But there's absolutely no incentive for the claims consultant, the unaccredited claims consultant, to look at that. They're there to come in, juice up the claim, fill out a couple forms, collect their $10,000, $12,000, $14,000 and walk away. It's an intrinsically predatory practice. There's no way to put it out there. And if this is about choice, like I said, I'm an accredited attorney. I'm not a VSO. I do charge a fee that is legal under the CFR. And my name goes on all the documents we file with the VA. So if the VA wants to come after me for bad behavior, they can. And if I invite them, if they want to do the right thing by veterans, they should join us in becoming accredited. We'll welcome them as partners in this process.
Excuse me. Thank you, Chair Beidel and members of the committee. I'm Jason Spiegel, president of the Maryland Military Coalition, and we join in recommending a favorable report on SB 298. The legislation would ban claims predators from preying on veterans by charging to process a claim or appeal denial of benefits. SB 928 incorporates federal law into Maryland law by providing that no one may charge fees for claims assistance who is not accredited by the U.S. Department of Veterans Affairs. Accredited agents, as has been described, include claim agents, attorneys, and veteran service organizations like the VFW and American Legion. Fees that agents and attorneys may charge are capped, and VSO services are provided free of charge. Banning claim predators does not limit the option that veterans have to obtain claims assistance. The simple solution for those currently providing services in violation of federal law is to become individually accredited. Doing so is neither complicated nor onerous. The objection to obtaining accreditation is that claim predators want to continue to charge whatever they can get away with. As the committee is aware, New Jersey passed a similar law, the constitutionality of which was upheld by the U.S. District Court for the District of New Jersey. The court stated that the purpose of the law was to prohibit unaccredited personnel from charging veterans for unaccredited services. The law regulates conduct and does not impinge on any First Amendment free speech rights. Accreditation also ensures that claims representatives who harm veterans or fail to perform their undertaking can be held accountable. Without accreditation, there is no government entity that can protect veterans from bad or incompetent actors. The Maryland Military Coalition therefore requests a favorable report on this bill.
Thank you. Who's next?
Good afternoon. I'm Kurt Serber, 24-year Army veteran and the commander of Post 304 here in town. I'm also the VFW State Legislative Representative. I'm here today on behalf of our almost 360,000 veterans in this state. SB 928 seeks to protect our Maryland veterans from the illegal and predatory practices of organizations we call claim sharks, who charge exorbitant fees to assist veterans with their VA claims. And I say assist in quotes as well. It is and always has been illegal to charge a veteran to file their VA claim, but criminal penalties were removed for violating this section of the law in 2006, which has allowed the claim sharks to operate an illegal loophole where they are violating the law but are unable to be charged for doing so. With the passage of the PACT Act, the VFW has observed an increase in online advertisements from these predatory claims consultants that targets veterans' earned VA benefits. Indeed, if you Google VA claims, it's the hits for the claim sharks that come up first because they pay for it to be that way. These groups promise to maximize veterans' VA disability ratings They argue that the high fees they charge in some way make them more effective in assisting veterans than the free services that are offered by VA accredited service organizations. The claim sharks claim that they are providing choice, or that they can do claims better or faster. Claims move at the speed of the VA, and claim sharks juicing claims for higher ratings only slows the system down. When the VA reviews these claims and finds fraudulent or inflated evidence, it's the veteran and not the claim shark that pays the penalty. They also claim that it's too hard to become accredited. But the truth is they don't want to be accredited because then they'll have to follow the rules. Claim sharks are offering amendments to this bill, and they say that they oppose bad actors. This is a ruse. They are the bad actors. They are just trying to fool you into allowing them to continue their predatory practices because that is what their industry is built upon. We ask you to move this bill forward as written, protect our veterans from predatory claim sharks looking to pull money out of their pockets and out of Maryland. Don't be fooled by their platitudes. They are predators who are only concerned with preserving their profit margins and not with doing the right thing. We're asking you to do the right thing. We thank Senator Smith for his service and for introducing this bill. Thank you.
Thank you. And you must be Mr. Moses.
Yes, ma'am.
Thank you. Go ahead.
Thank you. Thank you for this honorable. My name is Mike Moses. I am a Vietnam veteran, former Maryland State Commander of the National Association for Black Veterans, and an accredited VSO officer. Since 2012, I have processed hundreds of veterans' claims. I have organized frequent claim clinics in support of veterans and caregivers of all races, genders, particularly Black veterans from across the state of Maryland. However, I have observed an increase in non-accredited veteran claims assistance since the COVID and an enactment of the PACT Act, which expands VA health care and benefits. This has cost veterans thousands of dollars for the process that should have been free and has led to future reductions of their benefits. I recently received a mail personally from an out-of-town law firm from Chicago. The firm informed me that they were aware of my disability and my records and could assist me in increasing my benefits and compensations. We had an uncomfortable 15-minute Q&A. However, the record, they stated they knew about my disability without my consent. How they got my information till this day has never been revealed. In closing, I asked that the representing firm if they were aware of presumptive, secondary, direct service connections, or what was the difference between PTSD and acquired psychiatric disorder. The phone went silent. If they were accredited, they would have known the answer. This Senate bill will help provide generations of veterans and their survivors with the care and the benefits they have earned and deserve. This is why I'm asking for your support for SB 0928. Thank you.
Thank you, Mr. Moses. And then I just want to mention James Campbell was due today and has a family member that's sick, and he sent written testimony this morning. I have a question, Senator, and thank you all for your service, and particularly Senator Smith. In the bill, I'm reading that enforcement is in Title 13 of the commercial law, and I'm trying to, as you're talking, breeze through this. Is it a financial enforcement or financial penalties?
So that's the consumer protection, and the penalties are civil and criminal. If you look into are potentially civil and criminal. The fiscal note, page 3, at the bottom paragraph, outlines the penalties. So a merchant who violates the MCPA is subject to a fine of up to $10,000 for each violation and up to $25,000 for each repetition of the same violation. There are also some potential criminal penalties. Guilty of a misdemeanor and on conviction is subject to a fine of up to $1,000 and/or imprisonment for up to 1 year. So there's some elasticity and discretion within the statute, but those are the penalties.
And Senator, are there any amendments being offered that you support? Do you know?
So it depends. So I'll leave that to the discretion of the committee. And I outlined that you'll hear some testimony with folks, and I've had this conversation with veterans in the Veterans Caucus here in the Senate, as to the efficacy of some of the private services that they've sought. So I think there are two routes you can go. One is you can go the route that we're suggesting here, which is to make sure that everyone's accredited. You heard the Secretary speak to the over 90% success rate, 94% success rate. I think 45 million in benefits collected. So what they're doing is tremendously effective. So you can go that route. Or the second route is if you want to create a permissive environment for some of these private actors to come in, you should erect some significant barriers or rules of the road, which I'm sure you'll hear folks that are going to testify favorable with amendments. I defer to you on that. I'm putting forward this clean bill, and that's what I'm endorsing here today.
I think you just answered my question.
Excellent.
How difficult is it, Mr. Spiegel, how difficult is it to become accredited? Or, I'm not sure, the attorney, how difficult is it to become accredited?
If you can read, it's doable. I mean, you do have to read a bit. No, so seriously, it's been a while since I got accredited, so I don't even quite remember. But it's if you're getting accredited as an individual, there are a couple pathways to get accredited, which is important to note. If you're accredited as part of a veteran service organization, the veteran service organizations such as DAV, VFW, they handle your accreditation through their channels. For someone like myself, as an attorney, I had to go through a background check, which wasn't very onerous, and I eventually got fingerprinted, which now that there are more people working inside the VA offices, I suspect that'll happen even faster. There's some forms I had to fill out, and I had to take some like HIPAA training so that it was computer-based training. It was maybe a couple hours, but it wasn't that onerous. Now, if you're not an attorney, there's a little bit of coursework you have to do, and I think you have to pass a test. But
I can talk to someone.
And in fact, one of the people that I look up to in this industry is a 25-year-old guy, not an attorney, who got accredited and is just absolutely doing a great job serving veterans. So it's not that onerous.
Madam Chair. I just want to make sure that I will submit this to the record. I have the statute actually outlines the rules of the road for certification. So I will submit that to you. I don't want to go over it for time's sake, but it's a pretty. No, I have a one pager here for you that I'll submit for you, Madam Chair.
Thank you, Madam Chair. Yeah, I have a family member who just went through a long battle to get the status of not fully disabled, but partly disabled. And I was actually curious what he had done. He hadn't talked about it much, so I didn't know what he hasn't gotten back to me yet. I'm curious about a couple of things. One is we don't want anybody exploiting veterans for their benefits. But I also know when people go for disability, there are lots of practices that help people get disability, just regular disability. You can go to an attorney to help you with a disability claim for Social Security disability or other types of government services. So, there's the balance. Can I ask for the attorney, what you're accredited to help with this, correct? Or is it certified? What's it called? Certified?
It's accredited.
Accredited, yeah. So what do you, if you don't mind me asking, what's a typical amount of money that you would make for a case?
So it's all over the place. Okay. So for instance, I do a number of initial claims. So first of all, I can never charge a fee for an initial claim or a request for increase. An initial claim and a request for increase, I cannot charge a fee on. I can only charge fees on appeals. I do a number of initial claims every year, just pro bono, because I'm a veteran and I have a hard time saying no to non-revenue work sometimes. But I mean, these are my people, right? So I do a number of these claims. For the fee cases, it ranges tremendously. I have some cases where
what's a fee case?
Cases where I've done an appeal and we've won an appeal. And some of these cases where I've done an appeal and won the appeal, the fee is maybe a couple $100. But it can be much higher than that as well. So for this case where we found that the veteran, I think that we're able to get an effective date rolling her back and getting her profoundly disabled individual from 1989 onward, such that she's never worked and been under the care of her parents this entire time. The mistake that the VA made was such where we may be able to get her an effective date and 32 years of benefits, which will be just shy of $1 million, and our fee is going to be 20% of that.
And but 20% is a fee that is approved by?
That is presumptively reasonable. Some firms charge a little more than I do. I charge 20% because.
And does your fee have to be approved by the government?
So
Or the statute?
let me reframe it. My fee is the VA sets out.
I'm not criticizing you for getting a fee. I'm just trying to understand the process. Yeah.
I make my living helping veterans, and I cannot be prouder of what I do. So I don't take any offense if you ask what my books look like.
Yeah.
The answer to that question is that the VA states that 20% of retroactive benefits is presumptively reasonable.
Okay.
Some firms charge more than that, but they have to go through some extra hoops to charge that rate. The VA also will withhold the fee from a retroactive benefit. So let's say I win an appeal for a veteran, and the VA needs to pay him 10 grand in retroactive benefits. The VA pays the veteran 8, and eventually, several months later, they pay me 2, right? And that's closer to what my average fee is. They won't do that if I charge more than 20%, so I would have to collect from the veteran, and I've decided that I don't want to have that relationship with my clients. I just,
sure.
I would just make it easy on myself. So I charge 20%, which is, again, like I said, presumptively reasonable. Also, there's a fee challenging mechanism. So if a veteran says, Andy's a bum, he didn't do any work on my claim, he's not entitled to a fee, they can actually write to the VA and say just what I said, and I have to justify my work to them for that.
Thank you. And so right now, these businesses that are operating don't have to do any of that.
No, they have, and I don't know about the individuals who were speaking later, but a lot of them have arbitration clauses requiring to arbitrate fee disputes, so keeping it out of court.
I guess my question, okay, this is all really helpful because I'd be fine with be like, yeah, just get rid of all of it. Let's just stick to this. But we also know there's a long waiting period. So sometimes people will pay to get somebody to help them. I mean, in general, nationally, I know you guys are doing great work at the Veterans Administration. So is there not some place, I guess I'm asking is the bill of clean would just ban these basically unless they get accredited. And so I'm wondering if there is an argument for having something available for if someone doesn't want to hire an attorney for whatever reason. And to me, it is a marketable skill to say we cut through the red tape more quickly in certain cases. So, I mean, can you just, if you'd like to speak to that, Mr. Secretary.
Yeah, absolutely. Thank you, Senator. It's a great point and one that we've heard a lot about. As we mentioned, there is no fast track. There's no fast lane. There's nothing different. If you would like to be represented for free and you want an appointment tomorrow, you can do that with my department, right? And many of our veteran service organizations are similar. We've actually worked very hard since last year to bring down our wait times to make sure that if you want to sit in front of someone today, within 2 weeks at our busiest locations, you can have an appointment in person. But you could have an appointment tomorrow virtually if you want that. So that's quite important that we point that out. But when we submit a claim, again, it is subject to whatever the VA's backlog is of working through all of their claims. A claim shark does not have a different path. They're not going to be faster than anyone else. And in fact, as they mentioned, it actually slows down the process because they have a vested interest in getting the number as high as possible because they're going to take a cut. So they'll throw everything at the VA possible, and by law, the VA has to review every single claim in front of it, and that's what creates a backlog. So they're actually making the problem worse, they're making the lines longer, and they're not speeding up any sort of process. They're actually making it all slower.
Thank you for your answers. Thank you, Madam Chair.
Thank you, Senator. Senator Ellis.
Thank you, Madam Chair, and thank you, Senator Smith, for this bill, and all the folks who testify. I appreciate you and your service. And so Senator Smith mentioned there's a veteran here, and that veteran is me, Senator Arthur Ellis. Served for many years in the Air Force as an Air Force officer, injured in the line of duty, and got a lot of help from the Disabled American Veterans. Just want to say they handle your case for free. I'm a life member of Disabled American Veterans, and I carry their number around with me in my phone because I meet a lot of veterans, especially when I drive around with my disabled veterans license plate, and they talk to me, and I give them this number, which is 410-230-4440. And I gave it to one individual, connected them with a DAV. Took him 4 years to adjudicate the claim, all the way up to the Court of Veterans Appeals in D.C. at zero charge. And when that veteran got his payment approved, disability approved, he got 100% of his back pay, 100%. So I'm just kind of astounded why anyone would go to anybody and pay them anything when all these great organizations are here that will help veterans get their money. And folks have come to me who are in the professional business of representing veterans and saying that there are not enough veteran service officers out there. There are not enough people to help veterans. That's why these for-profit players come in and step in and provide this great service to them at whatever percentage they want to charge. I've never experienced that backlog. And listen to you, Mr. Secretary, you saying that is not true. There is no backlog. Could you expound on that, please, again?
Absolutely, Senator. So if a veteran wants to be represented and start the initial claims process, we can meet with them virtually tomorrow. They can immediately start the process. We can work with them as long as they want. They have up to a year when they file an initial intent to file a claim, and then they'll retroactively receive payment as though they've been getting paid every month.
Okay. Mr. Speaker, as a member of the representative leader of the Maryland Military Coalition, DAV, American Legion, VFW, do they have huge backlogs that turn people away? Have you heard of that?
I'll defer to Mr. Serta.
Sometimes it takes a little bit to get an appointment because we've got our service officers and there's a lot of veterans in the state, right? But they do what they can to get you in. We're adding service officers all the time.
Yeah.
And actually, the National VFW Service Officer Training is held here in Annapolis twice a year, here at the Doubletree.
But a veteran who wants your help, do they get in?
They do get in.
How long a wait do they have generally?
It's a couple weeks in our
Couple weeks?
Yeah.
So if you wait a couple of weeks, and we have veterans listening to this, that's why I want to bring this out.
Yeah.
Those veterans, if they're not willing to wait a couple of weeks, they're willing to give away, say, $200,000 of their checks for just 2 weeks of wait?
A lot of it is advertising.
Advertising.
A lot of veterans really aren't aware that the free option is there, and the advertising is in their face that the claim sharks are there saying, oh, we can do this for you. We're going to hook you up.
So,
and a lot of veterans don't know any better.
Don't know.
Yeah.
So we are failing as government, as veteran organizations, not letting our veteran population know what they should be doing.
All right. We're getting better. We're getting the word out as much as we can. I know the VA has really ramped up on trying to get the word out.
So how can we succeed?
It's difficult.
Well, how can we succeed?
Just more getting the word out. I think it's.
No. How can we? What should we be doing?
There are a
reach these
couple.
veterans?
The VFW is working on something where there's a thing called the TAPS class, which is the Transition Assistance Program, and the VFW is sponsoring. What we're trying to do is get it so that there is an accredited service officer at every Transition Assistance Program class session.
Right.
So that person is there as the veteran is transitioning out of the military. They can sit down and start the process before they even leave.
Okay.
That way, that paperwork is done. They don't have to worry about it. They transition, and the process works, and they get their claim.
Okay.
If I could speak to that too, Senator, you've made an excellent point. It's what keeps me up at night, the fact that I know that we've got this great free resource that is successful that helps veterans every day, and that they don't know that it exists. That bothers me a lot. We have increased the number of our veteran benefits specialists. We actually co-locate them now in 8 different motor vehicle administrations across the state. We found foot traffic is very, very helpful, and that increases their awareness of it. It's how we find out that they're a veteran when they want to get that veteran on their license or license plate. But you're absolutely right. We have to do more as a department to advertise that free service. We've also invested in a comms director with expertise in social media. We have to really focus on getting the word out. 40% of our veterans are unconnected to their benefits. That's our target population. We have to reach them where they are in new ways. It's a significant number.
Okay, thank you. I got some ideas. I don't want to take up more time, so we'll reach out to you, Mr. Secretary, Mr. Chair. Thank you, ma'am.
Thank you,
If
Senator.
I may,
I just want to compliment the Secretary's staff. You're amazing. I've had to call a few times for help, or I've been referred people, and they're prompt, they answer, they've always been accurate. You're really doing a very good job with your staff. Thank you, Secretary. Senator Jackson?
Thank you, Madam Chair. I just want to thank you, Mr. Secretary. He was able to help me get one of my veterans a new roof in my district. So I'm really grateful to you and your staff. My question is, in terms of getting the word out, is there like a flyer or something that like we can share on our social media to help you get the word out about?
That's a great idea, Senator. So one thing, we're actually partnering with Do It to revamp our website, and we think that always helps to just have easier access to information, make it clear, oh, I can make an appointment where I live, all those types of things. We would love to collaborate with you because you're absolutely right, Senator. The number of delegates and senators who are interacting with the constituents who need help every single day. It's one of the calls that we love to take and love to work with you on that, but we can make it even easier by equipping you with that. So we're happy to follow up on that.
Thank you, Mr. Secretary.
Senator Mounts?
Thank you, Madam Chair. I just want to also welcome and thank the Secretary, constituent of District 37. And I kind of want to follow up a little bit on my colleagues' comments. It's a little off the bill. There is just so much support and desire on the Eastern Shore to pursue a veterans hospital on the Eastern Shore for our veterans there. They'd have to travel to Baltimore. It's a long way to go. And
Sure is.
along those needs that are being served, one of the greatest things that could come out of this discussion, well, I wouldn't say the greatest things, but I just would want to leave this discussion without leaving that on the table for our veterans on the shore who can get to Wilmington in a short amount of time. And then the idea that they have to travel across the bridge, oftentimes with disabilities and things like that. It's a really important thing. And I know you've heard it over and over, but since we're on the record, Mr. Secretary, thank you for listening.
I appreciate that, Senator. And one quick thing I would add is that, our veterans in Western Maryland and on the Eastern Shore, it's one thing for us to help them get access to their benefits because, now they've gone through the process. It's another thing for them to be able to actually make it to their appointments. And I think that's why it's so important that we not take any money out of that veteran's pocket, because that is what helps them pay for the transportation costs to get to a VA appointment. We think that's really vital, and all the more reason why we shouldn't allow folks to prey on them.
I don't see any further questions. No, I don't see any further questions from the senators. Thank you all very much for your testimony. We are now going to move to another panel of favorable with amendment. Bernie Marsick, William Taylor, and Bruce Bariano.
Yes.
Bernie, would you like to start?
Yes, ma'am. Thank you, Madam Chair, members of the committee. Bernie Marsick from Cornerstone Government Affairs here today on behalf of Veterans Guardian. You will hear from Bill Taylor very shortly, but Veterans Guardian is a disability claim consulting company. It's owned and operated by veterans and their families. We have served, Veterans Guardian has served more than 30,000 veterans across the country, including over 2,000 veterans here in Maryland. We're here today supporting with amendments that are in our written testimony to Senate Bill 928. These amendments will ensure that veterans continue to have the choice in pursuing assistance with their benefits. We provided several amendments in our written testimony. They're outlined in the bullets on page 2 of the written testimony. And I think I want to thank Chairman Smith for his willingness to have conversations on this bill and his openness to these amendments. We look forward to working with you and the committee as we work through the process. And I will turn it to Bill, and he can talk through some of the process and answer a lot of your questions that you may have. And thank you very much. We'd ask for favorable with the amendments that we have provided to the committee.
Thank you, Bernie. Mr. Taylor?
So my name is Bill Taylor. I'm the co-founder and CEO of Veterans Guardian. I'm a 23-year Army veteran. My company, we employ over 200 people. Most of them are veterans, spouses of veterans, and spouses of active duty. We are proud of the service that we provide to our veterans on a daily basis. We have an over 90% success rate with everyone we work with, and our average veteran is getting a decision back in 85 days or less, compared to the national average of 152. I do not have a fast lane, but what I do have is the thoroughness of the packets, and I can provide some more detail on that. We do nothing but fully develop claims and do not rely on the VA's duty to assist with any claim we submit. I would also like to note that we work strictly on a contingent basis, and the veteran only gets charged a fee if there's a successful increase in their benefits. And my average fee is not tens of thousands of dollars, it's about $4. And so we believe that we are charging a reasonable fee, and the veterans understand that. There's two things that I would like to address. I respectfully disagree with the insinuation that we are operating in violation of federal law. In 2006, they not only removed the penalties, but they also rewrote the underlying statute. Prior to 2006, the law said you can't assist unless. At that point, we were illegal. They changed it to read you can't act as an agent or attorney without being recognized. We never take that step into agency. The veteran represents themselves to the VA. We are acting merely as a consultant to help them navigate the process. And because of that, we remain in compliance with federal law. I'd also like to note that I want to be accredited. I am fighting at the federal level to become accredited. There was a bill introduced just today by General Jack Bergman to reform the accreditation process. I am not accredited right now because you cannot charge a fee to assist with initial claims, which is the majority of what we do. So I push back on the notion that I don't want to be accredited. What we're proposing here today will help to address some of those issues and provide a right of action for veterans to come after us.
Thank you, Mr. Taylor. And Mr. Mariano?
Good afternoon, Madam Chair and members of the Senate Finance Committee. For the record, Bruce Bariano. I'm here on behalf of Veteran Benefits Guide in support of this bill with amendments. First, let me say, very respectfully, I'm very disappointed by the comments of some of the speakers as proponents of the bills. My client and the client that you heard from before, we're not sharks. We're not charlatans. We are not unprofessional. Some of the accusations made are very inappropriate and really not founded at all. My client, Veteran Benefits Guide, is owned and operated by a Marine who is no longer in service, although you're a Marine for the rest of your life, and his wife, who also was in the military. And they're not about the business of preying on and being predatory towards members of the armed services that they have served in. We provide a very vital service, and we provide it at choice. The bill, I ask you, Madam Chair and members of the committee, wait till you see the amendments. There are so many guardrails that have to be put on this to protect veterans, and we are all in favor of that. They're not even in the bill. We are not accredited by the Veterans Administration because we provide pre-services and advice and counsel to our clients. We're in many other states, and we want to do business here in the state of Maryland. And unless we can change this and straighten this out, we will be left behind. I think there's a sign out there, don't leave anybody behind. We want to help veterans, and all we want to do is provide a choice. One of the amendments is telling the veteran that the veteran, he or she, can go to a free service, can go to the state Veteran Affairs office and not use our services, and sign on the side, not just below, so they know that they have that option. Veterans should have options and choices, and that is what you will see respectfully with these amendments that we are offering to the veterans here in the state of Maryland. Would ask your favorable support with these amendments and ask you to look at them before any judgments are made.
Mr. Bariano, thank you for your testimony. And I see that you've signed in for oral testimony, but I don't see any amendments from you.
The amendments are being prepared.
Okay.
They're the amendments that both the previous witnesses and us that we're all working on. They're the same amendments. We're frankly waiting on the amendment room. Okay. Amendment room, God bless them. And I think you should go a little quicker. But,
They're working really hard, I have to tell
yeah,
you.
no, we are. But I think you'll be very pleased with them.
Okay.
And we've met with members of the Senate that are in the military and have been in the military to personally ask them and invite them, give us additional suggested amendments to guardrail and protect the veterans. Thank you very much.
Thank you. Senator Reedy?
Thank you, Madam Chair. And maybe my question would be for Mr. Boatwright, just because I'm interested. Generally, I think we try to give everybody a fair shake in the committee. Hearing what I heard from the first panel, I came in saying we probably want to try to preserve some pathway just based on what I read, but it's like I hear things that are concerning. So I want to give you a chance to respond. You mentioned accreditation and that you're not you're pursuing it, but you can't at this time. So this first question, then I have a follow-up on a separate issue. What's the deal? Why can you just elaborate on that? Why aren't you accredited?
And actually, it was well addressed by one of the previous speakers on the panel. Prior to 2006, no one was allowed to assist a veteran for a fee in any capacity whatsoever.
And you were not at that time.
And we were not,
right.
no. After 2006, they changed the law to allow agents and attorneys to come in and assist with appeal work, but they still maintained the prohibition on assisting for a fee with an initial claim. The lawyers, they're focused on doing appeals. My business model is focused on helping a veteran. I look at three pillars. I want to look at things they should have claimed that they didn't. That's considered an initial claim. I want to look for secondary conditions. If you're rated for your back and I'm now getting radiculopathy, that's also an initial claim. We also look for rating increases, which is considered an initial claim. I can't help with any of those for a fee as an accredited agent right now. So we made the choice to operate as an unaccredited entity because it allows me to better serve my veterans. I can look at them holistically and I can help them across the breadth of what they're eligible for. I want to be accredited, but in order to do that, what we are proposing with the PLUS Act at the federal level is it allows a veteran to charge a fee at any step of the process, but it puts guardrails in place, requires fees to be contingent on a successful outcome, no upfront non-refundable fees. It puts in on either $10,000 or $12,500 fee cap. It requires us to notify veterans in writing that there are free services available and where they can go find them. It has prohibitions against predatory and misleading advertising. I could run down the continuing list. You pick all of the complaints about our industry, and we address them in this law. That bill is being supported by the House Veteran Affairs Committee. Chairman Mike Bost is supporting that bill, and we believe that it's got a high likelihood of...
Let me, not to cut you off, but I know we're short on time. I appreciate all of that information. So what is your value prop? What are you bringing that we don't have here?
So so there's a couple of things. Number one...
I mean that I'm not trying to give you a sales pitch, no offense. I mean, I wonder why is there a hole that you're filling, I guess, in your opinion?
The one thing I can tell you is that we went through 6 months of decision letters coming back from our clients. And if you were ever represented by a VSO before, unless you go in and actively remove them, they remain your agent of record in perpetuity.
Okay.
70% of the decision letters coming back on my clients have a VSO listed as the agent, which means that at a minimum, 70% of my clients have gone to a free service before they come to me. There's a host of different reasons that they're doing that. I can't answer what that is. What I can tell you is that I provide I've been able to leverage technology. I can use AI to do medical record reviews. 10,000 pages of medical records, I can do a complete review of those in 20 minutes. When I submit a claim, my claim packets are 60 to 80 pages long.
Okay.
Because we provide all of the evidence.
Okay. And then finally, and thank you, Madam Chair, I just want to be sure we understand. So we're hearing about fees. So why are your fees not too high or exorbitant or what? Just want to give you a chance to defend yourself.
Yeah. Under the current fee model, the current fee model of 20% would not work for us, 20% of back pay, because about a quarter of my clients don't get any back pay because they get their claims approved so quickly. The industry kind of standard right now is that it's 5 times the monthly increase. So if you go from 10% to 20% and you only make $100 more a month, your fee is $500. If you go from 50% to 70, 80%, and that's a $500 increase in your benefits, the fee's $2,500. We believe that the answer to that question is my clients understand that going in, see the value proposition of what we're providing, and are making the choice to use our services. And they are making that choice from a position of knowledge that there are free services available.
Could you notify them?
Because I notify them.
And Mr. Barron, did your client notify them?
Right, but you'll see that's one of the amendments. They're going to have to sign for it. And it's, when you look at the amendments and you look at the bill, I'm serious, it's a freedom of choice bill.
Okay.
Plain and
Thank you.
simple.
Thank you.
Thank you, Senator. Senator Reedy? Senator Ellis?
It's a suit. Thank you, Madam Chair. And Bruce, I have a question for you. So you vouch for all these private companies. Maybe I heard you wrong. I know you are talking about the company you represent.
Yes, I
and
vouch for
I know
them, yes.
you definitely, knowing you over the 7 years I've been a senator, I know you would vouch, you would check out your clients, and you would definitely only pick reputable people to represent and to work with and to bring to us. Is that a fair understanding of how you do business?
My daughter-in-law is a full bird colonel in the Air Force. I'm not going to do anything contrary to the armed forces.
So you checked out, you vetted your
Yes.
client, right?
Yes.
Okay. And so I'm not doubting that your client is very reputable. But is it possible that others in the industry are bad actors and
Absolutely.
bad players?
That is why with the amendments, which there are going to be guardrails that are just phenomenal, I think, quite frankly. I mean, as someone who practiced law for 40 years, it should be 30 years, the analogy of someone coming in and that relationship and the fee they're going to pay and what have you. You look at these amendments, they are all, as was indicated, they are all for the benefit of the veteran. They have to read them, they have to sign them, they have to understand them, and if they choose to go forward with our services, fine. If they choose to go to the free services, which you're going to tell them about, then they do that.
Yeah, so if we pass this bill with some reasonable amendments to keep, say, some of the good actors in the private, that'll be fine, but...
The amendments should get rid of the bad actors.
Get rid of the bad actors.
Absolutely, 100%.
Have you determined what percentage of the industry might be just folks who are just abusing the system?
I do not know that, Senator. I'm sorry.
Yeah, so two things. Number one, I agree 100% with the intent of the original bill. There are predatory practices out there. There are bad actors. I think it's a much smaller percentage of the community than people expect. There is a trade association called the National Association of Veterans' Rights. They've done a catalog of the private industry. There's about 60 to 70 companies out there nationwide doing this. I would submit to you that probably, and this is a guess, but probably somewhere between 10 to 15 of those have some type of predatory practice.
Okay.
We believe that we need to protect against those practices, but we believe instead of taking a sledgehammer to this problem and just getting rid of this option for veterans, let's identify the predatory practices, let's legislate against every single one of them. And if we do that with these amendments, the AG can now come after me, the Consumer Protection Bureau can now come after me, and the veteran now has a right of action to sue me in court. And so these protections not only stop the bad practices, but also give an enforcement mechanism in Maryland that doesn't exist at the national
level. Thank you. Appreciate it. Thank you, Madam Chair.
Thank you, Senator Ellis. Senator Guile.
Thank you, Madam Chair. I was really interested in this bill, and I got pulled to another committee. So, and forgive me if any of the questions I asked were addressed in your testimony, but I did write down some things from the first panel that I did have some questions about. I think Mr. Gross had mentioned some VA cease and desist letters.
Yes.
You've received a VA cease and desist letter?
So we did receive a letter back in '24 from the VA saying that we are in violation of federal law. We provided a response to the VA within 2 weeks outlining our interpretation of federal law and why we feel we're not in violation of federal law, and the VA has failed to respond to our response to that letter. I also want to note that they brought up the New Jersey case in the Third Circuit. I'm the litigant in that case. We're suing the state of New Jersey because we believe the law they passed was unconstitutional. That has not been decided yet. The only thing that's been ruled on is a preliminary motion, and I will note that in that ruling, the Third Circuit did affirm the concept that if you're not acting as an agent, you're not in violation of federal law. However, they didn't go as far as to pass a judgment on whether or not we're acting as agents. So that still hasn't been determined by the courts. But the indication is the courts support our interpretation of federal law.
The indication is that the courts support your interpretation of federal law. Is that what you just said?
Yes.
Okay.
But that has not been ruled on yet.
I'd be curious to see what that is yet to be ruled upon.
There's just been a preliminary motion for an injunction.
It's just but it's a preliminary motion for a
Yes.
okay.
For a temporary injunction.
Okay.
So the case has not been heard yet.
But in fairness, though, that's a temporary injunction at the outset, just at the very beginning. So
that's
as far
correct.
as the merits of the case, those have not been.
They have not, no.
Been completed.
That's correct.
Okay. I just want to clarify that because the
100%.
preliminary injunctions are routinely given.
Yes.
You know. Okay. Not necessarily. Okay. And then. I would be curious also to see those cease and desist letters. Mr. Bariano, good to see you. Has your client received a cease and desist letter from the VA?
I do not know, and I'll find that out immediately and let you know.
But yeah,
sorry,
we'd be
I don't-
more than happy to provide both the letter as
Yeah.
well as our response to
I'll
the
get
VA.
that to you, Senator. I'm sorry I don't have that answer.
And I do have another question too, and I know I when I was speaking with Bernie previously about this bill, I have an understanding about what you charge when there's an increase in a rating.
Mm-hmm.
Can you help me understand what do you charge for? And maybe this has already been discussed, but can you tell me what you charge for that initial rating? Do you handle initial ratings? If somebody comes to you and was like, I'm processing a claim for an initial rating with the VA?
Well, okay, there's two categories there. Number one, we don't work with any clients within their 1-year presumptive period.
Okay.
And actually, that's one of the provisions that we're also recommending in this bill. You don't need my help in the presumptive period. We do sometimes get with the veteran maybe 5-10 years after they've gotten out that's never filed a claim before, and we do assist with those. We just consider wherever you came to us when you started to wherever you end up, that difference is what we base our fee off of. So
Okay.
whether that's at 0 or 10% or 20%, it gets treated the same way.
I guess what I was kind of wondering is if there's somebody that goes, you know, if it has been somebody that hasn't sought a disability rating yet, and you're going from like 0 to whatever the case may be, if they're receiving 0 and then receiving a couple $1,000s a month, do you still take 6 times that?
5 times.
5 times that? You
Yeah.
still take 5 times of that? So if they go from 0 to a few $1,000s, that's what, then they have to pay that to you up front? Is
No,
that
no,
right?
no.
When
All
do
of-
they pay?
They pay, okay, this is a great question. It is contingent on them having a successful adjudication of their claim. We do not charge the fee until we validated the veterans getting their new money from the VA. And we offer 3 payment plans. They can do a lump sum with a 10% discount. They can do a 5-month payment plan or a 10-month payment plan. No fees, no interest on those plans. That's one time. We don't touch back pay. And once they finish paying it off, they enjoy the benefit for the rest of their life. So no veteran is paying me a fee. Any fee they pay me is with new money they're getting from the VA. So no veteran is going to be financially disadvantaged from where they were before they came to us. Now, I would also like to note that we are also proposing the potential fee caps. So in that rare case, when someone goes from 0 to 100, my fee would probably be somewhere in the $16,000 to $17,000 range for that, because you're going to get anywhere from $3,200 to about $3,500 more dollars a month. We could cap that. Right now, the federal proposals are either $10,000 or $12,500.
Okay. And just one more question, I think, and again, I apologize if this has been answered. What's so hard about getting the accreditation? Is it just because you're not going to be able to charge then?
I can't operate as a business as an accredited entity.
Okay.
I think go through the whole process again, because they help on the front end.
Yeah.
Yeah.
And it's
I
different
get
than the accredited who are helping on the appeal.
I got that. And then we heard from Mr. Gross, the attorney, I guess, who is able to operate, but it sounds like he charges a percentage, a contingency fee on the basis of an appeal before the
That's
board of
correct.
BVA, before the board of
Right.
Veterans
Under the
Appeals.
current rules, you cannot charge a fee to do what we're doing. as an accredited agent or attorney. We are not acting as agents or attorneys. We are acting merely as a consultant to help the veteran navigate the process in their own name on their own behalf. And so that's how we're remaining compliant with federal law.
Okay.
I want that to change.
Okay. I mean, I guess I understand what you're saying. I do take a little bit of, concern about what you just said about complying with federal law, because there was a cease and desist letter from the VA. At least the VA at least once took a position that you weren't complying with federal law.
Yeah. Can I address that? We believe.
Well, I did want to. I just lost my train of thought. There was one other question that I wanted to ask you about, but you know what? Instead, we can discuss it later offline, and I'm happy to. I do have some concerns on the business model. I really do, but happy to discuss this later. Thank you. Thank you, Madam Chair.
Thank you. I don't see any other questions for this panel. Thank you very much for your testimony. We have one more favorable virtually, Nigel Forney. I think. Yeah, there we go.
Yes, Madam Chair, thank you. I am Nigel Forney, and I represent the Joint Veterans Committee of Maryland. We fully support this bill. As a chapter service officer, I am accredited annually to file claims and advise veterans on their claims and appeals process. It is illegal for myself to receive monies or monetary gains from veterans for filing such claims. I know that there are a lot of veterans that are impacted by claim sharks promising them a faster decision and a higher disability percentage that they cannot guarantee. It affects them mentally and physically. They don't get what they claim sharks have promised. No one can guarantee a percentage. These unaccredited people are taking advantage of the veterans that have medical problems, some of which are life-threatening and severe. They are charging for a service that we accredited service officers are doing for free. The Disabled American Veterans alone procured over $30 billion last year worth of benefits for the veterans free of charge. We follow the claims process for the veteran from the initial claim all the way to the Board of Appeals, in which the claim sharks don't. As a chapter service officer, I have seen firsthand how these unaccredited claim sharks have affected our veterans. And we cannot allow these people or entities to continue taking advantage of our nation's great veterans. Also, Senator Ellis asked, if a veteran in Carroll County or somebody from the DAV called DAV, usually within 72 hours, we're there to process their claim for them. I yield my time back to you, Madam Chairperson.
Thank you very much for your testimony. I don't see any questions. That ends the hearing on Senate Bill 928. We're going to go out of order because of some witness issues, so we're going to go on to Senator Lamb. Senate Bill 987, Artificial Intelligence, Health Software, and Health Insurance Decision Making. Senator Lamb, you have Marie Grant, James York, and Padmini Ragasingal virtual as part of your panel.
Yeah, so Dr. Randenstein's on service, so I think she'll be virtual, and then Dr. York next being Marie Grant as well. So thank you, Chair Beidel, for the opportunity to be able to introduce Senate Bill 897. For the record, Clarence Lamb, Senator District 12. This proposed legislation takes a first critical step to ensure that health-related artificial intelligence, or AI, is used ethically and responsibly. AI intelligence-powered software plays an increasing role in patient care and healthcare decision-making, as well as many other sectors of our economy. And I think we venture to say that many of us are still trying to understand and fully grasp the extent to which AI is going to be involved in many different industries, including in healthcare. And while these advancements offer great potential, we cannot allow innovation to outpace effective oversight. And this bill hopefully is a way to be able to start that process. With the use of AI, the cost of reviewing health insurance claims goes down, and insurers may expand their review process for smaller claims. As this committee heard about SB 474 on February 12th, there's been a steep rise in insurance denials over the last 3 years, and Ms. Grant can speak to that from the MIA perspective. perspective, we would be remiss to allow the use of AI to worsen the impact of insurance denials for Marylanders' healthcare access. Without proper transparency and accountability regarding AI, we risk jeopardizing patient safety, undermining medical ethics, and eroding public trust in the healthcare system. First, this bill establishes a statewide registry for AI health software. The registry, housed within the Maryland Healthcare Commission, will provide a critical baseline of knowledge to track which AI tools are being used, how they're being used, and who's responsible for them. With the data provided by the registry, Maryland can enact appropriate AI-related safeguards and guidance for users and also for manufacturers. Secondly, this bill takes an important step to protect Maryland patients by prohibiting health insurance carriers from using AI to make healthcare decisions without physician oversight. No patient should ever be denied treatment or coverage based simply on a black box algorithm. Medical decisions should be made by trained professionals, not by unregulated software. And so, in part, I think this was a recognition that particularly with AI seeping into more and more healthcare-related decision-making, that up until this point, this body in the state has generally relied on licensed healthcare professionals, whether they're physicians, advanced practice professionals, nurses, and others, to make healthcare clinical decisions. And so in that instance, there's always someone responsible that the state can turn back to either pull a license or question that individual about the clinical care that they provided. With AI, that is oftentimes masked. People may not know who's behind the software or the algorithm that was designed for this, and it may be very difficult to track back to who is the responsible individual that may be responsible for that clinical judgment or decision making. And oftentimes, we're potentially in a situation where there may not be an individual making that clinical decision making process. That, I think, for many patients still presents a level of discomfort. The League of Life and Health Insurers of Maryland already note that no carriers deny care based on decisions by artificial intelligence. This legislation codifies that practice, ensuring that a human, not artificial intelligence, is the one making any health insurance carrier decisions or adverse decisions. I have also spoken with some radiologists because I know some of the radiology practices that issued opposition letter testimony in your bill packet. I think many of them are really keyed in on, are concerned about the definition of AI, that radiology is a field that probably about 70% of radiologists use some type of AI, and that definition of what falls under AI can be really, really important. And I think there's just some angst about how that definition is going to be scoped out. And I think that's reflected in a lot of the testimony that you're seeing in written form in your packet. That's certainly something we can have a conversation about. I think there's some angst about how the Maryland Healthcare Commission might define AI and whether that over encapsulates or if that's more narrowly tailored towards what some might think is AI being used in clinical practice. And so I think that's something happy to work on with some of the radiology practices that have brought up those issues and concerns too. It's just a field that radiology in particular is a field that AI is being heavily used in. So with clear registration requirements, enforcement penalties, and a framework for future protections, this legislation ensures that AI serves as a tool for better healthcare outcomes rather than a barrier for care. And with that, appreciate the committee's consideration and ask for a favorable report. Happy to turn over other members of the panel and take any questions at the end.
Thank you, Senator. Dr. York, would you like to go next?
Yes, thank you. Good afternoon, Madam Chair, Vice Chair, members of the committee. My name is Dr. Jim York. I'm a physician with decades of experience caring for Maryland patients. I'm honored to have current and prior leadership in Maryland physicians as past president of MedChi and current delegate to the AMA. Importantly for this bill, I have experience studying and using AI applications for personal and professional use. In the AMA, I and MedChi President Dr. Renessing, who you'll hear from shortly, both serve on the Informatics Caucus, and I'm also a member of the American Medical Informatics Association, a separate informatics-related association, and I'm participating in current continuing education in medical economics, informatics rather. I'm speaking on behalf of Maryland physicians, strong support of Senate Bill 987. Artificial intelligence applications have tremendous potential for good. I use an AI ambient microphone agent in our Epic electronic health record software to quickly, accurately, and efficiently capture office visit details all day long, every day, including this morning. This improves access, patient satisfaction, and eliminates a keyboard between me and my patients. I use OpenAI and Scholar AI and other applications for personal use, clinical research, and summarizations of professional presentations. AI applications have tremendous potential also for harm. More recently, health insurers have turned to AI decision-making tools that generate prior authorization decisions with little or no human oversight. These AI tools have been accused of producing high rates of care denial, in some cases 16 times higher than what we've seen more typically and recently. To quote AMI President Dr. Bruce Scott, and this came out just recently this month, insurers use automated decision-making systems to create systematic batch denials, like just batch denials, with little or no human review, placing barriers between patients and necessary medical care. So medical decisions need to be made by physicians and their patients, and so Senate Bill 987 will begin to provide this benefit. And this testimony was made without AI assistance, and thank you. I'm happy to answer any questions.
Good, thanks, Dr. York. Insurance Commissioner Marie Grant.
Thank you, Madam Chair, committee members. Marie Grant on behalf of the Maryland Insurance Administration here in support of this important legislation. I think you've heard very eloquently why it's needed. Just a couple of additional thoughts from a regulatory perspective. It is our view under current Maryland law, first of all, that a physician does need to be at the end of that adverse decision or medical decision. But I think it's the directly influenced language in this bill that is so important, and it's just a really important first step to make sure we have our arms around this issue. We are engaged in a survey of our health insurers that we should have responses back later this spring about how insurers are using AI currently and plans for the future. And so I'm hopeful that that will continue to inform perspectives on this issue. But in the meantime, this bill is a great first step. And so we're proud to support it. Thank you.
Thank you, Commissioner Grant. We have one more virtual witness part of the panel, Dr. Ranasinghe.
Yeah, thank you so much, Madam Chair, and thank you for the committee giving us the opportunity to speak. My name is Padmini Ranasinghe. I'm a physician and a faculty member at Johns Hopkins School of Medicine and currently serve as the president of MedCai, the Maryland State Medical Society. Additionally, I'm also a member of newly formed AI task force at the American Medical Association. I also would like to express my strong support for SB 987, the bill that aimed to regulate the use of AI in healthcare in our state. As a physician, I have witnessed the potential benefit of AI in improving patient care, outcome, and especially in streamlining the operation side of the clinical care. However, it is imperative that we ensure these technologies are safe, effective, and used ethically. SB 987 addresses these concerns by establishing a registry for AI healthcare software and requiring health insurance carriers to have human oversight when making healthcare decisions that are influenced by AI. These measures are essential for maintaining patient safety, trust in our healthcare system. I would like to emphasize the importance of having an inclusive group of overseeing the implementation regulation of AI in healthcare software, as Dr. Lamb mentioned. The Maryland Healthcare Commission has taken significant steps in the direction of forming a diverse oversight group that includes healthcare professionals, patients, community leaders, and experts in AI and ethics. It is critically important that a wide range of perspectives are represented. By doing that, we can guarantee that the development and deployment of AI tools are equitable, transparent, and respectful for all our patient groups. In conclusion, I urge to support SB 987. Together, we can harness the power of AI to enhance healthcare while safeguarding the rights and well-being of all Marylanders. Thank you.
Thank you, Doctor. Do I have questions? I do. Senator Mounts.
Thank you, Madam Chair. Just a quick question. I'm not sure who best this should be directed to, so I'll let the sponsor decide who should respond. But I was just going through the testimony. RadNet, leading radiology forward, is testifying unfavorably, stating that that this is already registered, and that by having a requirement to go get registered in Maryland would stifle innovation or prevent the use of AI. Have you seen that testimony, and do you have a quick response to it? Or who would be the best person to
Sure,
best witness to quickly
I can take
respond to it?
first stab at that. So so I have looked at their testimony, number one, and number two, I know some people were filtering in and out. You may have caught this, that I think, particularly with radiology, it is probably the field of medicine where AI is currently being used the most. And so there's a lot of angst about the definition of how AI, the actual definition of AI, right? And the use of AI in the healthcare space, and what is healthcare software AI. And that definition is really key. And so I actually just talked to some radiologists this morning about this, and what their angst is how that is actually going to be defined. The definition in the bill, it actually leaves it to the Maryland Healthcare Commission, to the MHCC, to define how healthcare AI-related software is actually defined. And so, I think some of this is really extending from that there's, some concern about if it's defined in certain ways, it could be maybe overly broad. If it's defined in other ways, it could be maybe too narrow. And so I think that in part is a lot of the radiologist's concern. I think the fact is that they also cite that FDA has to kind of sign off on certain uses of these technologies when it's in a clinical environment, just like any other medical device that's out there. That is true. But I think where we as a state have a responsibility is that we license every healthcare provider out there that's making clinical decisions, right? So that's physicians, nurse practitioners, nurses, social workers, and the like. And that's because we regulate the practice of medicine at a state level. And so ultimately there's a responsible individual or responsible body that the state can turn to for any clinical decision-making that might be adverse or improper or incorrect or whatever. And in this instance, while, yes, some of these technologies may have been FDA approved or have sign off from FDA just like any other medical device, that doesn't mean that there's necessarily a responsible body that the state can turn to if something goes awry. Where if a physician isn't doing something right or other provider, we can go back to the Board of Physicians or the Board of whatever health occupations that is to be able to find that individual, bring them in, ask some questions. What happened in this instance with these AI tools? Because the developer may oftentimes be masked or several steps away. It's really hard. And so this is the first step to at least create a registry so we know where all these tools are being used and have an identifiable point of contact behind that.
I appreciate your time addressing that. Thank you.
Thank you, Senator. I don't see any other questions for this panel. Thank you for this bill. We have a favor with amendment. Phil?
Thank you. Thanks, Mary.
Phil, I don't even attempt your last name, but you must be the only Phil in the room, so we're good.
Thanks. It took me a while to get it, too. Thank you, Madam Chair and members of the committee. Philemon Kondrowski here today on behalf of the League of Life and Health Insurers of Maryland, favorable with amendments on SB 987. I don't think I need to tell all of you the importance of artificial intelligence. I'm sure you're going to be hearing a lot more of that later today. But insurance AI is a tool that can be deployed to improve the customer experience by simplifying processes in an efficient and accurate manner. For example, carriers use AI to speed up claim payments, flag electronic medical record overlap for care coordination, and create efficiencies across the healthcare continuum. To be clear, and I appreciate Senator Lamb for citing us in his testimony, no carriers are making adverse decisions with artificial intelligence programs. I'll repeat that. No carriers are making adverse decisions with an artificial intelligence program. Denials are always made finally by a human being. I'll also add the MIA has issued a bulletin ensuring carriers are complying with all applicable state and federal laws and regulations, and this includes laws related to unfair trade practices and discrimination. The amendments that we're requesting today would conform this bill to a bill in the House, HB 820, that's moving through the House as we speak. That bill codifies a number of requirements for insurers related to AI usage, and we respectfully request that this bill be amended to that statute.
Phil, did I understand you say that the House has adopted these amendments on their cross-file?
So the House doesn't, I believe, have a cross-file of this bill. HB 820 is a kind of a separate bill.
Okay.
But they have adopted some amendments, I believe, from the MIA, and that bill's moving through.
HB 820.
820.
Okay, thank you very much. Do you have any questions? I do not see any. Thank you for your testimony.
Appreciate it.
And now we have unfavorable, Rory Murray and Margaret Durkin.
Madam Chair, members of the committee, Rory Murray here on behalf of Kaiser Permanente. We are respectfully in opposition to this bill. As the sponsor said during his testimony, it's really a breadth of the potential impacts issue. We don't know what the definition of artificial intelligence is going to be, and that really is the crux of the entire bill. Also, with some of the language that says that an insurer or a carrier may not use artificial intelligence to decide or directly influence a healthcare decision. As Phil just said, there are no carriers that are denying claims using AI software. However, AI programs are becoming increasingly more used during healthcare decision makings to assist physicians as they make healthcares. If the documentation being provided to the carrier involves any use of AI decision making during that period of time when the physician is working with the patient and then submitting it to the healthcare insurer, we'd be worried that they could not then take any of that into account. So it's more of a question about the language issue. I think everybody is on the same page that AI needs significant oversight, and there should be a lot of safeguards put in place, but the language itself is a little broad here, and that's what gives us pause. Thank you.
Thank you, Rory. Margaret?
Good afternoon, Chair Beidel and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet, a tech trade association. Thank you for allowing me the opportunity to speak today on Senate Bill 987. Our members are committed to responsible AI development and use, and we want to strike the right balance between consumer protection and business innovation. This bill allows the Maryland Healthcare Commission the mandate to oversee all AI health software and places a requirement that they must register with the commission or be subject to fines. We understand that the commission has a role to play in such software. However, because the bill fails to define AI health software and gives discretion to the commission, we are concerned that this will lead to uncertainty for businesses. And it also allows wide latitude for what information is collected for such registry. We're also concerned about the lack of exemptions for software that has been approved by the FDA, and further that the bill doesn't contain any exemptions for fraud abatement efforts. We're also concerned that this bill will apply to all healthcare AI, such as day-to-day things, scheduling, note-taking. One of the prior speakers mentioned their microphone. This, in our view, would subject those tools to registration. And regarding restrictions on AI by insurers, insurers are ultimately making coverage decisions, not healthcare decisions. And we're concerned that this bill would eliminate AI for those more simple decisions within the healthcare space. Our members have indicated a willingness to work with the sponsor to potentially narrow the approach of this bill. And for the above stated reasons, we are currently opposed to this bill. Thank you.
Thank you, Margaret. Do you have any questions for Margaret or Rory? Seeing no questions, we have one virtual witness, unfavorable, Roxy Kozukecki, maybe?
Hi, good afternoon, Chair Beidel, Vice Chair Hayes, and members of the committee.
My name is Roxy Kazitsky. I'm Senior Director of State Government Affairs at AdvaMed, the MedTech Association. AdvaMed is the largest medical technology association representing the innovators and manufacturers transforming healthcare through earlier disease detection, less invasive procedures, and more effective treatments. Our nearly 600 members range from emerging companies to large multinationals, and 80% of the industry is made up of small startup companies that drive this innovation. I'm here today to discuss our opposition to Senate Bill 987. AdvaMed's concern that legislation as broad as this gives the MHCC authority to manage a registry of AI technologies used in healthcare in the state when it does not have the physician expertise to do so. Further, the purpose of this registry is not exactly clear, as it doesn't detail what kind of AI in healthcare it's most concerned with and why, which would create a slippery slope for further arbitrary regulation of the innovative medical device manufacturers located in Maryland and throughout the US that are highly regulated already in this space. As a result, the bill could hamper access to the best-in-class care that is available to patients in Maryland. A commission such as the one proposed would override 25 years of experience at the FDA in reviewing and authorizing AI-enabled medical technology, creating an unnecessary backstop that would confuse providers and patients instead of informing them. Physicians that AdvaMed's members work with, many of whom are members of the state's medical society, are concerned the idea for this legislation fundamentally misunderstands how AI and medtech actually works. It appears that the scope should probably be limited to non-FDA regulated AI healthcare technologies instead of the broad scope currently drafted. To be clear, AI and medtech technologies require human oversight to operate. They only augment a provider's ability to devise the most optimal treatment plan for their patients with greater accuracy and precision. Today, there's only one technology regulated by the FDA that fully operates on its own, and that is to scan the eye and diagnose diabetic retinopathy. If the pure goal is to research and assess what AI is being used in the state in a healthcare context, we would argue that you don't need a bill like this to pass to do that. As such, we would question the motive of this legislation, and we urge the committee to, at a minimum, narrow FDA-regulated technologies and to oppose Senate Bill 987. We are, of course, happy to be a resource as the legislature examines AI and medical technology and its use in healthcare in Maryland, and we're on record with encouraging the FDA to create clearer guidelines and post-market surveillance on FDA-regulated medical technologies. So we believe that jurisdiction should reside with the FDA. And I'm happy to answer any questions. Thank you for your time.
Thank you. Do I have any questions for Roxy? Senator Lamb.
Thank you, Madam Chair. Just a follow-up question to this witness. Is there anywhere where I can look at to get a list of AI products that are actually sold in the state?
I'm not sure about that, but I don't know that that would give you the right information that you're looking for. I mean, if you're looking for utilization, insurers would probably have the best information, but if it's sales data, I don't know where you'd find that or what exactly information that would provide that would be useful. I could certainly look into it, but I just don't know what use that information would be.
Really just trying to get at what is being sold here so we also can get a better sense of overall utilization as well. But, you know, I think that speaks to the point where a registry would be helpful. Thank you, Madam Chair.
I'm sorry. Thank you. I don't see any other questions. Thank you for your testimony. That ends the hearing on Senate Bill 987. And Senator Lamb, now we're going to do 976, Collective Bargaining, Local Government Employees and Public Employee Relations Act. You have David Marr, Denise Gilmore, John Barry, and Sam Epps. And Sam will be virtual, but we'll hear his testimony too before we go to questions. Thank you.
All right. Thank you, Madam Chair, members of the Senate Finance Committee, and for the record, Clarence Lamb, Senator District 12, here to introduce and testify in support of Senate Bill 976. In 2023, the Maryland General Assembly, as many folks who were here in this committee can recall, as well as council, passed the Public Employee Relations Act, which I know was a large bill that had been worked on. This phenomenal piece of legislation consolidated and streamlined and modernized our public sector collective bargaining laws in our state, in our K through 12 schools, and higher education under a single labor board, the Public Employee Relations Board, the PERB, when previously there were actually 3 separate boards. And so this brought it all under one roof. At the county and municipal level, employees face the same patchwork of laws, rights, and procedures that the Public Employee Relations Act fixed for the state, public school, and higher education employees. This bill offers a thoughtful approach to starting the process of modernizing and standardizing collective bargaining rights at the county and municipal levels. This legislation ensures that all employees, regardless of jurisdiction, can benefit from the same collective bargaining rights that this committee has repeatedly affirmed for public employees. The bill, number 1, standardizes the process for employees to form a union and to vote on whether they want union representation. Number 2, it consolidates the administration of union elections under the Public Employee Relations Board, the PERB, which has the expertise and the authority to enforce unfair labor practices and oversee elections. This change would also save local jurisdictions money by eliminating the need to hire outside contractors to manage elections. Because local governments have unique needs and operations, this bill offers flexibility for jurisdictions to adopt specific laws regarding the administration of collective bargaining, such as bargaining calendars and impasse procedures. The bill also establishes a baseline level of rights and procedures drawing from the practices of more advanced jurisdictions. For local governments like Prince George's County, which already implement many of these practices, the impact will be minimal. Much of this bill is modeled after the processes in Prince George's County. Jurisdictions like Montgomery, Anne Arundel, Baltimore City, Baltimore County already have binding interest arbitration in place, and this bill standardizes those procedures across these areas. For jurisdictions without existing collective bargaining systems, this bill establishes a foundation. It guarantees that all municipal and county employees have collective bargaining rights and access to established procedures under the Public Employee Relations Board, or the PERB. In these areas, the goal is for local governments to develop their own systems using universally accepted procedures under the PERB. If they do not, employees seeking to organize will at least have a pathway to unionize under the PERB's own framework. This bill is a crucial step forward in standardizing, streamlining, and modernizing our public sector collective bargaining laws. There is no reason why over 150 municipalities across the state and our 24 counties should each have a different adjudication process for defining a supervisor in the context of bargaining units. But that's what we have currently. In light of the unprecedented attacks on civil servants at the federal level, it's no surprise that state and local government employees are seeking uniformity in their collective bargaining laws, and in cases where they currently lack it, the opportunity to be able to unionize. This bill provides the framework to make that a reality. We do have some amendments. Some are technical, while others are substantive. We initially requested that quasi-governmental organizations be included in the bill, recognizing that all Maryland public sector employees are excluded from the application of the National Labor Relations Act. Unfortunately, this provision was omitted from the final version of the bill, so we've amended it to be included. The amendments also provide a provision on bargaining units and impasse procedures. This is a new section designated 22-408, specifically for these units. It gives Allegheny County a 1-year phase-in in another amendment, and given the status of the current law, under further inspection, they should be looped in with the categories of counties with more advanced laws, including that list that I mentioned earlier. We've met with the judiciary, and at their request have included new language to clarify that judiciary employees are not included. It also moves the definition of supervisor from section 22-101, where there's the current potential to conflict with K through 12 and community college bargaining units. Our panel will provide further details on the phase-in process outlined in this bill, as well as explain why local government workers are strongly urging us to act now, and hope that you will give this strong consideration and a favorable report, and happy to turn it over to others on the panel, and then to take any questions at the end. Thank you.
Thank you, Senator. So who would like to go next?
I will go next.
Okay.
Good afternoon, Madam Chair, members of the committee. My name is David Marr. I'm an attorney at KSC Law. I represent AFSCME Council 3 and a number of other unions, both public and private sector, in the state. I represent them with regard to state employees, higher ed and K-12 under the Public Employees Relations Act that was passed a few years ago, but as well county and municipal unions and employees seeking to unionize in our counties and municipalities. And frankly, the patchwork that existed and the fragmented state that existed prior to PIRA is much, much worse when it comes to the counties and municipalities. More than half of Maryland's counties do not provide any collective bargaining rights whatsoever to employees. An overwhelming majority of municipalities do not provide that either. Where there are laws, they differ drastically in the rights that are offered, the ability of employees to engage in unionization, union activities, and any protections for those. So this bill would establish, among other things, a framework and a floor of collective bargaining rights processes and procedures, as well as handing administration of elections and ULPs over to the Public Employee Relations Board, rather than forcing counties and municipalities to absorb the expense of hiring arbitrators and outside contractors to conduct these, as is the current practice in these counties and municipalities. But recognizing that not all counties and municipalities have the same needs, there is flexibility allowed under this bill for counties and municipalities to work with upon meeting that floor, particularly in regards to the composition of bargaining units, impasse procedures, and the bargaining calendar. And there is a process that is provided where when a county or municipality's laws reach the sufficient level to protect employees under that floor, they can petition the PERB to get an exemption and have their own administration. There is a one-year phase-in, I think the Senator already mentioned, for certain municipalities which already have advanced laws for them to gain those exemptions. And I'm happy to answer any further technical questions the committee has on both the phase-in and any other aspect of the bill.
Thank you very much. Denise?
Yeah, good afternoon. My name is Denise Gilmore, and I'm the Legislative and Political Director for AFSCME Maryland. We are in strong support of SB 976. I want to begin with a brief moment of privilege, but I just want to thank the committee. Last year, you passed a supervisor collective bargaining bill, Senator Kramer's bill, actually. Yesterday, breaking news, but the supervisors unit actually voted to unionize with AFSCME in a fair and efficient election held by the PERB. So on behalf of our supervisors, just thank you. They now have a union and they're very excited. But I want to speak on this bill. Last year I met a worker in Elkton. His name is Jeremy Kivler. He's a ground maintenance worker. And he couldn't be here today, but he asked me to read his testimony, so I'd like to read it. It says, in 2023, my coworkers and I started to organize. We were organizing for a seat at the table where we could fight for respect in our workplace, safety on the job, and a voice in all policies that affect us day to day. Whether it was making sure we were spoken to in a dignified manner or given the proper protective equipment for disposing of used needles, the right to bargain would have given us the tools we needed. In a small town like Elkton, it's easy to feel like there's little opportunity to make a change, but we didn't believe that. Instead, we took the risk, we organized, and over 80% of town employees signed on to start a union. But town leadership had different plans. In the town of Elkton, despite a supermajority of employees expressing their desires for a union, the town charter needed to be amended and then a labor code written to outline the union parameters. First, we spoke to the mayor, asked for the charter amendment to allow us collective bargaining rights. He seemed supportive. Then the mayor and commissioners consulted with an anti-union law firm to start putting up a long line of roadblocks that would have taken us through a brutal fight for a union for the next day. Needless to say, they did not get their union. The legislation that they wanted to put into code there was incredibly regressive. He's asking for this committee's support so that he's got a chance to unionize. He ordinarily wouldn't. So thank you very much.
Thank you, Denise. John Barry?
Yeah, hi. Thank you, Madam Chair and members of the Senate Finance Committee. I'm John Barry from United Food and Commercial Workers, 1994 McGeo, Municipal County Government and Employees Organization. We represent public sector workers in Montgomery County and in Prince George's County, and we're here in strong support of Senate Bill 976. I'm speaking also here on behalf of some of the municipal employees, like the ones in Elkton. 976 is a bill that gives these employees the right to organize, the right to vote on a union. Now, if you're from Maryland, you probably assume they already have that right. But you're wrong. In 90% of the municipalities in Maryland, there is no recognition of their right to bargain collectively. For the other 10%, the definition of collective bargaining changes from one city to the next. So you're a mechanic who works for the city that has no labor code, a laborer who lifts 80-pound trash cans during the snow, then you have a long road ahead of you. Let's get specific. In Laurel, Maryland, employees came to me after they had the opportunity to vote in December 22. They found they had to get a charter, then they had to go to the employer and try to get the employer to pass a labor code, and then they had to negotiate with that employer. It took 14 months of prodding and attending council sessions to get to the point where the code passed. In District Heights, it's taken 14 months to get a charter, giving them the right to bargain, and after 18 months, they're still waiting for a code. The fact that they've waited this long speaks for itself. They want a union. Now, I haven't run into a single official in all of my time in any of these cities who says they don't believe workers have the right to collectively bargain. But if you can't exercise that right, as far as I'm concerned, it's not a right. Senate Bill 976 offers a uniform, fair, equitable path toward collective bargaining for these people who need it badly.
Thank you. And we have one more virtual, Sam Epps.
Good afternoon, Madam Chair, and thank you for the opportunity to testify virtually. And to the members of the Finance Committee, Vice Chair Hayes, my name is Sam Epps, and I'm the president of the Metropolitan Washington Council, AFL-CIO, and I'm here today in strong support of Senate Bill 976. And at a time when federal attacks on our civil servants have left many public employees across the nation uncertain about their future, this legislation offers a clear pathway for our unorganized local government employees to collectively bargain, should they choose to do so. Additionally, it standardized bargaining rights for employees who already have them. Senate Bill 976 also ensures vital protections for our public sector unions in local government, many of which are threatened during this Trump era. These protections include access to new hires and standardized dues processing policies that this legislator has consistently affirmed for other public sector workers in Maryland. A strong labor movement makes Maryland stronger. Unions play a key role in building the middle class in our state, and we hope this legislator will join us in our mission to continue doing so in strengthening the middle class. When workers have income stability, due process protection, and benefits for themselves and their family, our local economy thrives. And so please, we hope that this committee provides a favorable report to Senate Bill 976. Thank you, Madam Chair.
Thank you, Sam. So do I have questions for this panel? Any questions? I don't see any questions right now. Thank you all for your testimony.
Thank you.
We have two unfavorables, Bill George and Carrington and Anderson.
Good afternoon, Chair, Vice Chair, members of the committee. Bill George with the Maryland Municipal League here today in opposition to Senate Bill 976. Local governments are simply fundamentally different than those in the private sector, in that local governments provide essential services and in most cases have multiple categories of employees that would be represented by different unions.
Municipal governments in the state that currently allow employees to collectively bargain do so at their own discretion with the full understanding of the costs and responsibilities that come along with it. This bill would flip that discretion to the employees and place financial burden and administrative burden on local governments, some of which are ill-equipped to take on those responsibilities. So 2 points for you before I turn it over to my colleagues from the counties. One, managing multiple contracts and negotiations is a tall task. Currently, there are some municipal governments that negotiate with more than one union on behalf of their employees. Police, fire, public works, for instance. And this would become more prevalent if this bill were to take effect. Many private companies obviously only work with one union, another aspect in which local governments are simply different. These negotiations and contracts are time-consuming and detailed that require additional staff to manage them. There are significant consequences that come with deviation from these contracts, so proper management is critical. Secondly is the strike provision in the bill. There's a reason why governmental units are exempt from the National Labor Relations Act. It's because of the essential services that they provide. This bill would allow union workers to strike upon an impasse in the negotiations. When auto workers strike, factories might close and fewer cars are made. When dock workers strike, ports may close and fewer goods are delivered. Not to devalue the work of these people, but this is where local governments are simply different. If local government workers strike, law enforcement officers stop patrolling the streets, trash goes uncollected, and maybe a repair to a broken sewer pipe is delayed. This is where public safety and public health come into play, is through the services that are provided by local governments. For these reasons, and the ones you'll hear from our county partners, we ask for an unfavorable report.
Thank you, Madam Chair and members of the committee. My name is Carrington Anderson with the Maryland Association of Counties, speaking in respectful opposition to Senate Bill 976. I echo the comments from my colleague from MML. As you're well aware, counties vary in labor relations. Some counties have no collective bargaining. Some counties have collective bargaining for certain units in certain ways, and some counties have collective bargaining across the board. I want to touch on the binding arbitration piece that this bill mandates. Binding arbitration is a one-size-fits-all. Binding arbitration in particular has been a subject of state legislation in the past multiple times that this legislature has considered very carefully. Making the final decision of third-party binding on a local government entity that either has to raise taxes or cut essential services to fulfill that obligation is a step that the General Assembly has been reluctant to make broadly in the past. Arbitration decisions are unpredictable and could force counties to make decisions that they have not budgeted for. Some counties have had collective bargaining for many decades and determined their policies thoughtfully, carefully, and locally, also with their unique workforce needs and their budget capacities. This bill would result in one way of doing things discounting what has been working locally. Local governments have good systems, and this bill undermines that. This bill undermines the equilibrium that has taken years to build. For these reasons, we would respectfully urge an unfavorable report.
Thank you, Carrington. I do not see any questions for this panel. That ends this hearing, Senate Bill 976. And next, we are going to Senator Heddleman. Stop. You said she's on her way? We're waiting just a minute for Senator Heddleman. Mr. Vice Chair? Yep.
Oh. Indeed. Next bill, we'll hear Senate Bill 842. That will be presented by Chair Beidel. And I have three people listed on her panel. Laura Hale, Kristen Jemison, and Tyler Brody. No? Oh, cancel that. Senator Hedelman has arrived, and so at the chair prerogative, she's going to let Senator Hedelman go instead. Senate Bill 846. Senator Hedelman, and you have a virtual panelist, Patricia
Rubaki.
Yes, that's it. Thank you for saving me there.
Thank you, Mr. Vice Chair. Thank you, members of the committee. I am going to share with you a story that happened to me and that I think everybody can relate to. And this happened to me this summer, and this is the impetus for this bill. I set aside a couple hours in my day to go to the cell phone store. And it is not one of my favorite activities because I'm not exactly a Luddite, but I like to be around people who really know what to do with their phones and transfer data, and I have a ton of photos, et cetera. Set aside time, I go to the Xfinity store, and I asked them if I can purchase a new phone. And I'm on the account, but I'm not the primary user on the account. My husband is. And so they said, "Oh, I'm so sorry. You cannot purchase a phone today. You have to have your husband with you." And I said, "I'm sorry, what?" I have his password. He knows I'm here. I can get him on the phone. I would like to purchase a new phone, please. And they said, "Sorry, we cannot help you. He has to physically be here with you in the store." At which point, I was not real happy. And I asked to speak to a manager of the store. And I think I was nice, but I said, I'm very upset. I set out this time. I'm kind of busy. And I am here and I earn a living. My name is on the account. I would like to purchase a phone. And they said, "We're so sorry. We instituted a policy a few months ago that said, because of fraud, the person who is the primary person on the account needs to physically be here." And I said, "This is a weekday. We have a lot of flexibility. My husband and I in our work, I'm sure he could come here, but I imagine there are a lot of people who do not have that flexibility. And I also imagine that there are a number of people who are women who are the secondary on the account and whose husbands are primary, and maybe you don't intend it, but it feels like this is a pretty sexist practice, and it seems totally unreasonable." He said, "I'm so sorry, we have this policy." And I said, "Well, can you tell me, like, the fraud, like, what is it that you have of his that you don't have of mine?" And he said, "Well, we have his social security number and whatever." And I said, "I'm happy to give you my social security number. You can have the same information, my personal information, that you have of his." And they said, "Go pound sand." I go in my car, I call my husband, where I was not as calm as I was in the store. And he said, "Well, why don't you go open your own account?" And I said, "Great idea." I go back in the store. "I'd like to open my own account." They said, "I'm so sorry, you cannot do that." I leave. I call a number of folks, and I make my way up the chain and express my frustrations. And I do know, because I had recently changed to this particular company, that other companies do not often have this, also have this practice. Some do, some do not. Fast forward a few months later, I decide to post on Facebook about my personal experience. And here, and I'm happy to share them with the committee, I got over 100 comments of people who had very, very similar situations, including men whose wives or partners were first on, who felt emasculated. Those were the term that was used to describe their feelings to me numerous times. People who just had really, really difficult situations, and I'm just going to read a couple of them that I think everybody can relate to. One said, "It's cheaper as a married 35-year-old woman to still be on a phone plan with my parents. I can't do anything regarding the account or upgrades without my father as the account holder. I called to set up my own account, and they wanted to list me as a new customer. I said, no, I should have my loyalty discount because I've been with you for over 10 years. This was somebody who was on their account from their ex-husband. And they said, well, your ex has, anyway, she had to make her way up through the chain to find somebody in the store who would allow her to keep her 10-year subscriber status. Then I have another one. I have it with my wife in the reverse. She is the primary, beyond frustrating and infantilizing, ludicrous. Another one. I mean, this goes on and on. So I thought, here I am in a position to do something about it. And it's a very simple bill, and I have an amendment. There are a number of people who have said that the language that we have in the bill may not do the trick. So we have an amendment, and it just says, now the bill says, a cellular phone carrier shall allow the customer of record who is responsible for payment on an account to designate other individuals as authorized users on the account, and an individual designated as an authorized user on an account to purchase services or devices or to make a claim under any service contract connected to the account to the extent that the authorization extends to the action. So it is a very straightforward, a very simple bill. And all it would do would avoid allowing cell phone companies to have the kind of policies that precluded my and millions of other people from having the decision-making authority to be able to do simple things like purchase a cell phone. And with that, I would like to turn it over to one of the people who I do happen to know and who also posted on my Facebook page about similar experience that she had. We literally, I did not want to burden this committee with dozens and dozens of people, so you have my story, but I think so many people can relate to it. And with that, I'll turn it over to Tricia. Thank you.
Hi, everyone. I'm talking to you from my home in Baltimore City, and I am one of the people who read Senator Hedelman's post on Facebook about what had happened to her. I live in Baltimore City. I live in a large apartment building. And in June, we moved from one apartment in one part of the building to another apartment in the other part of the building. And I went online to try to change my address, to simply change my address from one apartment to the other. And I was not allowed to do that. I was told I had to come in and do it in person. I looked at the account and realized that was in my husband's name. And I thought, well, I might as well change me to be the account holder, and then I'll be able to do this without having to go in. Could not do that. So I went ahead and went into the Xfinity store, and you do have to wait quite a while there. They have a queue for everyone to wait. And when I had my turn with an agent, the agent told me that I could not make these changes to the account without my husband present. My husband has Parkinson's disease, Lewy body dementia, and 2 types of cancer. For that reason, I have both power of attorney and health power of attorney for our finances. I asked the agent if they would accept these documents so I could make the changes and I would not have to bring my husband there. And I was told the answer is no. Your husband must come in and request the changes himself because he is the account holder. I did go back with my husband a few hours later, and after waiting through the same rigmarole, we were able to change our address and put the account in my name. I wholeheartedly agree with Senator Hedelman and in favor of the bill she introduced.
Thank you so much for your testimony. Senator Hedelman, I often leave the cell phone office and go draft a bill. I'm with you on that. Senator Gall.
Thank you very much, Mr. Vice Chair. Senator, I remember your Facebook post, and I felt that same rage and for you. But I noticed when looking at the bill file, noticeably absent is our friends from Xfinity. Is there a reason that have you heard from them as far as their position on this bill?
I have not heard from them directly lately, although in passing, a conversation about maybe the bill as drafted didn't do exactly what I wanted it to do, but they didn't seem to have a problem with what we were trying to do. So they haven't seen, we did forward them the language as we submitted it to DLS. What we just got back from amendment drafting is a slightly different version. So I do not have their comments on that. But they did not seem to object to what we were doing. And I made it really clear when I talked to them that that wasn't the last they were going to hear from me, that I was going to introduce a bill.
Okay. I like it. Girl power. Let's do it.
Thank you.
Thank you. Are there any additional questions for Senator Hedelman or her panel? Thank you so very much.
Thank you.
All right. That is the bill on Senate Bill 846. Next, we have Senator Hedelman up one more time for Senate Bill 914, Baltimore County Public Library, collective bargaining. Joining Senator Hedelman are two virtual guests. We'll start with Senator Hedelman and then go over to Bridget Fitzgerald.
Thank you very much, Mr. Chairman. Madam Chair, Mr. Vice Chair, members of the committee, my name is Shelley Hedelman. I'm Senator from District 11, and I'm here in support of Senate Bill 914. This is a collective bargaining bill for Baltimore County Public Library supervisory employees. A couple of years ago, in 2021, the General Assembly passed a bill that I worked on, along with Delegate Kathy Forbes, to allow non-supervisory staff of the Baltimore County Public Library to form a union and collectively bargain, and should they choose to do so. And they did, and I'm happy to say that they have gone through a number of successful negotiated collective bargaining agreements, and things seem to be humming along, I think, pretty well. And I think everybody would agree with that. It's not without fits and starts. It's not easy, but it's been working. So last year, this committee and the General Assembly passed the Library Workers Empowerment Act. And in that, they extended collective bargaining rights across the state of Maryland for library systems, and BCPL was excluded from that bill. One of the things that bill did is that it did permit collective bargaining rights for the supervisory employees of BCPL. For library workers. But our bill did not include supervisory employees, and that is what this bill before you today does. There are lots of examples across Maryland where there are separate bargaining units of both supervisory and non-supervisory employees, and they share the same union affiliation. It is not that unusual. MSEA, for example, has local affiliates throughout the state that represent both supervisory and non-supervisory employees within the same school districts. In Allegheny County, Carroll, Dorchester, Frederick, Garrett, and St. Mary's, for example. And this demonstrates that there can be separate bargaining units that exist successfully under the same union while maintaining clear distinctions to prevent conflicts of interest. That is not even to say that necessarily supervisors would pick the same union as the already existing bargaining unit. But we think that this bill promotes equitable treatment by granting supervisory employees the same rights to collectively bargain as other staff members, ensuring that all voices are heard in the organizational decisions. I want to commend to your attention a written testimony that was submitted by Heather Faust. She's a library supervisor at BCPL, and I think she really clearly outlines why this is important to her. She was a worker covered under collective bargaining and then was promoted to supervisor, and she had to really think about whether that was something she wanted to do because she was going to be exiting the union and required to exit the union. And I think she lays out from her very personal experience kind of what the issues are. So I am going to turn it over right now to others here, and they can talk about why it's important to them. And I just want to thank you and urge you to extend the collective bargaining rights that are available across the rest of the state to the Baltimore County Public Library supervisors. Thank you so much.
Thank you, Senator Howland. We have Bridget Fitzgerald virtually.
Can you hear me?
Yes, Bridget,
Hello?
thank you.
Good afternoon. Greetings, Chairman Vidal, members of the Senate Finance Committee. My name is Bridget Fitzgerald, and I'm an organizer with the International Association of Machinists and Aerospace Workers, known as the IAM. I want to thank you for considering this bill and extend our appreciation to Senator Hettleman for always standing by the Baltimore County Public Library workers since they first began down this path. In 2021, the General Assembly passed the Baltimore County Public Library Collective Bargaining Bill that authorized and enabled non-supervisory staff to form a union if, in fact, they chose to do so. They did, and I'm happy to say they are now in the midst of negotiating their fourth contract. But since then, other collective bargaining legislation has passed to include the state personnel collective bargaining for supervisory employees, the Maryland Public Employee Relations Act, and the Library Workers Employment Empowerment Act. That's to name a few. But regardless of the purpose of these laws, it signaled an expansion of collective bargaining for workers in the state of Maryland. Supervisors in 10 educational systems have organized into administrative and supervisory units with the Maryland State Education Association and the American Federation of State, County, and Municipal Employees, known as AFSCME, are currently organizing supervisors into S units across their public sector workplaces. The Library Workers Empowerment Act was a comprehensive piece of legislation, but it did not include the Baltimore County library system because this system was already organized in some fashion. The Library Workers Empowerment Act did authorize supervisory and non-supervisory units in the affected counties. Creating two units is intended to avoid a conflict of interest. The people that will be elected to represent those units will only be from those units, and it will prevent the workers from having a conflict of interest with management. Prince George's County is an example of how this works. We're not seeking supervisory license. We just would like to have them to have the same license all. Thank you very much.
Thank you for your testimony. Anita Bass.
Hello, can you hear me?
Oh. Yeah, yes, we can hear you. Go ahead.
We can hear you? Okay. Thank you, Senator Vidal and the Finance Committee and Senator Hettleman for letting me speak today. My name is Anita Bass, and I work for the Baltimore County Public Library, and I am the union president for our local 4538. Our supervisors and managers are requesting that they be part of our union because of the Library Workers Empowerment Act. As being a supervisory unit, it defines supervisors as employees with the authority to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline employees, and also address and resolve employee grievances. BCPL managers, supervisors are not involved in negotiations and are not considered confidential employees under the Library Workers Empowerment Act. The staff members would like to be able to have a choice, and I repeat that. This is only a choice. This does not give them to their union. This is only a choice. And they want to have that choice to be able to choose if they want to have a union. Okay, I thank you for listening to me, and I appreciate you giving me my time.
Thank you, Anita. Do I have any questions for the senator or her panel? Seeing no questions, we have two unfavorables.
Thank you. Can I just give a shout out to Tammy, who was very kind to me in my office today with technology.
Tammy's always very kind. That's why we all listen to her.
She went above and beyond today.
Thank you.
I appreciate it.
Bernie Marsick and Sonia Alcantara Antoine.
Madam Chair, members of the committee, again, Bernie Marzik, Cornerstone Government Affairs, here today on behalf of Baltimore County Public Library. In respectful opposition to Senate Bill 914. I wanted to give a little bit more detail. The previous speaker spoke about the history of this issue. 4 years ago, we spent countless hours working on the bill to allow Baltimore County Public Library employees to collectively bargain. At the time, Sonia had just come in as executive director. The bill was introduced. We worked through session to come up with a workable solution for both the library management as well as for the library employees. Since that has happened, as was alluded to, the union was formed, the members organized, and it's been a successful partnership between the management and the employees. The union, the board, and the managers all agreed at that time to not include supervisors and managers in the agreement. And since that passage, we've had elections and the successful creation of the union, as I mentioned. There's been 4 successful contracts, including the latest MOU was ratified just 2 weeks ago by the staff and the board. And then there's also been very open communication and ongoing collaboration. And there's been very few grievances over this time. So the relationship is good. We are opposed to this bill because of adding these managers and supervisors. We think there's going to create a conflict of interest. We think it's going to be an added cost at a time where the state and the county are in difficult financial situations. And we don't think that cost should go on to the county and on to the library. So we would respectfully oppose this bill. I'll turn it to Sonia to provide more details.
Good afternoon, Madam Chair and distinguished members of the committee. My name is Sonia Alcantara-Antoine. I'm the Chief Executive Officer of Baltimore County Public Library. 4 years ago, Baltimore County Public Library worked collaboratively with the bill sponsors, including Senator Hellman and the IAM Union, to create Baltimore County Public Library's collective bargaining law. Our labor attorney, Sean Malone, was also at the table 4 years ago, ensuring that our law adhered to labor laws and standard best practices. We did so willingly and in good faith, never ever opposing the right for BCPL staff to organize. BCPL's collective bargaining law enables BCPL employees to collectively bargain, but specifically prohibits confidential employees, managers, and supervisors from organizing. However, this current bill seeks to allow BCPL managers and supervisors to organize. It goes against standard guidance from the National Labor Relations Act, as well as the good faith agreement that we negotiated 4 years ago. BCPL opposes this change. It would undermine the ability of our managers and supervisors to carry out their responsibilities objectively. BCPL managers and supervisors are an extension of myself and library administration. They have the authority to hire, fire, discipline, and evaluate employees. They directly address grievances. They represent library administration on the Labor Management Committee and in labor negotiations. They participate in critical advocacy events, such as Maryland Library Legislative Day, and they participate in strategic discussions. They also help to establish and enforce library policies. Every day, they make operational decisions that directly impact labor relations. Including them in a union would create a clear conflict between their duties as representatives of the employer and their interests as union members. Further, our law is tailor-made for BCPL in that it directly references our funding relationship with Baltimore County government. The language in our law that prohibits confidential employees, managers, and supervisors was cut, copied, and pasted directly from Baltimore County Code. Changing our law would have a cascading impact on Baltimore County government, who funds Baltimore County Public Library. BCPL cannot support this bill as it's written. I ask for an unfavorable report on SB 914. Thank you.
Thank you. Do I have any questions? No. I have one question. If we did it for the rest of the state and the world didn't collapse, why shouldn't we just include one more county?
So Baltimore County Public Library was excluded from consideration in that bill because we already had our own law that was well established for us. So we weren't included, and nobody asked our opinion about the bill. Had we been included and been given the opportunity to weigh in on the bill, we would have joined the chorus of opposition from libraries who were supportive of their staff organizing, but were not supportive of their supervisors and managers organizing. And post-implementation of that bill, a number of my colleagues across the state are struggling with implementation of that bill, specifically because supervisors are organizing alongside their staff.
Thank you. Senator Mounts?
Thank you, Madam Chair. And that kind of follows up on the previous question. So we've got 4 counties in District 37. All 4 were opposed to the bill last year. Are they? Do you know offhand if they're opposed to this bill? Again, the same opponents, the same groups that were opposed to the bill, were they opposed, or have they now said, well, this has now changed? Have they changed? What's their status?
So, Senator, this bill is specific to Baltimore County, so I don't think those counties have weighed into it. Last year's bill did not include Baltimore County because we had a specially crafted bill from 4 years prior, so we were not included in the bill from last year. So I presume they did not weigh in on this bill.
My mistake. Bad
No
question.
problem.
Thanks.
Senator, I think that ends the hearing on this bill, and I'm going to turn this back over to my vice chair.
Thank you.
Thank you, Madam Chair. Next, we'll hear Senate Bill 846, 842, other tobacco products and electronic smoking devices. Chair Bidel and her panel, Laura Hale, Kristen Jemison, and Tyler Brody. Are we missing someone?
Thank you, Mr. Vice Chair and members of the committee. For the record, Pam Bidel, District 32. And thank you for the opportunity to present Senate Bill 842, other tobacco products and electronic smoking devices, seizure and wholesaler licensure requirement. You may be aware that in Maryland, we're having an issue with underage folks that are purchasing the electronic smoking devices. And so this bill makes an attempt to limit the availability of these devices to our young people. So though Maryland has made important strides on tobacco control, the problem of youth access to tobacco products, particularly electronic smoking devices, remains significant. Big tobacco is persistent in targeting children, so we too must remain persistent in protecting these children from these products. I've included several sponsor amendments with SB 842. The amendments arise from the conversations we've had with ATCC that further align the bill with their current practices. There was a time that before it was ATCC, when this was still handled out of the comptroller's office, that they could perform these enforcement operations, but when it became the ATCC, that MOU did not transfer over. So this bill is really taking the ATCC back to the enforcement that they were allowed to do before they were the ATCC. They're currently unable to seize tobacco products like cigarettes in carrying out its enforcement authority. Notably absent from any seizure authority, however, is authorizing language that allows it to seize electronic smoking devices for any violations. Senate Bill 842 would grant the ATC this seizure power. A similar loophole exists in the record-keeping requirements for electronic smoking devices. Though other tobacco products are subject to record-keeping requirements that include key information like who the products were purchased from, what retailers they may be sold to, and supporting information like quantities and dates of sale, electronic smoking devices are not subject to these same record-keeping requirements. Senate Bill 842 would bring electronic smoking devices under the same record-keeping requirements. This bill, I've worked with the ATCC to bring you this bill. In a little while, we'll have another bill from Senator Guile that is from the Attorney General's office that will address registration and other things. So these two bills can work together. They're not in opposition to each other. This is the operation of the ATCC. Senator Guile's bill is the Attorney General's office. So the need for this legislation is broadly recognized. In 2024, polling showed 81% of Maryland voters supported action against big tobacco to safeguard our children. The facts make clear why concern is so widespread. Over 48,000 Maryland high school students self-report that they use tobacco products, a number that likely falls short of the true total. The impacts of tobacco use are significant. Maryland incurs annual health care costs of approximately $3.14 billion directly related to smoking, and 27.5% of cancer-related deaths in Maryland can be traced to tobacco use. For these reasons, I respectfully request a favorable report on SB 842 with sponsor amendments and continue your strong track record of protecting our children from the dangers of tobacco. And thank you for your attention.
And I just wanted to say Laura Hale from the American Heart Association was sick today and could not make it.
Gotcha. That's what I was missing.
So, good afternoon, members of the committee. My name is Kristen Jimison. I am the Regional Advocacy Director for the Mid-Atlantic for the Campaign for Tobacco-Free Kids. I'd like to thank you for the opportunity to be here today and also acknowledge the support of our public health partners who couldn't be here due to conflicts from the American Heart Association and the American Lung Association. They both submitted written comments. Senator Bidel explained the bill. I'm going to talk a little bit about some of the public health impacts and then let Tyler share his own experience, which I think is really compelling. Last year, we passed the Tobacco Retail Modernization Act, and this legislation is seeking to close a loophole in that act around enforcement laws in the ATCC, specifically related to electronic smoking devices, also known as e-cigarettes or vapes. We know that the problem of youth access to tobacco control remains, and that the tobacco industry persistently targets our children, Black Americans, Latino communities, and our LGBTQ communities. So we must also remain persistent. We know that more than 14% of Maryland high school students reported using e-cigarettes in 2023. We're seeing that young people aren't just experimenting with these products, but they're also showing signs of serious addiction. Some of today's e-cigarettes can contain as much or more nicotine than 200 cigarettes. We know that nicotine is a highly addictive drug that can harm the adolescent brain, particularly in the areas of the brain responsible for attention, learning, mood, and impulse control. We feel that this is the next step forward in continuing the strong work that this committee and the legislature has already done to protect children from tobacco, and we urge a favorable vote. Thank you.
Yes, for the record, Tyler Brody. I have the pleasure of serving as lead youth activations coordinator with CLEA, Community All in Action. And I want to say thank you to Mr. Chair, Vice Chair Haynes, and the members of the committee. My name is Tyler Brody, and I'm here to support my strong interest in Senate Bill 842. But most importantly, before I do that, I want to thank Chairwoman Bidel for her leadership in sponsoring this important legislation, which will protect Maryland's youth from the harmful influence of tobacco and e-cigarettes. It was already stated, but more than 48,000 of Maryland high school students self-report using tobacco, and that number likely underestimates its true total. We know that big tobacco has a large history of targeting young people with flavored e-cigarettes, sleek marketing, and easy access to have a nicotine addiction growing amongst our youth. I see firsthand, schools are struggling to curb vaping in classrooms and in bathrooms. Students once who excelled are now distracted, anxious, and unable to focus due to the nicotine addiction. Many of them don't even realize of the long-term consequences that these products have made. It was already stated, but I'll say it again. Maryland spends $3.14 billion annually on health care, and 27% of that goes directly to cancer-related deaths in our state, which are linked to tobacco use. If we fail now, we're not only risking the health of young people, but we are creating a long public health and economic burden. Senate bill not only grants the Alcohol, Tobacco, and Cannabis Commission the same seizure powers, but it also requires wholesalers to maintain sale records for e-cigarettes and bringing them in line with other tobacco products, and it will increase accountability. These are common sense measures that will help prevent illegal and harmful products from reaching our kids. And 81% of that, because we voted for it, we have to take a stronger action. If this is our opportunity to take a stand to continue Maryland's strong legacy for protecting young people and the dangers of tobacco, thank you for your time and leadership for this issue.
Thank you. Are there any questions for this panel? Seeing none, thank you so very much. Next, we have a group of individuals who signed up favorable with amendments. That is Matthew Milby, Melissa Hendricks, Candace Gott, Almer Bailey, and Carrington Anderson. Will 5 of you please come up to the table? I'm counting 3, 4. 4 are we missing? Okay, that's fine. There you go. You may proceed in whichever order you desire.
Thank you. Good afternoon, Chair and Committee. My name is Candace Scott, and I'm a member of the Maryland Vapor Alliance. The intention to crack down on bad actors in the ESD market is crucial, and I commend this initiative. However, as currently written, the bill will cause a clerical and compliance tornado, creating challenges for audits of both businesses and vendors, which could render it unenforceable. We should focus on practical amendments that truly address the issues at hand. I wholeheartedly support the bill's goal of enhancing the ATCC's enforcement authority, as this will protect public health and ensure a fair market. Increasing the power to seize products sold in violation of the law is necessary to eliminate rogue operators that endanger consumers. I am proposing an amendment to require all retailers selling electronic smoking devices to obtain a specific ESD retailer license or a vape shop vendor license. This will help regulate the market, ensuring compliance with IDs, tax laws, and product safety standards. This standard alone will generate a specific list for the ATCC to work with. Currently, it would be burdensome and likely to have no effect if vendors must register with the state, who will have the task of auditing the vendors and then auditing that list against retailers in Maryland. This won't work. Additionally, it is vital to establish mandatory penalties for businesses that fail to collect or remit sales tax on tobacco and ESD products. Many retailers are currently non-compliant, depriving the states of millions in revenue. We need clear consequences for tax evasion to deter the bad actors and protect honest businesses. I also recommend limiting the sale of larger volume vape products that are over 5 milliliters to licensed vape retailers. This measure will allow for tighter control and oversight, ensuring that these products are sold in responsible environments that prioritize public health and compliance. I'm asking this legislator to work with responsible people in the vape industry to find solutions that will not kill small business. Thank you.
Thank you, Mr. Vice Chair and members of the committee. My name is Carrington Anderson with the Maryland Association of Counties, speaking in support with amendment on Senate Bill 842. County's amendment suggestion is really just clarifying and I believe aligns with the intent of the bill. One of the provisions grants the executive director of the Alcohol, Tobacco, and Cannabis Commission or a peace officer the authority to seize products. Where counties are just asking for clarifying that the enforcement duties fall within the commission and their peace officer, rather than local law enforcement or others that might otherwise fall within the term peace officer. So really just a belt and suspenders we think aligns with the intent of the legislation, and it's for these reasons we would suggest a favorable amendment to report on Senate Bill 842.
Thank you. Good afternoon, committee members and Chair Beidel. Thank you for your time today. I'm favorable with amendments of SB 0842. As a small business who works with the MVA, I really do hope that you take these amendments seriously. We've had a few members within the organization, so other small vape shops. We've gone around to over 70 shops who are not complying with sales tax or age checking. So we have been working with the ATCC in hopes of strengthening the licenses that we currently have within the state. And the reason that we need to strengthen the licenses is to understand the products that are to be sold within what location. When I purchase my product, I have to update my vape vendor's license to our distributors or I will not be able to buy product. However, you can have a vape vendor license, tobacco license, or an OTP license in order to sell the same thing that I sell. But I can't sell cigarettes with the license that I currently have. This makes it hard for the state to figure out who is selling what and even at the correct tax. Limiting 5 mils and lower nicotine devices or liquid 5 mils or lower to just tobacco license and OTP license, that'll help reduce the number of families and products exposed to children. Keeping 5 mils and above within vape shop vendor license will help to keep it out of the hands of children. Plus, there's a clear difference between what each of the license holders are to be allowed to sell. Penalties should be given with businesses not complying, and I do think that the ATCC should have the authority to do so with stronger penalties and enforcement. I've been in business for almost 10, 11 years, and I have not been checked for IDs, not once. And I'm very stringent on that policy. So thank you for today.
Thank you, panel. My name is Elmer Bailey. I'm with the Maryland Vapor Alliance. I'm also a shop owner in Western Maryland, Frederick County. So thank you for the opportunity to speak here today. I really would like to make it clear that we are not big tobacco. We are kind of the anti-big tobacco. We have contributed greatly to the state in bringing cigarette tobacco usage to what I believe are record all-time lows. And we actually supported, we received the governor's pen for Tobacco 21 legislation here in Maryland. We led the effort to curb access to tobacco products and e-cigarettes. These products do not contribute to burdens on the healthcare system. They actually contribute to getting people off of cancer-causing combustible tobacco. I wholeheartedly agree. We should have some clear, concise enforcement. We should also have clear, concise regulation and licensing of where these products should be sold and where they shouldn't be sold, which would also go a long way towards prohibiting youth access. We have not been the bad actors in this problem. Issue comes with widespread availability in outlets that are selling big tobacco products, which we are not. So I think this is where some of the conflagration and issues start to muddy the waters a little bit. So I would love to see better licensing, stricter licensing regulations, separate and understand the difference between the big tobacco products and what we are offering the state.
Good afternoon, Madam Chair and members of the committee. My name is Matthew Milby, and I'm a small business owner and disabled veteran here in Maryland. And we understand what this bill is trying to accomplish and giving excess power to the ATCC to enforce the law. And we're very in favor of the ATCC enforcing the law. We share these values. We have seen a plethora, a boatload of shops in Maryland not charging the proper tax. And we've done some of our own investigating into this. And the budget deficit we're in right now in the state of Maryland, this accounts for a lot of money. I'd love to sit and go down the figures with you. But a lot of shops are only charging 6%, and especially a lot of shops, if you're paying cash, you're not paying any tax whatsoever. And these vapes have become an item of convenience where you can get them anywhere. We even found a flower shop selling these products. They belong in vape shops. Vape shops have proven to card an ID and to pay the proper taxes. And you can do that easily with a simple Google search on compliance in Maryland. We are not selling to minors. And we propose these amendments. So we're going favorable with amendments about moving these 5 mils or more into vape shops. It puts access in the hands of responsible retailers instead of as a convenience item like it is right now that you can virtually get anywhere. We've offered the amendments to this bill that will bolster enforcement while not compromising tax revenue. So we're urging you to work with the Maryland Vapor Alliance, and we can pass this issue and collect the tax that is due Maryland and help keep these out of the hands of children. Thank you.
Thank you. I think that's it. Right. All right. Are there any questions of this panel? Senator Reedy.
Thank you very much, Mr. Vice Chair. Mark, I wonder if you could elaborate a little on your testimony. So you mentioned the flower shops and other places that are selling things that they shouldn't be. They're selling these when they shouldn't be. You guys are willing to have some sort of licensing scheme or permitting scheme to help regulate, correct? I mean, that's what you're saying in your testimony?
Yes, these items, like I said, the ESDs, they've become a item of convenience that you can get virtually anywhere because people, they don't have the proper licensing. This flower shop that we saw selling ESDs had no license at all, either the vape shop vendor license or the ESD retailer license. They had neither one of these. And so we would love stricter licensing to make sure that the people that are selling them have, the proper license to do so.
Do you think that sometimes it's just an issue? Is it more of an issue of, do you think the current enforcement process doesn't need to change, or do you think it should be tweaked a little bit more? Because obviously the bill's trying to make some real changes to it, and it sounds like there are some bad actors. I mean, anybody can answer that question.
You can speak to that probably better.
We definitely don't want people, we definitely want compliance, and we don't want people getting the stuff that they shouldn't have. I'm sympathetic to, I think we're all in the committee sympathetic to small businesses that are trying to do it the right way. So I mean, I don't know if you could comment.
That's correct. So for the licensing, we have 3 different types of licenses. We have tobacco license, we have OTP license, and then you have a vape shop vendor license, right? Even if I'm a tobacco license, I can still sell vapes. But as a vape shop vendor license, I can't sell tobaccos, I can't sell cigars, but they can sell the products that I'm selling. And at the end of the day, that puts those products inside convenience stores and wherever else, corner stores, liquor stores, gas stations.
And is it your contention that's where we're having a problem?
Yes.
Within the companies?
100%.
Okay.
Yep.
Okay, thank you.
Can I add to that real quickly too? That
I don't think the chair allows us to do it. Thank you, but maybe somebody else will ask.
All right. Are there any additional questions for this panel? Thank you all so very much.
All right, thank you.
Indeed. Next, we will hear from Bruce Bariano. Bruce is signed up as unfavorable.
Good afternoon, Mr. Chairman, and members of the committee, Senate Finance Committee, Madam Chair. Probably should have signed up favorable with amendments. I testified on this bill over in the House side. I was supposed to get amendments and did not get them, and hopefully I can get them here. I have some procedural concerns. I'm here on behalf of the Maryland Association of Candy and Tobacco Wholesalers. The problems I have with the bill are as follows. Very disturbed that you're giving power without any warrant, without any judicial officer, without anyone looking at that beforehand. And as indicated by one of the other witnesses, the definition of peace officer really needs to be clarified. It's a very broad term, but it really troubles me. And without a warrant, and if you look at Senator Giles' bill, which I know is next, and I'm not trying to testify on that now, but the extent that my clients, the wholesalers, are going to get more involved in this, the ability to go into their businesses without a warrant troubles me greatly, because not only can they then seize, but under this bill, Senate Bill 842, once you've seized all the material, we're then responsible, regardless of reimbursement for the cost of transportation, storage, or disposal of the seized property. We're also responsible for attorney's fees and actions against us by the authorities. And I think someone has to look it over before such significant authority. The ability to go in without a warrant. Maybe it's the 30 years I practiced law, but you've got to have some probable cause. You have to have some, at least prima facie reason to have the ability to exercise such significant power and authority. And that's what I'm concerned about. I'm not dealing with the other issues, which are valid and very legitimate, but that is really the concern. And if you look at this in terms of Senator Giles' bill, Madam Chair, as you indicated, they kind of go together. That gives my clients more involvement with these products as wholesalers, which is fine, and I'm signed up favorable for that. But we don't want someone coming in without a warrant and without some probable cause. Thank you very much.
Thank you so very much, Senator Bidel.
I do have a question. What's this process now for if we have seizing cigarettes that are untaxed? Do they go in with a warrant or without a warrant when they see cigarettes?
I'm not certain. I think they go in without a warrant.
Okay,
But two wrongs don't make a right.
Thank you.
And I was taught that by my parents.
Thank you, Mr. Berry.
Thank you.
Appreciate it. Oh, hold on. We're not completely done.
I'm sorry.
Senator
Sorry.
Guy.
Sorry, I didn't mean to be rude.
No, it's okay. Just to follow up on that question, because I know we've had this discussion before. I remember there was a floor debate on a bill that the ATCC brought. I mean, I understand your point being raised about needing a warrant, but the thing is if you're getting this license, that you basically agree to the restrictions under that license. Is that fair? And so therefore that they can enter at any time to do these checks. Is that
Yes.
correct? Yeah.
Yes.
Okay. All right. Thank you. Thank you, Madam Chair.
Thank you very much.
Thank you. Thank you for your testimony. Are there any additional questions? Seeing none. Next. I think we are done. This ends the hearing on Senate Bill 842. I'm going to turn it back over to Senator Biden.
Don't you have two virtuals?
No, they're not, no shows. Yep. Senator Biden.
Thank you. I think I see Senator Hester here. Senate Bill 691, Cybersecurity Healthcare Ecosystem. We're joint with EEE on this bill. So, I know. Yeah. So, Senator Hester, you're doing double duty. You're here as your sponsor and you're here as the representative of EEE, but you can handle it. So, thank you.
Okay, thanks.
You have Ben Yellen and Clay House on your panel, right?
I do.
Okay.
Thank you very much.
Thank you.
Thank you, Chair Beidel, members of the esteemed Finance Committee. For the record, Senator Katie Fry Hester here to present Senate Bill 691. My Chief of Staff is passing around a PowerPoint, which kind of follows my testimony if you want to follow along. Senate Bill 691 is a critical piece of legislation aimed at protecting Maryland's healthcare system from escalating cyber attacks. Cyber attacks in healthcare are a serious threat to public safety, with the FBI and Department of Justice labeling them as a threat to life crime. The National Security Council has identified healthcare as one of the top 3 sectors that urgently need stronger cybersecurity. Cyber criminals, often backed by hostile nations, target hospitals knowing that that any disruption can put lives at risk. If you flip to page 3, you can see that healthcare is a prime target due to its valuable data and urgency of ransom payments. Hacking-related breaches have surged 256% in the last 5 years. And in 2023, the FBI identified healthcare as the most targeted sector for ransomware. Maryland alone has seen 84 major breaches since 2010, affecting over 3.5 million residents in 23 alone. Going on to page 5, I apologize. The kinetic impacts and the financial impacts are kind of crisscrossed at the top of the slide. But my point is that cyber attacks are not just IT issues. They disrupt patient care. A recent study found that 92% of healthcare organizations faced cyber attacks last year. They also reported a 28% reported increase in patient mortality for those hospitals that had the cyber attacks. 28% increase in mortality. 59% saw delays in procedures leading to poor health outcomes. And 46% of those hospitals had to transfer or divert patients. Cyber attacks are taking a severe toll on hospitals' finances as well, with 94% of hospitals reporting financial loss and 60% losing over $1 million per day. On the next slide, the 2024 Change Healthcare attack underscores the financial strain caused by these cyber disruptions. A significant 82% of hospitals are experiencing major cash flow issues still, making it increasingly difficult to keep their operations running and pay for essential services. At the same time, 67% of hospitals are struggling to switch clearinghouses, adding another layer of complexity to restoring billing and reimbursement processes. To make matters worse, 20% of hospitals are still uncertain about the full extent of the financial damage caused by this incident, leaving them in a vulnerable position as they continue to deal with these disruptions. On the next slide, Senate Bill 691 really follows the approach that we used in HB 969 from 2023, which provided increased cybersecurity standards for utilities. This bill takes a very similar approach. It requires the Department of Emergency Management, the Maryland Insurance Administration, the Maryland Health Commission to enforce stronger cybersecurity standards and adopt a zero trust model. Biannual, meaning every other year, third-party audits starting in 2026 with findings reported to the state CISO. A healthcare cybersecurity work group to improve resilience, to define essential functions, and coordinate incident response. And this is because it's not really a matter of if, it's a matter of when these attacks happen. Real-time cyber incident reporting to enhance state situational awareness. Last year, there was a bill that was very similar to this one, which we wound up pulling because it wasn't quite ready for prime time. We tried very hard to work with the Maryland Hospital Association over the interim to discuss the bill and the path forward, but we really didn't make that much progress. We did share with them examples from New York and Oklahoma, and if that brings us to where we are today. We're still in conversations with them, colleagues. But I urge this committee to take decisive action to protect Maryland's healthcare infrastructure by implementing the safeguards outlined in this bill. Cybersecurity in healthcare is not optional, colleagues. It's a matter of life and death. For these reasons, I respectfully request a favorable report on Senate Bill 691.
Thank you, Senator. Ben Yellen.
Chair Bidel and members of the committee, thank you for the opportunity to testify. My name is Ben Yellen. I am the Program Director for Public Policy and External Affairs at the University of Maryland Center for Health and Homeland Security. We worked with Senator Hester during the interim on a report detailing the frequency and impact of cyber attacks on the healthcare ecosystem. An analysis of this threat landscape was sobering. Healthcare is an attractive target for cyber criminals for several reasons. First, the system contains valuable data, including patient-protected health information and personal identifying information. This valuable data can be sold on the dark web for amounts far exceeding, for example, stolen credit card information. Second, the disruption to health systems is devastating for its impacts in communities. It can cause downstream effects that lead to bad patient outcomes, just as Senator Hester shared that very sobering statistic of a 28% increase in mortality rates for systems that suffered cyber incidents. Finally, cyber criminals are fully aware for the potential of this catastrophic disruption, and that is an incentive for these criminals to try to extract significant ransom. What makes attacks on healthcare systems unique is that an attack on one part of the ecosystem has a cascading impact in the entire ecosystem. When Change Healthcare, a subsidiary of United Health Group, suffered a cyber attack, the impacts were devastating, even though the attack had no direct impact on hospitals, providers, or insurers. But because Change Healthcare served as an intermediary to facilitate important functions like eligibility checks, insurance claim submissions, and billing services for care centers, the entire ecosystem suffered. 74% of hospitals suffered impact to patient care. 94% reported a significant financial impact. So this is just the backdrop of the necessity for this legislation, and for these reasons, I respectfully request a favorable report on Senate Bill 691.
Thank you, Ben. Clay House.
Good afternoon. My name is Clay House. I'm the former Chief Information Security Officer for Care First. Thank you for the opportunity to give my support to this bill. As you've heard, the attacks on healthcare continue to increase. And while the financial impacts are significant, the impacts on patient care and mortality rates are tragic. You've also heard that the healthcare system is really an interconnected set of entities that must communicate in real time. And when one of those entities is attacked, that has the ability to ripple across the infrastructure. AHA's National Advisor on Cybersecurity and Risk noted that cyber adversaries have mapped our system and they are targeting central services. He concludes that we must have regional incident response plans and can no longer do this in silos. Current regulations perpetuate the siloed view of this. Regulatory oversight of Change Healthcare failed both to identify the vulnerability at the company as well as the potential risk to the system as a whole if they were to go down. Senate Bill 691 has the assessments that Senator Hester spoke about and compiles them into a system-wide view of the risk, which is something that we don't have today. It then has two industry-led work groups, one focused on looking at these controls and the risks that they represent, and another focused on what it takes to make our system more resilient so that the care can continue to be given if in the event of an outage. For these reasons, I urge you to support 691.
Thank you. Senator Guile.
Thank you, Mr. Chair, or Madam Chair, sorry. Mr. Vice Chair. Mr. Yellen, how does this, I was just looking at this, how does this compare with the New York approach?
So the New York approach, instead of being enshrined in statute, was a regulation. The regulation, and we have a link that I believe we can provide, I don't know if Senator Hester's office can provide to you, is much more prescriptive than this bill. This bill would give authority to MHCC as it applies to healthcare entities and MIA as it applies to insurance, to the insurance industry. It would have them work with the Office of Security Management to develop standards. The only prescriptive element of that is adopting a zero trust approach to cybersecurity, which is a best practice. But other than that, it's far less prescriptive than the New York regulations, which you can really get down in the weeds in reading those regulations.
Okay, thank you. Thank you very much for the explanation. Thank you, Madam Chair.
Thank you. Senator Ellis.
Thank you, Madam Chair. Thank you, Senator Hester, for this bill. I mean, your work in the cybersecurity area has been priceless for the state of Maryland. Did a lot of work with you when we were on the same committee, now EEE, and a lot of those innovations you've pushed forward are now state law, and I see the effects of them. So I really appreciate your work in the cybersecurity area. And you know, it's difficult to understand for a lot of non-tech people, but you do a great job in breaking it down for us. So I really appreciate you. Ben? Yeah. What other states have taken this kind of lead in legislation like this?
So there are a couple of different approaches that can be taken. We talked about New York, which took a regulatory approach. Several states, including the state of Oklahoma, took a safe harbor approach. In that approach, it was an affirmative defense in the case of any type of lawsuit against a hospital or hospital system. It was an affirmative defense for the hospital that they took proactive cybersecurity measures. Okay. So that's more of a carrot approach than a stick approach.
Now, that's a kind of different new term, safe harbor approach. I'm not familiar with that. I mean, what does that mean? They can't be sued, or what does that mean?
Yeah, it is a defense in a civil lawsuit. It is an affirmative defense in a civil lawsuit that they took proactive cybersecurity measures, and it can be decisive in these cases. It shows that they weren't negligent, for example, in their handling of private health information.
So it either kind of protects them or mitigate their liability?
It could mitigate their liability,
Okay.
yes,
Okay.
mitigate their losses.
Thank you. Thank you, Madam Chair.
Thank you, Senator Ellis. Senator, I think I see in the bill that the hospitals would have to do a cyber and IT audit every 2 years. Did I read that right?
That is correct, Madam Chair. That is currently what we require of each of our state agencies. We did that a couple
Did
of
I
years.
see you in the front of Maryland Matters this morning criticizing our state agencies for the money they're wasting in IT?
Only do it.
Only do it. Okay, so they're doing an audit every 2 years, and now you want the hospitals to do an audit every 2 years, but it's not been very successful with the state.
Well, you're mixing two things.
Apologies. Tell me what I'm mixing.
So the audits are maturity assessment audits for cybersecurity. We have seen improvements across all of our state agencies in their cybersecurity maturity level. The criticism of wasting the IT money is for the IT development projects, and I'd like to thank the good Senator Hershey for working with me on this. But that is really because when they're developing their IT projects, which have nothing to do with cybersecurity, when they're building them. They're hiring contractors to oversee other contractors. There's multiple divisions within DoIT, and my criticism has been very specifically about the major IT development projects.
Okay. So what happens when the hospital does the audit after 2 years, and who does the audit?
It is my understanding that many of them are currently required to do these audits by federal regulation.
Okay.
But we're not asking for them to send us the information. We're asking for them to certify that they are in compliance with minimum cybersecurity standards.
So
and that can be done actually by an auditor. Senator Ellis and I worked on that 2 or 3 years ago.
So it's an outside firm that audits the hospitals? Third party?
It's required to be a third-party entity.
Required to be a third party. What happens if they fail?
So cybersecurity is a journey, Madam Chair. There's nothing in this bill that penalizes them for not meeting the requirements. That would be counterproductive. The state really wants to be a partner and to assist the hospitals in meeting these cybersecurity goals. That's why we are increasing the staff at MHCC to make sure that they have a person who understands this technology who can, help to make sure things are going well. In my opinion, I believe that most of the larger hospitals and the other large entities in the ecosystem probably already are doing the bare minimum. It's the littler guys which we will have to support, and both the Department of Emergency Management and the Department of IT can provide services.
So the fiscal note looks like due at expenditures is $559,467. Have you talked with Budget and Tax about the fiscal note?
I have not yet, but I will.
Anything over $100,000 we have to submit.
Absolutely.
So that needs to be discussed. Thank you very much for your testimony. Any other questions? Thank you very much. Next, we have a couple of, John Fiastro is favorable with amendment.
Madam Chair, I'm going to hand off to my client, Tasha Cornish,
Instead
first.
of you, it's going to be your client.
She is registered to testify this afternoon.
What's her
Tasha
name?
Cornish.
What is it?
Tasha Cornish.
No, you are registered, John, only you.
Okay, well, then I will.
Okay. You could give it to her.
Yeah, I can see
But I'm not going to have
give
both
her.
of you.
Can I give her a minute?
No.
Okay, all right.
So which one of you is testifying? Go for it, Thank you.
I'll go for it. Thank you. Thank you so much. Chair, Madam Chair, Vice Chair, very pleased to be here. For the record, my name is Tasha Cornish. I am writing today on behalf of the Cybersecurity Association. We're a nonprofit 501c6 organization dedicated to strengthening the cybersecurity industry. Our association represents over 600 businesses ranging from small enterprises to large corporations employing nearly 100,000 Marylanders. We appreciate the opportunity to be here today. We overall support the gist of this bill with amendments, of course, to ensure this legislation aligns with best practices in cybersecurity law while balancing security requirements with the reasonable compliance expectations. One of these amendments include ensuring that we are keeping up to date with the federal compliance and federal regulations. For example, just last month, HIPAA introduced a new security rule or a notice of rulemaking to update that. So we want to make sure that this law follows those standards and does not add undue pressure to our healthcare systems here. Secondly, the first panel teed us up a little bit. We did include amendment language here about the safe harbor and affirmative defense. We did reference specifically the Oklahoma Hospital Cybersecurity Protection Act of 2023 that does, again, grant affirmative defense and tort actions for healthcare entities that implement and maintain reasonable cyber measures based on recognized industry standards. There's more information on this in our written testimony as well. So again, we really think that this is a needed addition to this bill. The carrot reference was made earlier. Our healthcare systems are already under incredible pressure with very small margins to conduct their jobs. And while we highly value cybersecurity, they need some support in doing so. So thank you for your time.
Thank you, Tasha. I did find your testimony with amendments under John's name, but we found it. So thank you. Do I have any questions for Tasha? Thank you very much for your testimony. Next, we have 3 unfavorables, Ron Nolte Jr., Jake Whitaker, and Andrew Nicholas.
Good afternoon, Madam Chair, members of the committee. My name is Jake Whitaker on behalf of Maryland's hospitals and health systems, here to testify in respectful opposition to Senate Bill 691. While we appreciate the goal of this bill and Maryland hospitals are committed to upholding the highest cybersecurity standards and safeguarding patient data and safety, that said, we do have some concerns with the approach outlined in this bill. Hospitals already comply with rigorous federal and standards and accreditation requirements, including HIPAA, the National Institute of Standards and Technology Frameworks, and the Joint Commission standards. So for example, the Joint Commission is responsible for accrediting hospitals and making sure that there's quality and patient safety protections in place. So for example, there are very robust guidelines, including hazards vulnerability analysis, continuity of operations plans, disaster recovery plans, and emergency management education and training programs. Additionally, in order to maintain cybersecurity insurance, hospitals have to also meet very stringent cybersecurity standards, including conducting risk assessments and audits, and doing incident reporting and employee training. And so as a result of these standards, as I mentioned, Maryland hospitals already conduct regular assessments and audits. And so as we know, technology also evolves extremely quickly, and so do these standards. So for example, I believe a previous panelist mentioned that HIPAA is actually recently updating the cybersecurity rule, and they proposed that in December. And another point that we wanted to make is that cybersecurity threats do not stop at state lines. Healthcare cybersecurity involves multiple stakeholders, hospitals, insurers, health information exchanges that operate across multiple state lines. And for example, some of the hospitals that are even members of the Maryland Hospital Association have hospitals in other states. Additionally, I wanted to point out that to the extent that this bill would impose additional requirements, this could result in unplanned additional costs for Maryland hospitals. Maryland's hospitals use a unique rate-setting system that limits hospitals to a global budget for any given rate year, meaning that they're working with basically a fixed amount of revenue for any given set rate year. And I'll wrap up shortly. And in light of our global budgets, because this bill could impose new costs, without providing a funding mechanism, we have concerns that we would need to cut from other services in order to cover the costs of the requirements of this legislation. So for the aforementioned reasons, we respectfully request an unfavorable report on this bill. Thank you.
Jake, thank you. First, I want to ask you, Andrew is not here, or Ron Nolte?
No, Andrew could not make it, but I'm not sure about
I don't know
Ron.
where Ron's from.
Yeah, I believe Ron is out sick, unfortunately.
Thank you. Everybody's sick.
I know, it's going around, yeah.
So with the current things that you do, we keep talking about the change, you know, the big cyber with change. Did they do all the things that you do as a hospital? Were they under all the same kind of regulations?
That I would need to follow up with, but I think it kind of speaks to the larger issue that we're dealing with national entities. They're across state lines. There's different types of health entities that are kind of working together. And I do appreciate Senator Hester recognizing that and having an ecosystem bill where it covers multiple entities. But I think it speaks to the fact that this needs to be more regulated broadly at the federal or kind of a national level because of the fact that the data is kind of crossing those state lines.
Well, I'm not surprised that you would say that, but we're not getting much done on the national level, but thank you for that recommendation. Senator Ellis?
Thank you, Madam Chair. Before I ask you a question, sir, Madam Chair, you asked a question about who would do these audits. So regular auditors, CPAs, now they have a specialty called Certified Information System Auditors that can go in and do their regular audits. They also audit the information systems and the cyber. So that is just placed right in there. And the audits for every organization is then turned over to the management, who's responsible to their boards and to others to make sure those audit findings are, we call it, adjusted and changed to make sure the operations go well. So the system is in place. I know for the state, we did that in the cyber bills we passed a few years ago, and our legislative auditors also do an information system audit to make sure that these state agencies, towns, and other state functions are properly functioning with the information systems, and it's working very much seamlessly. So to you, sir, you're Jake, right?
Yes.
Okay, with Maryland Hospital Association?
That's right.
Okay, yeah. You seem to think that, correct me if I'm wrong, that just doing this additional function in the regular audits would be kind of burdensome or so much more expensive. But think about the effects on consumers. You know, I hate to say that I'm a victim of the change attack. I knew problems were coming, and it came when I saw my credit cards were being used in Vegas. I mean, thousands and thousands of dollars charged, you know, and I mean, I just kind of knew it would happen, and we were watching for it. So on the effects on hospitals, on patients, and other folks in the community, don't you think the benefit would outweigh the costs of basically doing some of these things recommended by this bill?
Thank you for the question, Senator. And I think we certainly agree that it does outweigh the benefit, or the benefit does outweigh the cost. I think the challenge is that this requirement is duplicative. So hospitals already conduct these assessments and audits. They're required to by federal rules and regulations. We follow accreditation guidelines that also recommended these assessments as well. And frankly, our cybersecurity insurance policies also require us to conduct these assessments. So totally agree that these are critically important, and that's why the hospitals are doing that already.
So they're doing it already?
That's right, yes.
Okay, well, I don't know how to.
So I could further clarify. So hospitals are already conducting audits and assessments. Yeah. I think our concern is by having it this prescriptively laid out in the statute.
So this would make you do more, or you said it's confusing. I mean,
it would be duplicative and different, but I'm happy to share with you some of the assessments and some details related to those that we're doing in comparison to the state rules.
Okay, reach out, in the interest of time, reach out to me. Let's talk about that later.
Absolutely.
I understand that, okay? I want to take a committee time, because you kind of lost me right there. Yeah. Okay.
And thank you, Senator, and thank you, Jack. I want to add one more thing. I misquoted the fiscal note. There's 3 different parts to the fiscal note. MIA gets a position for $140,000. The MHCC is $280,524, and DoIT is $559,467. So there's almost $1 million fiscal note on this bill for hospitals that are already doing assessments. So just wanted to share that with you. Thank you. I think that, we have another question from Dr. Lamb, Senator Lamb.
Yeah, thank you, Madam Chair, and apologize, I was in and out because of other bill hearings that I have, but, and maybe I missed it. So if you're already doing it, if hospitals are already doing it, then I certainly understand the costs, but for MHA's opposition, what's the concern if hospitals are already doing this, right?
So when we consulted with our members, I think the concern is that the requirements are duplicative and they're kind of inconsistent and they're too prescriptive for what we need. So hospitals already conduct these assessments, and apologies, our cybersecurity expert couldn't make it, but I'm happy to take that back to show you a comparison of what we already do versus what the bill is requiring us to do.
So if that could be addressed in a way where it meets most of what you're already doing, would you be comfortable with the bill then at that point, or would?
That's something I would certainly take back to our members, but the bill does a lot more than just require those audit processes.
Okay. Thank you.
Thank you.
Thank you, Senator. Senator Cobb?
Yeah, thank you, Madam Chair. Just one quick question, Jake. I mean, I had some information that maybe not all hospitals of all sizes are doing these assessments already. Is it your testimony that all of them are doing this?
So we didn't pull every single hospital, but the hospitals I spoke to said they engage in assessments, but I'm happy to reach out to our members to see to what extent every single one of them does it.
Yeah, if you could get that information, that would be helpful.
Absolutely.
Thank you, Jake. Appreciate it. Thank you, Madam Chair.
Are you finished, Senator Cobb?
Yes.
Okay. I got the analyst talking to me. I got somebody from the Hospital Association texting me. It's like, okay, if there are no other questions, that ends this part of the hearing. We have one more virtual. It's Greg Lehman, favorable with amendment. Thank you, Jake. Thank you. Mr. Lehman, you can unmute and go ahead.
Well, thank you, Madam Chair, Vice Chair, members of the committee. Thank you for the opportunity to testify for Senate Bill 691. For the record, I'm Dr. Greg Von Lehman, Special Assistant for Cybersecurity at UMGC, and I'm also staff to the Maryland Cybersecurity Council, and my comments today are my own. Just broadly, I would say the bill has 4 strengths. First, it recognizes the complexity of the problem of healthcare ecosystem resiliency, and it does that by calling for a deliberative process to help inform any regulation MHCC and MIA would undertake. And this is the bill's requirement for MHCC to convene an ecosystem stakeholders antecedent to the initial rulemaking to deliver recommendations for regulatory standards and other changes. It sets in motion a process of continuous improvement, does this through third-party audits, and requires self-certification of ecosystem entities attesting that they're in compliance with standards or moving to close those gaps. Third, through its reporting requirements, the bill enables the state to understand the risk profile of the healthcare ecosystem in delivering patient care. This risk profile could be used to inform state emergency preparedness planning priorities, as well as future rulemaking. And finally, a strength of the bill is that in its requirements and in the way in which it works, it borrows broadly from the state's Critical Infrastructure Cybersecurity Act of 2023, which concerns PSC oversight of the cybersecurity of the entities that it regulates. The lessons learned and the compromises reached within that rulemaking could benefit the implementation of this bill. And finally, I'll just mention that one of the reasons, other than the kind of the unique focus on the ecosystem as a whole for this bill, is that the current standards in place are not, federal standards are not adequate. That's why HHS has a new cybersecurity rule out that would raise the bar on the cybersecurity of covered entities. So thank you for the opportunity to testify.
Thank you for your testimony. Do I have any questions for this witness? Seeing none, that ends the bill hearing on that bill. And now we're going to move to Senate Bill 936. Again, Senator Hester, Consumer Protection, High-Risk Artificial Intelligence Developer and Deployer Requirements. Senator Hester, are you bringing up Donna Edwards, Crystal Weiss, Grace Gedge, Care Williams, and Eric Knoll?
Madam Chair,
Yes.
after my testimony, my first panelist is online and he's got to go. Could he go first?
Sure.
Okay,
sure.
fabulous.
Is that
Dr. Yes.
Say the name.
I can't get on my glasses. It's Dr. Suresh.
Dr. Suresh. Okay. Doctor, would you like to go first? I understand you have to depart, so unmute and give us your testimony, please.
Thank you. I appreciate the time and being able to jump ahead. I appreciate that. Shall I just start with my remarks then?
Please start. Yes, sir.
Okay. So I'd like to thank Senators Hester, Guile, and Love for giving me the opportunity to testify here today in an informational capacity on SB 0936. I'm a professor of computer science at Brown University, interim director of Brown's Data Science Institute, and the director of the Center for Tech Responsibility. I've spent over a decade researching the impacts of automated decision-making systems in society. Most recently, I served as an AI policy advisor in the Office of Science and Technology Policy in the Biden administration, where I co-authored the blueprint for an AI Bill of Rights. The blueprint itself was born from a recognition that automated decision-making systems, ADMs, are being used in virtually every place where people's rights, opportunities, and access to services are at stake: housing, credit, employment, insurance, education, child welfare, unemployment services, clinical treatments, diagnostic tools, surveillance, criminal justice. The list really goes on and on. And over a decade or more of scientific research and dogged journalism has shown conclusively that ADMs, when implemented without protections for consumers, will be ineffective, harmful, discriminatory, opaque, and unaccountable. And they will compromise consumer privacy, dignity, and autonomy. And that's why the Biden administration put out the blueprint, to articulate rights that we should all have in a world increasingly run by AI, and why it issued an executive order and detailed technical guidance on the responsible deployment of AI. While the administration may have changed, science has not. Our need for protection from the deployment of ineffective, discriminatory, and opaque automated decision-making systems remains critically important. And even more than before, we need rigorous requirements for testing and evaluating these systems. We need independent entities who evaluate or provide oversight to these testing regimes, just like we do for other critical technologies. And we need to acknowledge the fast-moving pace of tech development by focusing our attention on the point of impact, where the consequences of unguarded tech affect people's lives rather than on technology itself. I conclude my remarks. I thank you for your attention.
Thank you, Doctor, for your comments. Do I have any questions for the doctor so he can leave? Thank you. Thank you very much.
Thank you very much.
Senator Hester, would you like to do your presentation?
Yes, thank you so much. And thank you, Dr. Strash. Appreciate you. Madam Chair, Vice Chair Hayes, members of the committee, once again for the record, Senator Katie Fry Hester here to present Senate Bill 936, Consumer Protection for High-Risk Artificial Intelligence Systems. This legislation is essential to safeguarding Maryland residents as we navigate this rapidly emerging technology. As you know, artificial intelligence is increasingly automating key aspects of hiring, employment, and financial decisions, often with little transparency or oversight. And this leaves consumers vulnerable to bias, error, and privacy breaches. The consequences of unregulated artificial intelligence are already evident across the country. I wanted to point to you, somewhere in your testimony, you should have this article, which talks about Michigan and the Midas unemployment claims system, which falsely accused over 34,000 individuals of fraud due to a lack of human oversight, with estimated damages approaching $100 million. It's critical that government benefits are not biased in this way. Luckily, last year, we passed Senate Bill 818, which made sure that each and every agency in the state of Maryland is testing the artificial intelligence that we use. In the private sector, there are a number of other examples where AI has found to systematically discriminate against different applicants. I'll point you to another piece of my testimony. There's like a one-pager which gives several examples. There's an example of racial bias where ProPublica's investigation into the Compass risk assessment tool revealed significant racial bias in its predictions. I mentioned the government benefits. In terms of employment, Amazon has developed an AI-powered recruiting tool that intended to streamline the hiring process. However, the system was biased against women. There's also an example of Tammy Dobbs of Idaho, who lost her Medicaid services due to an AI error. And Robert Gomez, who was a small business, was deranked on a major e-commerce platform. And Robert Williams, who was falsely arrested based on AI-driven misinformation. So what does this bill do? Because these cases are just the tip of the iceberg, this highlighting the urgent need for regulation. Senate Bill 936 accomplishes these safeguards in 3 specific ways. Luckily, this committee passed really comprehensive data privacy legislation last year, so you're up to speed on most of the definitions in the first 9 pages. The first thing that the bill does, it establishes developer responsibilities. Developers must exercise reasonable care to prevent known and foreseeable algorithmic discrimination. Developers must provide deployers with necessary disclosures around the AI system's capabilities, limitations, and potential risks. They must make available documentation and information required to conduct impact assessments. The next part of the bill sets out the obligations for AI deployers. AI deployers must establish and maintain a risk management policy and program for each high-risk AI system that they use. They must conduct impact assessments to evaluate the AI system's effects on consumers, particularly concerning algorithmic discrimination. They must inform consumers when a high-risk AI system is used in a consequential decision that affects them. And they must provide mechanisms for consumers to correct information and appeal decisions made by AI systems. The last part of the bill concerns enforcement and consumer rights. The Maryland Attorney General is authorized to enforce compliance with the Act. Consumers also have the right to bring civil actions against deployers for violations, seeking remedies for harms caused by noncompliance. Colleagues, for the past 2 years, I've served on the steering committee on the multi-state AI policymaker working group, which needs a new name. But we're a bipartisan coalition of over 200 state lawmakers in more than 45 states who are dedicated to developing a shared understanding of these emerging technologies. During the interim, the working group facilitated discussions on consumer protection legislation with various models that are now being introduced and implemented. The first one to pass was Colorado. Virginia has also just passed. Connecticut is pending, New York is pending, Massachusetts is pending, and Texas is pending. The draft as introduced most closely followed the model established with Virginia. However, I'm committed to working with consumer rights and labor organizations to strengthen the bill, and my chief of staff has just passed around an amended red line copy. Maryland has already demonstrated strong leadership in consumer protection with the passage of the Maryland Online Data Privacy Act and the Maryland Kids Codes. Additionally, as I mentioned last year, we passed Senate Bill 818, which requires the state agencies to conduct impact assessments for new safety impacting and rights impacting systems. Senate Bill 936 builds on this strong foundation, ensuring that AI-driven technologies operate fairly and transparently, safeguarding Marylanders from dangers of bias and misuse. Now is the time to act, colleagues, before these risks become real harm for Maryland residents. SB 936 positions our state as a leader in AI legislation, ensuring we remain ahead of the curve in consumer protection. Furthermore, given the uncertainty at the federal level and the number of federal contractors that this bill could apply to, I think it's very timely that we pass Senate Bill 936, and I request a favorable report on Senate Bill 936. Thank you so much.
Good afternoon. I'm Donna Edwards. Hello, Madam Chair, Mr. Vice Chair, and members of the committee. I'm president of the Maryland State and D.C. AFL-CIO. I want to commend the sponsor and the co-sponsors for the work that they have done on this bill. And we had a testimony that is support with amendments, but the new draft has adopted most of those. And I just want to let you know, I mean, you're probably saying, well, what are we doing with AI? Well, AI is extremely important because for the rest of our lives and the children's lives and everybody else, AI is going to impact every aspect of that. And so this has been a major issue for the AFL-CIO at the national level. I work with several of the states that have this legislation pending. At the national level, our experts are out there talking with the Labor Caucus, the coalition of state legislators who are working on this. So we're very, very deep in the woods on this subject. I have to make things simple so that I understand it. And for me, AI, basically, it is not intelligence. It is a statistical probability machine. And the easiest way for me to understand it is to say that it could have started as Jones and Sons, and then it became Jones Jr. and Sons, and now it's Jones III and Daughters. And the daughters want to hire more women, more people from diverse backgrounds. And so they're going to use AI to evaluate the people who are applying for the job. However, the system is going to draw down the history of what we've been doing. And it is going to be biased towards the white men who were Jones and Jones Jr.'s employees and kick out some very valuable people who could help. So what we are saying is that we need transparency, we need accountability, and we need impartial evaluation from independent auditors in these systems. Please pass Senate Bill 936. Thank you.
Hi. Good afternoon. Thank you for the opportunity to speak. My name is Crystal Wise. I'm the Innovation Policy and Program Manager for the AFL-CIO Technology Institute, and I'm also a Maryland resident. The Tech Institute is a nonpartisan organization that's affiliated with the AFL-CIO, which is a federation of 63 unions that represent more than 15 million workers across the country. We provide workers with a voice in technological developments, including artificial intelligence. We appreciate all the work that's been done by Senator Katie Frey-Hester to stand up AI guardrails in Maryland. We know that the AI industry is rapidly transforming all parts of our lives, but in particular workplaces. And right now, workers are unprotected from surveillance, from privacy invasions, and from discrimination, and from the erosion of labor rights. These immediate threats of unregulated AI are very real in the everyday lives of workers. So as a labor movement, we're looking for strong protections against discrimination and bias. We need transparency so that workers and consumers know when and how companies are using AI to make key decisions about them. We need provisions for Maryland as a government, as an employer and deployer of AI, and we need strong, robust accountability and enforcement. We're very grateful for the recent inclusion of many of these principles in the new amendments for Maryland SB 936. As introduced, there were a number of loopholes and problems with definitions, but the amendments close those loopholes and that would have left consumers and workers vulnerable to harm. We're happy to support these strengthened protections against the harms of AI. Thank you for your time and consideration, and welcome any questions going forward.
Thank you. Who's next? Thank you.
I'll go next. Thank you, Madam Chair, Vice Chair, members of the committee, for allowing me to testify on SB 936. My name is Eric Null. I am the co-director of the Privacy and Data Program at the Center for Democracy and Technology, a 30-year-old civil society organization based in DC that's focused on advancing civil rights and civil liberties in the digital age. We greatly appreciate the effort that Senators Hester, Guile, and Love have put into crafting SB 936, and we're generally supportive of the transparency provisions in the bill and understand that many of the provisions that we had identified as issues have been fixed in the updated version, which obviously is very welcome, and because there were several loopholes and exemptions that would have undermined the bill's goals and would have allowed companies to essentially opt themselves out of complying with the law. And this concern is not hypothetical. We saw exactly this play out in New York City, where they passed an AI hiring ordinance that companies have essentially ignored. AI systems that are biased or that unfairly withhold benefits from people are not the types of AI that Maryland should be investing in. People are increasingly subject to AI-informed decisions around hiring, salary, healthcare benefits, lending, housing, all sorts of important areas that make or break people's livelihoods. While the AI used in these circumstances may improve efficiency for the companies involved, the harms related to these decisions can be severe. Instead, it is better to invest in AI systems that are transparent and that protect against the bias that we've long come to recognize as significantly harmful. In other words, we should be investing in responsible, rights-respecting AI. Most of my issues have actually already been addressed, and so I think I'll just leave with we're happy to continue working on these issues with the committee and with the senators. Thank you very much.
Good afternoon, Chair, Vice Chair, and honorable members of the committee. My name is Grace Getty, and I'm a policy analyst at Consumer Reports, where I focus on artificial intelligence and consumer protection issues. Consumer Reports is a nonpartisan nonprofit with 6 million members across the U.S. I'm here to urge the committee to give the bill a favorable report with amendments. This bill is focused on a critically important issue, ensuring that AI systems used in high-stakes decisions about Marylanders are transparent, free of bias, and that residents have some autonomy and recourse. Despite companies' best efforts to keep under lock and key information about how predictive AI systems work, or for that matter, don't work, a steady stream of research and testimony from experts suggests that these products can bake in bias, be error-prone, or simply be snake oil. One resume screening program, for example, identified 2 factors as the best predictors of future job performance: having played lacrosse and being named Jared. A healthcare algorithm used widely by hospitals to identify which patients would receive additional care was found by independent researchers to be biased against Black patients. Why was this? In attempting to predict which patients would become the sickest, it instead predicted who would spend the most money on care. This bill helps address those issues and covers the use of high-risk AI in high-stakes decisions over who gets access to education, employment opportunities, financial lending services, housing, insurance, and more. I'm very pleased to see the amendments that Senator Hester brought today. They're very sensible, and they address many of the issues that my colleagues at this table has already mentioned. With the amendments, this bill could act as an essential patch for Maryland's existing civil rights and consumer protection laws in the AI era. While these existing laws clearly apply to AI products, the black box nature of these systems and their ability to partially stand in for humans with intent can make cases difficult to bring in practice. I'm so grateful to Senator Hester's leadership on this front, and as she mentioned, many other states are considering similar bills. To just name a few: Colorado, Virginia, New Mexico, California, Vermont, Connecticut, New York, Texas, Pennsylvania, Nebraska, Ohio, Massachusetts, and there may be others. Thank you. I look forward to answering any questions.
Thank you. And Kara, you're the last witness.
Yes. Thank you, Madam Chair, Vice Chair, and members of the committee. And thank you to Senator Hester for her leadership on this issue. My name is Kara Williams, and I am an attorney at the Electronic Privacy Information Center, or EPIC. EPIC is an independent, nonpartisan nonprofit founded 30 years ago to secure the fundamental right to privacy in the digital age. EPIC has worked closely with state lawmakers, including many from Maryland, on tech issues for years. I'm here today to support SB 936 with the amendments that Senator Hester is presenting here today. This bill tackles an urgent problem. As you've heard already today, companies across sectors use AI systems every day to make important decisions about our lives. Whether we get a job or admission into a university, if we qualify for a mortgage or for a loan, how much we pay for rent or insurance, and whether we can access healthcare or government services. Right now, Maryland residents have no way to know whether companies use AI in making these decisions about them or how these AI systems work. SB 936 aims to address these problems, but unfortunately, the version as introduced would do little to protect Marylanders. As introduced, it is full of loopholes that would allow companies to decide for themselves whether or not to comply with its requirements. Fortunately, Senator Hester has been working closely with numerous stakeholders to craft a solution that is right for Maryland. The amendments she is presenting today would make SB 936 a strong bill that EPIC would be proud to support. These amendments will require real transparency from developers and deployers about the AI systems they build and use, and protect Marylanders from algorithmic discrimination. The risks of relying on AI systems to make important decisions about people's lives are real, and people are being harmed every day by the unregulated use of this technology. SB 936, as amended, would be a welcome step toward mitigating those risks. Thank you for this opportunity to testify today, and I'm happy to answer questions.
Thank you. I just have one question. You all testify favorable with amendments, all the same amendment, the bill that Senator Hester has now brought us as amended? I just want to make sure it wasn't all different.
Yes.
Thank you very much. Senator Hershey?
Thank you very much, Madam Chair. And Senator Hester, certainly want to appreciate your work on the National Multi-State AI Policymaker Working Group. So, and I do think that almost everybody wants to see some type of regulation, especially on this so-called defined high-risk AI. But in reading some of the other letters that have been submitted, TechNet talks about wanting to advocate for a federal IA framework that brings uniformity to all Americans, regardless of where they live, encourages innovation, and ensures that consumers are protected. What are your thoughts on letting the feds take the lead on this?
I would like to wish TechNet the best of luck with Elon Musk. I mean, I think one of the reasons we founded the multi-state AI working group is because we heard from the commercial sector about the scattered approach to data privacy. And so we wanted to fast track this. So all the states were working together to try to pass similar legislation across the United States. And I think that we've done a pretty good job at that. It's not perfect trying to coordinate across 50 states. But I mean, it would be ideal if the United States would pass something like the EU AI Act. The last time I checked, I believe the blueprint for AI, which was in the OMB guidance that the Biden administration had done, is all taken down. I mean, if you read the tea leaves, with the loss of federal workers, I mean, who's going to do the work? I think it's going to be artificial intelligence. Do you think that there's going to be the right checks on those pieces of AI that the federal government's using? Well, maybe if they outsource it to federal contractors, we can at least, have this remiss. But it would be ideal, absolutely, Senator Hershey, to have federal legislation. I don't see it happening in the next 4 years.
Okay, so then we're back to state by state.
State by state, but with a coordinated approach. We have been really working hard for the past 2 years, and maybe some of my other colleagues here could attest to some of the similarities between all the bills.
Okay, then I'll ask consumer protections. Is that okay? Sorry. There's a letter from Maryland Tech Council that is somewhat similar. Wants to make sure that there's no conflict with federal definitions. Wants to strive for consistency with other states to not have a patchwork of laws from state to state. A lot of states have been mentioned that there is something pending. I would assume that Maryland is now pending, or is that, so that's what pending status is, something's been introduced, okay. What we know so far, Virginia's passed, correct, Virginia's been passed, although
Through the
there's
legislature.
conversations of vetoes in Virginia, apparently at the time. Colorado seems to be really the one has gone the furthest, right? That has been passed. I think they've also passed a work group as well. We know that there's a similar work group that's been introduced in the House. Tell us about what Colorado's done. If you could.
Sure, and actually I'm on that working group, so I'm happy to speak to that. Yes, so Colorado passed this into law. It's going into effect. It's going into effect, I believe, this summer of 2026. I need to look back at the bill, but it's definitely happening. And so for the folks who are particularly concerned about interoperability, looking at what Colorado is going to do is a great start. I think, we really saw the tech lobby turn out against hard on that bill, and I think that's part of the reason there's been such a kerfuffle about trying to get amendments made after it's been passed. Maybe there will be amendments. It's hard to know at this point.
Right. But Colorado hasn't implemented yet, so it will be implemented. Is the task force recommendations going to come out before they implement, or how is that going to work?
The task force is officially concluded, and now the Senate Majority Leader and the sponsor of the bill is weighing what he would like to do.
Okay, so I'm clear. The task force, they were both passed together, but the task force has completed its studies making recommendations prior to the implementation of the law.
Yes, conversations are ongoing, though, among stakeholders.
Thank you. Real quick, where am I looking? Ms. Weiss, right? Sorry, talking about. Going back to now talking about multiple states, Colorado taking the lead. What was introduced was very similar to what Virginia passed. Now there's a series of amendments that brought everybody on board with it. Can you just tell me how these amendments might differ?
I'm gonna pass to President Edwards.
Ms. Edwards, yeah. Can you just tell me how these?
I'm usually the person you favor in asking these questions.
You're always my first one that I usually ask.
I know.
But,
no, I will explain. The amendments that we did from my office were really created by Elizabeth Bobo, the legislative director of my office. And she did side-by-side screens of the New York bill, the Massachusetts bill, the Colorado bill, and the Virginia bill, because we had a lot of our questions and also information that we had from the AFL-CIO, and the amendments put together the best possible accountability, transparency, and trying to audit to make sure that we could create non-biased systems here, AI. And so that is the very important part. There were a lot of loopholes in the Virginia bill, a lot of loopholes that would harm consumers and workers. So we've looked at that, and well, I'm just letting you know that this is a combination of 4 or 5 states' legislation and best practices.
Well, that's what's
from our amendments.
Understand, and that's what's getting to be now a little bit concerning, is that we did have something from Colorado, we did have something Virginia to take a look at that I think a lot of the different industries have been able to take a look at, and now we're coming in with your organization saying that we need to even strengthen it further, is what you're saying, right?
No, when you say industries, you mean people who are trying to sell the products. That's fine, but I'm talking about the millions of workers and consumers that it's going to impact, who have a huge part of the need to have you all provide the guardrails.
Could too much regulation leave not enough room for innovation?
No.
You sure?
Not in this. No.
Why is that?
Why would
if
it
you
be? Too much
over-regulate
regulation.
it, you can't. You don't think you'll stifle innovation?
Do you really want to not have the regulation that would then harm somebody for the rest of their lives? And I found it really interesting, even the task force that's proposed over in the House, the first 2 of the goals have to do with employment and livelihood, but there was no representatives from labor even on the task force.
Well, I'm trying to think why Maryland has such unique problems that the other states haven't.
We're not saying the other ones don't have problems.
You're saying that the other states that have passed the legislation that has broadly been considered model legislation by a number of different groups has not been strong enough with respect to your concerns.
Not strong enough for workers and consumers.
Okay.
Yes, Colorado was written by the industry. Virginia was influenced by the industry. And we have concerns and probably will come back to strengthen those. Why shouldn't Maryland try to get everybody, all stakeholders, and do the better on behalf of the majority of the people that are going to be affected for the rest of their lives?
Well, you and I can converse all day long, I think, on
Yes,
a number
we
of
can,
things,
can't we?
Ms.
Yeah.
Edwards. But I do think that we have to be a little cognizant of how far we do go outside of what other states have looked at if we're going to try to get something that's somewhat consistent. Now, that's not to say that Maryland couldn't go further, but I think that we would have a lot more pushback in trying to do something that is reflective of the amended bill rather than the bill that was originally presented.
Well, you're considering Virginia and Colorado. We considered also Massachusetts and New York and other states.
But they're not. Okay. Senator Hester, just final question, and I know you want to add a little bit more as well too, but obviously there is a bill in the House that talks about a work group and being implemented. Just from your perspective, can both bills be passed together? If we decided that with the pages and pages and pages and pages of amendments that are here, not just from AFL-CIO, but also from the industry as well, would we be better off taking a look at passing the bill that deals with the work group and then getting back and trying to work on this bill with respect to the issues and the comments that they bring forward?
I'll answer your question, but I'd like to start by just drawing the committee's attention to what a consequential decision is. Like, we're not talking about like video games here. We're talking about parole, probation, pardons, education enrollment, access to the provision of employment, financial and lending decisions, access to health care services, housing, insurance, marital status, legal status, and access to government benefits. Those are high-risk decisions, and I do not think that we need a work group to know that we need to not have bias in those high-risk decisions. In the House, there are two bills. There is the work group bill, which is loaded with industry members and doesn't have any labor on it at all. And there is also a bill by Delegate Chi, which is the Colorado model, which is very close to where this is. It's been hard because we all operate in condensed sessions. But when I first introduced the Virginia mill, it wasn't this at the same point that they were at, right? So it's hard for us all to be exactly the same. But you think about the basic principles. All of these states are asking for the basic principles of transparency, accountability, the right to have a human in the loop when you are making a decision about parole, probation, lending, employment, housing, healthcare, and your government benefits. I personally do not want some random algorithm to make a decision about my benefits. I want there to be a person who I can call and ask a question and say, hey, you are discriminating against me.
Thank you. Thank you, Madam Chair.
Senator Kyle?
Yeah, thank you very much, Madam Chair. And thank you, everyone, for your testimony and your work, especially you, Senator Hester, on this important issue. I have a few questions. I wanted to first ask Ms. Weiss if you could help us understand, because I know we have representatives from labor here, what impact does AI have on workers?
Thank you for that question. So AI impacts workers in many ways. Broadly, it can directly harm their civil rights. So we know that AI, especially algorithmic decision-making systems, are biased against women. We've heard examples about that. It's biased against workers with disabilities. It's often proven to be biased against workers of colors. So when we look at how AI can impact workers, it doesn't just impact recruitment and whether or not you get a job, but it can also impact, do you keep that job, how you're monitored, how you're disciplined, if you're promoted. So it impacts a worker's ability to earn a family-sustaining wage, which is what we want for all of Marylanders, right? And so and I think to better like understand, because sometimes it seemed like the tech industry will have us feel like, oh, well, we can't possibly understand this technology. It's too complicated. It's not that complicated. So I want to break down two ways that bias can enter a system. And because I think if you understand why the bias happens, then it's easier to understand why we need this legislation that regulates the transparency around it so we can spot it, stop it, or fix it if it happens. So there's two kinds of ways that bias can happen, right? And the first is data bias. So essentially, it's what President Edwards talked about. We have these databases of what's happened historically. Data is not neutral. It's a record of what's happened. And we know that there's already all kinds of systemic injustices and discrimination that happen in our society. So then when you put those into a system, algorithmic decision-making can exacerbate and make all those inequalities worse across all the different protected classes. The other thing that happens is these systems don't just spawn out of nowhere. They're designed by an engineer. They're designed by a human. So the way that they are created, whether intentional or not, can also be biased. So we have these very imperfect systems impacting our lives in very real, huge, important ways, especially in the workplace, whether you get a job, whether you keep your job, whether you earn enough to keep your lights on and keep food on the table and to pay your bills. So it is absolutely essential that we just have some basic ground rules around transparency. A lot of this is about transparency. What are you doing? How are you doing it? If there's a problem, how do we fix it? So it's essential that workers have that. Thank you for your question.
Yeah, thank you very much. And then more, I guess, broadly for the rest of the panel, I mean, we already have existing civil rights laws. We already have existing consumer protection laws. Why is it necessary to have an algorithmic discrimination bill on top of what we already have?
Thank you for your question, Senator. You're right. Of course, we already have civil rights laws and consumer protection laws, but this bill provides important transparency requirements that Maryland residents need in order to enforce their existing rights under these laws. For example, people can only bring an algorithmic discrimination claim if they know that an AI tool has been used in making the decision about them. Right now, without this bill, Maryland residents have no way to know whether a tool was used on them. Second, AI is often, I'm sure you've all heard, referred to as a black box, but this bill, with its transparency requirements, will allow consumers and workers to have essentially a peek behind the curtain to figure out why the system produced whatever recommendation or decision it did, and the individual who was harmed by a discriminatory tool can use that information to back up their perhaps a discrimination claim under an existing Maryland civil rights law. So it gives consumers and workers, this bill would give consumers and workers the information they need to successfully defend their rights under other existing legislation.
Okay, and following up on that, and I guess this is thank you for your response, doesn't necessarily be for anybody else on the panel. And I know Senator Hester just gave a list of, how the broad areas where this might impact it, but I don't know if you can help us with some other real world harm examples. I don't know who else may be able to give us that.
Yeah, I'm happy to hop in here, and I'm sure every panelist has some good examples that are in their mind. One that I can think of, there was an article, it might have been from CBS, about a gentleman who had Navy-level security clearance, applied for a housing unit, wasn't at all concerned about the background check because he's undergone a very extensive background check. And yet was denied from the apartment due to failing the background check. It later came out that the algorithmic system that conducted the background check confused him with someone else who had a similar name, similar looking name, and who had a criminal record. And so that was just a straight up error. And luckily it came to light. But there are errors like this, we don't know how often algorithmic systems are making errors like this, but a lot of data is being scraped off the internet and some of that data is erroneous. And so this bill would, in that situation, make that error discoverable to the consumer. They would get the explanation. They might spot there's been an issue. It would give them the right to correct, and it would give them the right to appeal the decision.
Okay, thank you. And I know Senator Hershey had asked some questions about to Ms. Edwards about whether this might stifle, whether regulations such as this might stifle innovation. I'm wondering if anybody else wanted to also respond to that, and whether we should wait for AI to develop more before we regulate.
Good question.
Thank you. Yes, thank you very much for the question. So what I sort of mentioned in my opening statement was like, we don't just want innovation for innovation's sake. Like, we as a society have decided that we don't want certain products or services to be discriminatory or to be completely hidden in the shadows so people don't know anything about what's happening to them. We've seen similar requirements to provide information if you've been given a denial, like under the Fair Credit Reporting Act that was from the 70s. And so, we're trying to ensure that it's responsible, rights-respecting innovation that will actually work for everybody and not just for certain populations.
Okay, thank you. Thank you very much, Madam Chair.
Thank you. Senator Ellis.
Yeah, thank you, Madam Chair, and thank you, Senator Hester, again, for this bill. And the question, should we wait for AI to develop to really start regulating, but we were stifling regulation? So, quick story of over 40 years ago, I graduated from University of Maryland, commissioned in the Air Force, an Air Force officer, and thrust into the technology world and worked with stuff that was very advanced. I was doing stuff on the internet before it was public, right? It was the DARPA Defense Advanced Research Project Agency Network, communication system between the university, research universities and federal government research. And so we have a new term called AI, but what we're doing is absolutely nothing new. It's been reincarnated, new terminologies as we go along. So this industry is really mature. But it's doing some scary stuff as a mature industry that's really innovating and getting so much more advanced. But one thing holds true. They taught us early on. I was trained by one of my trainers was a lady named Admiral Harper. She stayed in active duty for many, many years. There was 60 Minutes special about her, Grace Hopper. And she was one of my mentors and instructors, legendary. Person in IT and DOD and for the nation. And one thing she said, remember, young officers, garbage in, garbage out. You put garbage in that system, it'll spit out garbage. And we have a lot of people now putting garbage in the system. For instance, you go into the airport and you get your facial scan, especially if you have coming back into the country from overseas, you do the global entry. Some people always get rejected because the program is not programmed for their complexion or for their pretty much facial features. And that's been a problem, and they've been working on it with the federal government to fix that. But that's individuals who wrote that program put garbage in. They think everybody was like them, right? And they only did checks on people like them. And so they produce the garbage. I believe this bill will kind of put a check on that and make sure that the people who want to just put garbage into the systems that affect our lives are basically regulated. And so other states are doing this. I know, Ms. Edwards, you are at a lot of these conferences, NCSL, working hard, listening, participating. And a lot of things we do, are we basically out there by ourselves, or we're working together to kind of get something that's similar to really address this issue because Congress is not addressing it? Ms. Edwards, what's your...
I can say from all of the groups, because the AFL-CIO works with a lot of stakeholders in the AI industry, not necessarily allowing the industry to lead it, but I think it's unfair to just say, well, Colorado passed it in Virginia, so let's just use those. Because what the sponsor has done, she's part of a national group that is looking at where it's pending. And each time you're getting better with it. So no, I think first off, we can't wait. This is very, very important. It's not like we want to be ahead of it. Right now, we'd like to just run beside it you know, because it is moving so fast. And we cannot depend on the federal government and Musk to come up with what he wants, because all of our data he wants. So not even our industry that wants to develop different systems is going to have any control over that. You can set up, you, the legislature, what is going to be the guardrails in Maryland to protect the millions that live in Maryland, the consumers and the workers. This is your chance to do that. And we don't base it on, well, somebody else passed something. Okay. We base it on what's the best out there. And this is taking from all of our experience and putting it in to an extraordinary product, I believe. Yeah. And there's still work to be done on it. It's not done. You all have the ability to work with the sponsor. Okay. So thank you.
Thank you. Thank you for that.
Senator Mouse.
Very quick, I apologize. It'll be very quick. And this is for the sponsor, just to clarify, because I've been in and out and running around. How would this apply to existing AI? Would it be retroactively, so existing AI would have to come in compliance?
That is a good question. At the state level, it was new AI starting in February of this year going forward, and now we're starting to look back because it takes a little longer. But maybe you could answer this question?
Just a quick answer, besides this going on for a while.
Yes. It gives, I forget the exact timeline right now, but it gives existing AI that is being used by deployers that would affect Maryland residents a certain window to come into compliance with the transparency and testing requirements.
So there's a window,
it's like
but it would have to come into compliance.
I want to say 6 months, but I don't want to be wrong. So there's a number of days.
Thank you.
Mm-hmm.
Thank you, Senator. I'm not trying to rush it, but it's 5 of 5. We still have the rest of this panel, another bill, and voting. So unless we want to spend the night together. Okay, I see no other questions for this panel. Thank you all very much for the
Thank you very much.
Thank you.
Thank you, Mr. Vice Chair.
Next, we have Matthew Kilbane, Kelly Schultz, Hannah Abrams, and Russell Harris.
Good work. Good work.
And I have you all 4 of you, as favorable with amendments. Do you want to start?
Yes, ma'am. First off, good afternoon, Madam Chairman, and everyone else. Thank you very much for your time here today. My name is Matthew Kilbane. I am a seasoned professional with over 2 decades of distinguished service in the United States Army as a non-commissioned officer and commissioned officer in the Ordnance Corps. I have over 7 years with the Department of Homeland Security and years with multiple Fortune 250 companies. With a robust background in AI governance, technology business management, and IT program leadership, I'm an Azure AI engineer with an MBA and advanced certifications from MIT, the University of Geneva, the United Nations Staff College, and the United Nations Institute for Training and Research, among others. I'm adept at building and leading high-performing teams, and I currently serve as the Director of Legislation for the Maryland Veterans Chamber of Commerce. I am a small business owner, and I am the chairman on the Subcommittee of Governance and Technology for Maryland District 4, Glen Ivy, for the U.S. House of Representatives. We support the proposed legislation with amendments, and as the legislative director for the Maryland Veterans Chamber of Commerce, I advocate for policies that protect our citizens and promote the ethical use of technology. The inclusion of consumer protections in the legal and regulatory framework is a crucial step in ensuring that our laws keep pace with technological advancements. Laws and legislations normally advance linearly. Technology advances exponentially. AI technology has the potential to create realistic images, text, and video that can be misused, making it essential to update our legal definitions to encompass these new forms of media and prevent exploitation. Moreover, the lack of comprehensive AI legislation in the state of Maryland is detrimental to both our citizens and businesses. The absence of clear guidelines and regulations creates uncertainty and poses risks to privacy, security, and ethical standards. Maryland should create a strong regulatory agency, the Maryland AI Regulatory Agency, or MARA, to govern responsible AI development and operations by following principles outlined in other regions and with other organizations. An active and engaged regulatory body is necessary to enforce transparency, accountability, and fairness in the development and deployment of AI technologies. Additionally, the agility present within the body of subject matter experts will allow the organization to mitigate future economic, social, and ethical upheaval that is on the horizon. Failure to act is a result of unchecked proliferation of AI applications that could harm individuals and erode public trust in technology, government, and our society. Thank you very much for your time, and I stand by for any questions you may have.
Thank you. Next we have Russell.
Good evening, everybody. Madam Chair, my name is Russell Harris. I'm testifying today because Maryland is a great state for software, AI-powered startups, and we need to keep it so. For the last 18 months, I've been an investment associate at Techstars, the acclaimed startup incubator that recently announced an AI health tech program partnered with Johns Hopkins University. My primary role was to review thousands of applications of companies that wanted to come and bring business to Baltimore, Maryland, and even incorporate there. Let me be clear. As a Black man, I care deeply about bias. I'm pleased that Maryland has strong anti-discrimination laws. Software should not make or substantially influence unlawful discriminatory decisions. But this bill does not prohibit discrimination. That is already unlawful. It's about thinking, evaluating, monitoring, documenting, disclosing, and doing it all again. The process and paperwork requirements are 4 pages long. The bill requires AI-powered decisions to have disclosures that have never previously been required for consequential decisions, even when software is involved. I fear the bill will benefit big law and consulting firms and drive startups and investors to other states. AI helps companies with 3 people compete against 300 or even 3,000. With AI capital-starved, minority-owned businesses can succeed in ways that's never been possible before. But if compliance requires there to be multiple employees to oversee evaluations, documentation, instead of building products at scale, investors will see that as another risk, and too much money will be going to compliance, and they'll invest elsewhere. AI developers and deployers use anti-bias, quality controls, and assurance practices because they result in better products. It's good for business, especially in regulated and consequential decision industries. But adding the risk of an attorney general investigation and private lawsuits for violations and documentation process laws, even in the absence of discrimination, seems unruly harsh. My written testimony includes suggestions for specific changes, and I'm happy to discuss them farther with you guys if you wish. Thank you for the opportunity to testify, and I'm available for questions.
Thank you. Next we have Kelly Schultz.
Thank you very much, Madam Chair, Mr. Vice Chair, members of the esteemed Finance Committee. For the record, I'm Kelly Schultz, CEO of the Maryland Tech Council. We are favorable with amendments on Senate Bill 936. And first, I do want to thank Senator Hester for all of her hard work that she has put into this particular issue and her leadership on this. I believe that there is a framework here that myself and my members feel we can work towards a different type of a product with some amendments. We do support the development and the ongoing conversations of this, particularly when we're talking about the regulation of high-risk AI. Last year, the Maryland Tech Council developed an artificial intelligence policy statement. It is included in your written testimony that contains a set of factors to be considered by policymakers and regulators when deliberating new efforts to govern their use of AI. We attached that to your written testimony along with our suggested amendments. We have sent this bill out to our members, and we have involved them at every stage of this process. We do have members that are the very large members, and we have very small members similar to what is happening at JHU. So the feedback that you have is representative of a very widespread group of members that have this. I just want to highlight a few key points here. Impact on small business. There will be an impact on small business with this, and we want to make sure that as we move forward and continue discussions on the appropriate regulation, that we take them into consideration. And I believe that the fiscal note cited that as well. We want to make sure, of course, as discussed on the last panel, that we align with other states. One of the hardest things about deployment of this effort will be those businesses doing business outside of the boundaries of Maryland. And then, of course, the enforcement. We do suggest giving enforcement authority exclusively to Attorney General, protection for required disclosures, and ensuring that the bill does not have private right of action. Thank you very much, Madam Chair.
Thank you, Kelly. And finally, Hannah.
Chair Beidel and committee members, my name is Hannah Abrams. I'm an Assistant Attorney General with the Office of the Attorney General Consumer Protection Division. There's a gap in existing discrimination law, and this bill attempts to address that gap by imposing obligations on developers to ensure that they're evaluating and mitigating potential harms that they're products might cause. The division supports SB 936, but urges the committee to consider several amendments, which are included in our written testimony. I'll mention just a few here. First, the rebuttable presumption should be removed. As written, there is a rebuttable presumption that developers and deployers are compliant with the law if they are compliant with the provisions of the law. You heard that correctly. It's circular and it creates duplicative enforcement work and delays resolution. As prosecutors, first we have to overcome the legal presumption that the company has complied by demonstrating that they are not compliant with the law. Once the presumption is overcome, we then have to prove the violation. Although much of the evidence is the same, going through the process twice lengthens the time to obtain consumer relief and expends unnecessary resources. A rebuttable presumption also undermines the intent of consumer protection laws, which are meant to safeguard consumers. Second, we recommend making a violation of the Consumer Protection Act. I do want to note that SB 936 will require extensive personnel and technological resources to properly investigate potential violations. The OAG needs appropriate resources to enforce SB 936. We currently do not have them. We urge a favorable report with the amendments discussed.
Hannah, any questions for this panel? Seeing no questions, we're going to go to a panel of unfavorables. Barbara Zechnick, Grayson Wiggins, Aidan Hizakas, and Marie Durkin. I'm sorry, Margaret Durkin. The hour's late. And everybody stayed. Aren't we lucky?
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. You have our written testimony, so I'll be quick. I just want to thank the sponsor for meeting with us prior to the hearing, and I do appreciate her solicitation of feedback through a portal that was due Tuesday. I know that a lot of our members submitted feedback in that portal. I received a long list of questions, concerns, and my understanding is that Colorado, the bill has not been implemented. Some other states are looking at this. Virginia has passed it, but the governor has not decided whether or not he's going to veto it. He also has line item veto authority in Virginia. And in Connecticut, actually just I think 24 hours ago, the governor's office publicly asked the Senate not to move the bill because of concerns with stifling innovation. The amendments and comments that our members submitted through the portal involve things like questions regarding disclosure requirements, both from developers to deployers and developers to consumers, the joint liability that may attach there, the optional safe harbor, private right of action. The bill seems to exempt government entities, and so there's a lot of, but also seemingly seeks to regulate certain federal entities. So there's some confusion there, and so we'd be happy to continue to work on this. I will note that we have not seen the amended version based on the text messages I was receiving while the proponents were testifying. I don't think my members have seen the amendments either, so I'm not sure that the industry changes or comments have been incorporated to this amended version of the bill, but we'd be certainly happy to continue the conversation. And I would just note that we supported Chairman Wilson's bill in the House, which is the work group that will bring stakeholders to the table to develop a sound regulatory framework for the state. Thank you.
Good evening, Barbara Zekchik here on behalf of the Security Industry Association in opposition. SIA is an international trade association representing the security industry. Our membership includes both deployers of the technology, businesses who are security providers who use AI, as well as AI developers themselves. I will first say that you are so lucky to get me instead of my clients today, because one of them is in Colorado, one is on the Hill, and one is in Connecticut. And you, my friends, have been deemed the most reasonable body that did not need the clients themselves. So thank you for that. I do want to thank the sponsor for being so willing to work with private sector industry on all of the technology issues that she works on, as well as the important work that she has done with other stakeholders across the country. That is not lost on us, and I actually said to her in the beginning of the session we might support this bill, so I do feel a little bad opposing now. However, at this juncture, at this time, Grayson has already highlighted where all of those other bills are now. This bill started as the Virginia bill. The Virginia bill, frankly, has gotten more, I have to be honest, industry friendly. They did just remove the private right of action in Virginia before they passed it. Based on the sponsor panel, it sounds like you're seeing amendments that go in the opposite direction. We're not looking at the exact same bills as these other states. It's a tremendously wonderful effort, but that's not where we're at. We are also in a position right now in Maryland, I don't have to tell you all, where we're going to need to rely on innovation and new businesses because our economy is going to need them. I will say, I know this is an issue that not everyone will agree upon. Our membership does not think this is an absolutely real issue right now with very immediate harm. This, it has been said earlier, this has been coming for some time. This is in use now. This isn't like cybersecurity where we need to do something immediately. We think there's time for a work group, and we support that as well. Thank you.
Thank you, Barbara.
Aiden, thank you. Good afternoon, Chair Beidel and members of the committee. My name is Aiden Skass, and I serve as Policy Manager at Chamber of Progress. And on behalf of Chamber of Progress, a tech industry association supporting public policies to build a more inclusive society in which all people benefit from technological advances, I respectfully urge you for an unfavorable report for SB 936, which would stop Marylanders' budding innovative AI tech sector without meaningfully advancing civil rights. AI has tremendous potential for improving education, enabling creative expression, and creating new business opportunities. So it is critically important that public policy promotes the broad and equitable distribution of these innovations. My panels have already mentioned a lot of the other state bills, so I'll try to keep it short with some of the specific issues that we've been seeing. To start, SB 936, stifling of AI startups and innovation, is in direct contrast to the Moore Miller administration's 2025 economic growth agenda that seeks to bring tech industries and jobs, including AI, to Maryland to spur business growth and build an economy that works for everyone. Additionally, SB 936 will cost Maryland's AI market. We've included an economic analysis from Chamber of Progress in our submitted written testimony, but to summarize, the U.S. AI market is estimated to be worth $66.2 billion as of 2025. According to Superside, Maryland accounts for 2.5% of AI searches in the country. If we apply this percentage to the U.S. AI market, it comes to $1.66 billion. The costs for following rules and regulations, like those in SB 936, are estimated to be 17.22% of that amount, which means compliance costs in Maryland will be around $285 million. Every time the AI models are updated, another $285 million in compliance costs will be added. These recurring compliance costs are significant and could add up quickly, making operating AI-related businesses in Maryland more expensive. To summarize, we believe that innovators agree that bias is bad and have implemented practices. We have included specific languages in our written submitted testimony, and for these reasons, we respectfully urge you to oppose and provide an unfavorable report for SB 936. Thank you.
Margaret?
Good evening, Chair Beidel and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet. Thank you for allowing me the opportunity to speak today on Senate Bill 936 related to high-risk artificial intelligence. Our members are committed to responsible AI development and use, and we appreciate the sponsor sitting down with TechNet a few weeks ago while I was in Annapolis to discuss some of our broad concerns of this bill as drafted. I just received the amendments that the favorable panel was referencing, so I haven't had a chance to fully review that, but I will review that with members and get back to the committee if anything has changed. You'll see substantial comments in my written remarks, which were submitted to the committee, and I wanted to comment on some of the things that have been brought up by prior speakers, specifically the Colorado bill. Yes, Colorado did pass a bill. However, from introduction to passage last year in 2024, those dates were April 10th to May 8th. So as you can see, it is less than a month of deliberation, and they didn't have any stakeholder meetings before the first committee meeting. So when TechNet and other industries participated in that process, their first comments were brought forth at that first committee meeting after April 10th. and the bill ultimately went to the governor on May 8th. In terms of what TechNet does support, we support work groups to study artificial intelligence, and we were happy to support the AI workgroup bill in the House, and we believe that that is an important first step for evaluating these complex issues because it gives legislators and other stakeholders the opportunity for a thoughtful approach to a very complex set of issues. Again, I will reference my written remarks for our specific comments, and I'm happy to take any questions. In conclusion, we ask this committee for an unfavorable report on Senate Bill 936. Thank you.
Thank you. Do I have any questions for this panel? Seeing no questions, thank you all for your testimony. That ends the hearing on Senate Bill 936. Next, we have Senate Bill 918, the last bill of the day. Senator Guile, your panels, Anna McCormack and Clifford Mitchell.
Good to see you too. Thanks for being here.
Hi, how are you?
All right. Good afternoon, evening, colleagues, Madam Chair, Mr. Vice Chair. So for the record, Senator Don Guile here to present Senate Bill 918. Senate Bill 918 is very similar to a bill that we heard last year. I'm going to let the Office of the Attorney General explain a little bit on how it's different. But basically, this bill would require all businesses that manufacture, distribute, or sell electronic smoking devices or vape products in Maryland obtain a specific electronic smoking devices license, eliminating the existing license exemption that exists for businesses that sell cigarettes or other tobacco products. Removing this exception will allow the state to better know who is doing ESD business or electronic smoking device business in Maryland and aiding the state's ability to enforce the law. Just to sort of like set the stage, I mean, there's a lot of different products, various vape products that are on the market now. And I think we've talked a lot about this committee, some concerns about how a lot of these products are targeted to minors, whether it be flavored type products or they may be marketed a lot of times I've heard looking like a highlighter pen, so kids can like sneak these into their high school classrooms or look like a watch or something so they can use them. Obviously, this is really troubling. Vape products are the second largest nicotine product category after traditional combustible cigarettes for adult users, but for youth, vape use is higher than cigarettes. The 2022 Maryland High School Survey reports that while 3.2% of high school students smoke cigarettes, 14.3% of high school students use vape products. A national survey also confirms that in 2024, vapes are the most commonly used tobacco product among U.S. youth. I mean, you've all heard about how harmful that they can be. We're not necessarily opposed, if adults, these are legal products, I guess maybe it's not some of them, and I'll let the Office of Attorney General talk about that as well. But there's some concerns about what is currently on the market, and I think having a lot of more control on what is there will really help in seeing how a lot of these products are being marketed. This bill would require licensure for all these businesses, remove internet sales loopholes, and require license for distribution, improve inspection and referral authority, create a directory of these vape-type products, create an escrow fund for uncompensated costs of removal and disposal, improve penalties. It would also importantly create parallel structures that already exist for cigarettes. So there's already a registry right now for cigarettes that could be sold here in the state. So this would create parallel structures. From an enforcement perspective, I think as we heard about a little bit before from the chair's bill, Senate Bill 918 gives the ATCC express authority to conduct inspections of vape businesses, just as it does for traditional combustible cigarettes, and provides the Department of Health the ability to refer violations of the law to ATCC for further enforcement action. While the ATCC did not submit testimony on this bill, I can share that in speaking with them, their position on this bill is neutral. And for these reasons, I respectfully request a favorable report on Senate Bill 918. Maybe we'll turn it over to the Office of Attorney General. Madam Chair.
Thank you. Madam Chair, Vice Chair Hayes, and members of the committee, I thank you for your patience. I know it's late, and I wanted to thank Senator Guile for bringing this bill forward. And also, I wanted to just note that I see other senators here who have supported similar efforts in the past, and we greatly appreciate that. My name is Anna McCormick, and I'm an Assistant Attorney General in the Tobacco Enforcement Unit of the AG's office. Senate Bill 918 would significantly improve the laws for electronic smoking devices and enable the state to bring some much-needed oversight to this industry. It does this in two ways. It reforms the system for selling these products, and it creates a directory of legal products. First, Senate Bill 918 fixes a broken licensing system. It requires that all entities get an ESD license, eliminating the current license exemption that prevents the state from knowing who is selling ESDs. The bill requires all sales be made by and to businesses with Maryland ESD licenses, and for wholesalers to report their sales to the state so the state knows what ESDs are being sold and what volume of sales. It also eliminates the internet sales loophole that allows manufacturers to sell directly to consumers over the internet. The bill gives the ATCC authority to conduct inspections, just like it does for cigarettes, and to seize contraband products. Second, the bill would give the state oversight over ESDs by creating a directory. Manufacturers would apply to the Attorney General for approval before they could sell ESDs in Maryland. The AG would get information from applicants, including the marketing and advertising and product design, to evaluate whether the products are meant to appeal to youth or to deceive consumers. This process would be paid for by fees paid by the manufacturer. An ESD directory would tell businesses what products are legal to sell in Maryland, just like the existing cigarette directory, and keep products out that are not willing to follow Maryland law. This bill has very similar goals to Senate Bill 842 that you heard about earlier, but it goes further and creates a workable system for licensing and oversight of ESDs. The AG's office is working on providing revised estimates for the fiscal note so that it's more accurate. I urge a favorable report on Senate Bill 918, and I'm happy to answer questions you may have.
Thank you.
Madam Chair, Mr. Vice Chair, and members of the committee, for the record, I'm Dr. Clifford Mitchell. I'm the Director of the Environmental Health Bureau at the Maryland Department of Health. We have submitted prepared testimony, and I'm wondering if the sponsor, if the Senator Guile is okay if I say me too to her comments, given the hour.
I'm okay with that. I'm sure the committee is too.
But Senator Lamb has a question.
Sure, thank you, Madam Chair. You know, you kind of referenced this, but this bill looked very familiar, and you know, this bill was the first time I've seen this just today, because I think it's very close to a bill that I had last year.
Yes.
Down to the fact that it's 23 pages on both bills. There are whole pages that were taken and put into this bill. So, you know, I know this issue very well, and so, you know, I guess to start, you know, you reference the fact that there are differences between last year's bill, my bill, and this year's bill. And so I'm trying to understand why the AG's office is moving in this direction to set up another mechanism when FDA already has a mechanism in place for pre-market clearance.
Thank you, Senator Lamb, for your question. Yes, this is very similar to the bill that you submitted last year. No surprise there. I think that the difference is that in the intervening year, there's been sort of a sea change in the legal landscape. There's a couple of different things I'd highlight. First off, other states have passed electronic vaping directories, and they've received challenges from the vape industry. Some of these challenges have been based on a preemption basis, and they have been somewhat successful insofar as they've gotten preliminary injunctions granted. The basis is that only the federal government could enforce the Federal Food, Drug, and Cosmetic Act, and so the states relying on the FDA's approval or authorization or not authorization of a product is not something the state can enforce. They're still in court, so the resolution of those are not final. In Kentucky specifically, a court has found that you don't actually have standing to argue that you're losing the right to sell an illegal product. So that case is sort of heading in a different direction. So there's court challenges.
They shouldn't be selling anything that doesn't have pre-market clearance, right?
Yes, that is true. So at the federal level, there are 34 e-cigarettes that are authorized for sale. Every other product is not legal under federal law, full stop. It does not matter if they have an application in the pipeline. It does not matter if they have a court challenge. And we looked at this last year and we saw these changes. There's a case in the Supreme Court as well, the Wages and White Lion case, that could have also a significant impact on the FDA's PMTA process. We also looked at what's happening at the federal government and the firing of FDA folks. And so we tried to move this in a direction that was firmly grounded in Maryland state law to ensure that it would not be susceptible to these challenges on the basis of federal law reliance.
So you're creating a whole new mechanism where FDA already has a process in place for pre-market clearance or approval. So what is the AG? Because I think the FDA process actually is broader. It looks at public health implications and other things. What is the AG's office going to look at differently? Is it not including public health? Like, you know, I look at some of the things that have not been approved, that you reference that don't have approval, right? And I'm curious what the AG's office would approve that the FDA's office would not approve. Is it mother's milk and cookies? Is it killer fruits and blue raz? Like, what products would you approve that FDA would not?
So I think that we are looking at similar but different information in some ways. As we do with cigarettes, the directory would request that manufacturers submit a great deal of information, including who they are, where they manufacture. We would require them to get an agent for service of process in the state so that if for some reason they were out of the state, which frankly most of them are, if not international, we would be able to touch them for a violation. We're not doing the kind of assessment that the FDA does. We are not research scientists, but we would be looking at things like what flavor are they offering, what marketing did they do. Now, the assessment—
So you're not including the public health considerations?
Not as much, but we are
health?
looking at marketing and advertising, which goes to the AG's office's expertise in consumer protection actions, which date back to the Master Settlement Agreement and the big tobacco cases of the late 90s, continued in the early 2000s with cases we also brought against big tobacco and more recently against the Juul case. So we didn't want to we can't replicate the FDA scientific review process. We tried to do it in the areas where we have expertise.
Are there any products that the AG would approve that the FDA has not provided pre-market clearance?
I think that there is a possibility that the AG's office would approve some products that the FDA has not, because
really?
I think, you know, as we have in cannabis, I think we envision a process where there is law at the federal level and Maryland has created a slightly different system for itself. We are trying to set up a workable system. Again, I would go back to the fact that we are not quite sure where the federal law is going to land. The Wages and White Line case could frankly upend the entirety of the PMTA process for ESDs.
So if you think this is such a great public health bill, why are there no public health advocates signed up to testify either in support or against this bill?
I think that I can't speak for the public health advocates. I think I would ask you to ask them. I think that they have been leery of directory bills introduced in other states. We have been in conversation with them. We have explained our thoughts and our rationale, the fact that we're trying to ground this bill in a concern to prevent youth vaping and to promote consumer protection. And, you know, I think they're listening to us. They're neutral on this, and I can't speak more for them.
I mean, I think some of their concern is that this is a giveaway to big tobacco, that this is a proxy war between retailers and vape shops. Is that not so?
I mean, I've heard that argument. All I can say is that this was a bill that we drafted in reliance on our expertise and also on the cigarette directory that has existed for 20 years. The idea of a directory for nicotine-containing products has been around since the early 2000s. That has been in place for decades. It has worked very well. In Maryland, if you want to sell a cigarette, you have to apply to the AG's office and get certified for each and every product. The genesis of the idea for a directory came out of that. We wanted to make the ESD system parallel to the traditional combustible cigarette system. How people characterize that, I have no control over, but we are trying to make this be a very similar process.
So on the ESD part, only ESD license holders can sell vapes. Does that mean only vape shops?
No, retailers are certainly able to get an ESD retailer license. Those are two different
last year we had a bill that Senator Kramer had that would have only limited vapes to be sold in vape shops.
Correct.
Why would that not be a better mechanism to deal with this so that we don't have to create a whole new regime to be able to address that?
I mean, if that's the conversation, I think that's a slightly different conversation than this one. We certainly supported that bill last year with amendments because we thought that it could go further to work on the products. We loved the idea of limiting vapes to only being in vape shops because ostensibly that is an adult-only space. But that part of the bill did not survive. And so we are trying to, again, set up a system that is workable and that, takes in part the situation as we find it.
So if these should not be sold already because a bunch of them don't have pre-market clearance or approval from FDA, why can't the ATCC just do it on its own and remove these products from the shelves? Why do we need to go through this whole process of a proxy war between retailers and vape shops?
So the current biz reg section that the ATCC has authority in does not grant them authority to conduct inspections or to seize contraband product. And because the law is silent on the products themselves, under Maryland law, there actually is no contraband product. The law primarily speaks about licensure. So it's unclear how they would go into a shop and seize and whether they have the authority to seize. And so one of the things that Senate Bill 918 does is make explicit that ATCC, as it does for cigarettes, as it does for OTP, would be able to inspect license holders and would be able to seize contraband product.
So I see in the bill here that it says it has to be in full compliance with all applicable state, local, and federal laws regarding the manufacture and sale of electronic smoking devices. So if they already have to be in compliance with federal law, aren't we in exactly the same spot? Why do we need this bill?
I think that that's where the preemption argument is. Where states have tried to have similar laws and have tried to use that to go after people for selling products that are not legal under federal law, they have been challenged on preemption basis because the argument is the Federal Food, Drug, and Cosmetic Act can only be enforced by the U.S. government. So even this was something that the state cannot do.
So how can you be in compliance with federal law if you're selling a vaping product without pre-market compliance?
Arguably, you are not in compliance with federal law, but there is not a fantastic mechanism in the law right now for doing any enforcement about that, which is what this bill.
But ATCC could go in and pull them from the shelf.
It couldn't right now because they would be arguably preempted by the Federal Food, Drug, and Cosmetic Act, and they also don't have inspection authority.
Would you let a business certify that they're in compliance with federal law if they don't have pre-market clearance?
That is a good question. I think I would have to consult with the other folks in my unit. Again, I think that they're in compliance with federal law, but we can't enforce it. It sort of puts us in this strange position. It is sort of the law right now does not have an enforcement mechanism. Whether they would have to certify on a certification form, I could not tell you sitting here right now.
Okay. Well, I think we're in many strange positions here. But, I am concerned that, I think the more straightforward way of doing this would be just to limit vapes to be sold in vape shops. I think this is getting into a battle between retailers versus vape shops. And that's why there are no public health advocates here, except Dr. Mitchell, who's representing the department, I presume. The standard folks from Lung Association, Cancer Society, there's no one here. This is not a public health bill.
Respectfully, I would submit that, again, we have been in conversations with the public health folk. I think that they have hopes for a more serious restriction. And we at the AG's office with the senator are thinking of trying to make a workable system. The vape shop limitation was taken out last year. The flavor ban that was in the 2020 session also did not pass. We are trying to see what works in Maryland, and we are trying to set up a system that not only works at the product level, but deals with the licensing holes that exist in the law.
And what can pass in Maryland, too?
But to my point, I think we have had public health advocates reach out to us, even as of today, with strong concerns about this bill. Because I think, my opinion, is that it's not a public health bill. We're wading into an area where it's a battle between retailers and vape shops, and it's masquerading as a public health bill But it's an area that I'm not sure we want to get into in a way that this mechanism creates, because it doesn't rely on the pre-market clearance. It relies on some new regime that the AG's office is setting up.
It's a regime that we are borrowing based on the 20 years of experience with the cigarette directory, and in areas where the AG's office, as I said before, has many years of experience, consumer protection and youth smoking limitation.
So I guess last bit here, I know the AG was involved in last year's bill because we helped write, well, Mr. Kremer helped write this bill last year. Was industry involved in modifying this bill for this year?
This bill was Senator Kramer had a different bill last year, and the bill that you sponsored was the one we worked on with you. Those were two different things. This bill, as we did with last year, was drafted primarily by the Attorney General's office with the help of its sponsors. You know, we again.
Was there industry input in this bill, this version?
Has there been industry input? Yes. And we have also shared it with public health, and we've had conversations with them. We have, you know, considered technical amendments that we've gotten from the public health folks because they suggested, for instance, improving the definition of what is a vaping liquid so as to be more inclusive. We are trying to, again, set up a workable industry that balances many of the competing interests here.
And on that last point, I saw a lot of shaking heads in the back.
Senator, if we can go on to some other questions. Senator Jackson, you're next.
Thank you, Madam Chair. Can you explain to me the directory decision process and why a directory?
Yes. So what happens is that a manufacturer of electronic smoking devices would submit an application to sell in Maryland. As I mentioned before, they would include the kind of information like where they are located, what products they are seeking to apply for, and sort of break it out into different what we call brand families and brand styles. If you think of in traditional cigarettes, it works out like Marlboro or Marlboro Light. You know, there's like different subcategories. But so we would sort of have them explain all of the products they're trying to include. Again, if they're located outside of Maryland, we would require that they get an agent for service of process so they're reachable by Maryland law. And we would ask that they pay $1,000 per product that they are applying for to fund this process. We would also ask, for advertising and marketing information for what a physical version of the product so we could see what it is. As the senator mentioned, sometimes we see products that have games built into them. We see products that you can adjust the amount of smoke that comes out of it so it can be more discreet or not. Those are the sorts of things that we want to find out about. And we would then assess all of this in addition to sort of making sure that they have submitted all of the required information. And at the end, the Attorney General's office would sort of make a determination of whether this company is going to follow Maryland law, which we would, you know, evaluate based on all of the information they've submitted, whether they've paid the fee, and then again, whether whether it is a product that is meant to appeal to youth or what would deceive consumers.
One more question, Madam Chair. Does this change the taxes charged, and what about the taxes?
So this bill does not make any changes to taxes at all. The taxes went up last year at the very end of session, and this makes no changes whatsoever to that. So I think that in the House, we heard testimony about the negative effect that this would have on sales and use tax, but I think if you look at the fiscal note, that is not available information. I think any specific numbers are pure speculation. We've asked the comptroller's office how much sales and use tax is collected from electronic smoking devices, and they do not collect that information on like a product category. It is, you know, so we don't totally know. What we do know is that, as you have seen, there's been a rise and fall of different types of electronic smoking devices in popularity. So Juul was very popular. Now we see things like Geek Bar and Elf Bar and Mr. Fogg and devices that have, like I said, you can sync them up to your phone, or they tell you how much battery is left. So the products themselves are changing very, very quickly. And it seems as though there is not the kind of brand loyalty that would suggest that removing some products would ultimately have a negative effect, because hopefully people will be smoking or sort of vaping products that are now legal. Like, the idea is to guide them into legal products. And so while the hit on sales and use tax is not knowable, the hope is that it would not dip because people would be, instead of using illegal products, be using products that are legal in Maryland.
Thank you.
Thank you, Senator. Senator Reedy.
I'm trying to be quick. I guess trying to understand this bill and the differences between the two.
And can you explain to me, I mean, Senator Lamb talked about it not being necessarily a public health bill in his view, and I understand where he's coming from to some extent. I guess the public health interest we're mostly focused on is how to prevent kids from getting this, right? I mean, is that the idea? I think that seems like the idea behind both bills, unless my brain may be scrambled. So in your view, why is this the way to go to keep kids from getting it as opposed to, I guess, well, why is this the vehicle in your view?
So I think, thank you for your question. This would empower the state in various ways to sort of get more control over the industry. I think as you've heard, entities that sell cigarettes or other tobacco products and have licenses for those don't have to get a separate electronic ESD license to sell those products. So there's an absence of knowledge of who is selling the product, and this bill would correct that. There's also, right now, under existing law, a manufacturer can legally sell to anyone over the internet. And there's various ways of ostensibly age-gating internet sales, but they're not perfect. And as the parent of 2 teenagers, if they wanted to buy something over the internet, they would figure out a way to do that. And so this.
But how would, I'm so sorry.
Yeah.
I mean, this is, how would this stop that from happening?
So what we have found, and I think that this is consistent when you look at consumer protection actions, is that when a state makes something illegal, websites will start preventing you from buying something and sending it to Maryland. So instead of, right now, you can put in your zip code and give a Maryland address, and it'll say, no problem, happy to send it to you. With this, websites themselves will sort of self-select out of shipping to Maryland. And because it is now illegal, the Attorney General's office could take enforcement actions against those websites that are still selling things and those manufacturers that are still selling things.
But they can't do that now? Oh, because we don't have a law established.
It's legal to sell directly over the internet. So
You're
it
sort
makes
of making,
that, yeah.
It's funny to hear you say if you make it illegal, it'll slow it down, just because that's the reason I didn't want to vote to legalize marijuana, is because I didn't really want us to tell people it's okay to smoke it. But that's maybe a separate issue. I don't want to belabor the point. I think I appreciate it. It's a lot to look at.
That's
So
a good
thank
question.
you. Thank you.
I don't see any other questions. Thank you to this panel.
Thank you, Madam Chair.
We have a couple more favorables, Bruce Bariano and Manuel Mazumder. Mr. Bariano, you can begin.
Good evening, Madam Chair, members of the Finance Committee. Bruce Bariano here on behalf of the Maryland Association of Candy and Tobacco Wholesalers. As to the portions of the bill that touch upon and relate to the tobacco wholesalers, we support the legislation. We have a longstanding relationship with the Comptroller's Office, with the Attorney General's Office, relative to licensure and stamping and making sure that the product is properly handled at the wholesale level as we deliver it to the retailers. And to the extent that this brings in vape shops and vapes into that system for the various purposes that was indicated, I think my clients have shown over the many years that they're capable and able to do this and will continue to do this if that product is to be put in our process stream for legality purposes, and the Comptroller's Office and the Attorney General's Office knowing of what products are being lawfully stamped, sold, delivered to, et cetera. Thank you very much.
Thank you. And please.
Dear Senator, my name is Manuel Mazumder. I'm writing to express my strong support for Senate Bill 918, which aims to regulate a e-vapor product as a retail store owner. I believe this bill is crucial for consumer safety and responsible business practices in the e-vapor industry. The lack of clear regulation for e-vapor product has created challenges for retailer store owner like myself. Senate Bill 918 proposed to establishment of regulation and directories for e-vapor product. These directories would provide clear guidelines for retail store owners, assuring that only authorized and safe products are available in the marketplace. Implementing regulation and directories for e-vapor product would enhance consumer safety and confidence. Customers would have peace in mind knowing that the product they purchase have been thoroughly examined and approved for sale. In conclusion, Senate Bill 918 is necessary step toward regulating e-vapor product. It will assure consumer safety, promote responsible business practices, and create a fair marketplace for all retailers. I kindly request you to your support for this passes of this bill. Thank you for your attention today.
Thank you for your testimony. Do I have any questions? Not seeing any questions. Thank you very much. I have 7 unfavorables. I'm going to keep calling until the chairs are filled. Elmer Bailey, Matthew Milby, Melissa Hendricks, Candace Gott, I know you're still here, Tyler Bennett. That's 6, I think. No, one more. Kyle Vega. Okay. Tyler, will you start and we'll just go right down the line?
Sure.
Thank you.
Madam Chair, members of the committee, for the record, my name is Tyler Bennett with Compass Advocacy on behalf of the Maryland Vapor Alliance. We obviously have several members here to share their concerns with the bill. We are here in respectful opposition to the legislation. I wanted to take the opportunity to comment on some of the conversation so far. I think, frankly, if the goal here is to keep these products out of the hands of youth, I think the best way to do that is to limit where they were sold. We were certainly in support of that measure in Senator Kramer's bill last year. It wasn't something that we had suggested. It was something that we saw and felt that was a good idea. And it was also one of the reasons behind one of the amendments we had submitted to the bill heard earlier today, which was along the same lines, but didn't go quite as far. It distinguished between products that were 5 milliliters or less and 5 milliliters or greater. The law already makes this distinction in the way that these products are taxed. The products that are 5 milliliters or less tend to be those cartridge-based products that you see is mostly what the large convenience store chains are selling, and all other products would just be sold by holders of vape shop vendor licenses. And those businesses are businesses that only sell vape products. They don't sell any tobacco products, anything else like that. So we would certainly be supportive of that measure. The rest of the panel is going to talk about the concerns of this bill as proposed. And I think that's it. I think that's all I had.
Thank you, Chair Beidle and panel here today. Elmer Bailey, I'm a shop owner, Vapor Emporium in Newmarket with the Maryland Vapor Alliance. I will start with why a registry bill when these products are already filed and registered with the FDA. We're subject to FDA inspection. Any products that are in our stores that aren't on that list would be removed by the federal government. And I know they're going to get mad here, but I'm next to a dispensary. So when the Attorney General's talking about, having full control over products that are already being under consideration by the FDA, and there's a shop state sanctioned that those products are not government FDA approved at all. So it just seems kind of a weird argument from the state's attorney's office. It seems to give them undue discretion over what products are available on the market and which ones aren't. They're not for the benefit of public health. And I'll tell you, as a parent and citizen in the state of Maryland, you know, when it comes to the youth, and I've got kids, and I could tell you, when it comes to marketing, they couldn't even tell you who Joe Camel is. Those days are gone. I have bigger concerns, and this is per the youth survey. Marijuana and drug use, alcohol use, far exceed the record low number of youth vaping in the state of Maryland and on a national level. I mean, we have taken great strides as an organization in this state to keep these out of the hands of youth and be the responsible retailers of these products. And in closing, it is basically a big tobacco bill. And when the only people for this are big tobacco retailers and wholesalers and the industry itself, it really kind of should have our wheels turning a little bit. Thank you.
Thank you. Candace?
Good afternoon, members of the committee and Chair Beidel. My name is Candace Gott, and I am a board member on the Maryland Vapor Alliance and a small business owner in our community. Here we are again using legislation to give another gift to big tobacco. This bill is being lobbied all across the United States under the guise of consumer protection. It's not. It's for big tobacco's protection. This bill will effectively shut down my small business vape shops, and I'm one of the people that pay your taxes and follow your rules. First, there is no framework or mechanism described as to how products can gain compliance, so we just have to assume that most of our products will be banned. This bill requires an excessive $75,000 escrow fee and then another $1,000 per SKU fee annually. Open system vape manufacturers are not companies that can afford these fees, but do you know who can afford these fees? Big tobacco. Additionally, there is no pot of gold at the end of this rainbow. The very few big tobacco products that do sign up is all the state will reap from this. Meanwhile, the state will lose at least $100 million to $200 million in sales tax revenue each year, which is a conservative number since our sales tax has been raised 100% plus. This does not account for the payroll taxes that will be lost or what it will cost the state to enforce this cluster mess or the cost to build the framework for such a complex project. Has anybody considered these things? My customers who use 3 milligrams of nicotine on open system vape devices will be forced to use 50 milligrams of high nicotine big tobacco products unless they decide to get their products from another state, which is what I will advise my customers to do. Many customers will purchase off the big and booming black market because there is no closing Pandora's box. Or the worst scenario yet, they will go back to smoking cigarettes, which will be the state of Maryland's big gift to big tobacco. Teen vaping is at an all-time low, down another 2.2% from last year. So again, I'm going to ask the committee, who does this bill protect? Big tobacco. I'm asking for an unfavorable report. Thank you.
Good afternoon once again, Chair Beidel and members of the committee. Matthew Milby, small business owner. I'm also a disabled veteran, and I'm here in opposition to this bill. This bill is just another way to ban vaping across the state unless you have the money and resources to comply with the just very onerous record keeping and the money it takes to comply with this, which leaves big tobacco on the table. Yesterday we were in the House of Delegates and they asked us a good question and they said, how do you know the businesses can't afford to deal with this? So I spent the last 24 hours and I've emailed you all about 8 o'clock this morning. I reached out to different organizations, manufacturers, distributors, and I got some paper copies with me, but they said, yeah, there's no way we comply with 75,000 and 1,000 per SKU number. It's impossible. We'll choose not to do business in Maryland. Like I said in my previous testimony, we have proven to be the good guys of this industry. We pay the correct tax, 20%. We found many that don't. We card. I have a stack of compliance papers. Well, the police officers come into my shop all the time. We got tons of it. These products need to be moved in the vape shops. We are the gatekeepers of this industry in Maryland. And then we have to find some way to police the internet and TikTok where people can readily buy these products all the time. Because if this industry goes to big tobacco in Maryland, people are going to find these products on the internet. And I haven't heard a good plan yet on how to police the internet because it's already federally illegal to buy a tobacco product and have it shipped to consumer. And for how many years now? And we haven't found a way to stop that. I have very little doubt that the AG's office is, we can't figure out the way to collect the correct tax, and we're going to find a way to put millions of products into a category, and we're going to do well with that. I just don't buy it. Thank you.
Melissa?
Thank you, Chair Beidle and committee members. I am opposing SB 918. We already have somewhat of a framework of a registry. Any company that sells here to the state of Maryland, any vape products, they do have to register with the state of Maryland. So we should have some kind of list of something of the companies that do sell here to the state of Maryland. I'm actually currently dealing with that myself. I've been in business for 10, 11 years, and I've dealt with a few of these companies that I currently am unable to purchase product from because they're not registered here in the state of Maryland because they have relocated their business. And with that being said, at that business, they have to turn around, re-sign up, register with the state of Maryland in order to be able to sell me products. So I'm not sure why we can't just use what we already have as a framework and really kind of work harder on our licensing. This will help big tobacco because it's a lot of money for some of our smaller manufacturers that, they've been on the fight on a federal level along with some of these states. So, we're doing everything that we can to just kind of stay alive at this moment. Adding $1,000 per SKU that's a lot. I've got a lot of SKUs in my shop alone. I want to say maybe 5,000. I can definitely go back and look at how many SKUs I actually have, but I mean, that's a lot. And if the AG is going to take on that, but yet we can't enforce what we already have, I'm not really sure how this is actually going to work at the end of the day. Again, I've been in business for 10, 11 years and never have been checked for IDs. So what does that tell you? How many other stores in my area haven't? And I know they're selling to underage kids too. And I've reported them.
Hello, Chair Beidle, members of the committee. My name is Kyle Vega. I am a member of the Maryland Vapor Alliance, and I've been a two-store owner in Baltimore County since 2013. Today, I'm in strong opposition of Senate Bill 918. This bill would effectively shut down the vapor industry in Maryland and all small businesses like my own. One of the most alarming aspects of this bill is that it will hand the market back to big tobacco, create a monopoly by wiping out its competition. Now, some of y'all may not view this bill as a product ban, but I'm here to tell you that it certainly is, as we have all kind of stated on. None of our small businesses can afford these fees that are associated with everything. The scariest part is that even if we could, there's still no guarantee that we're allowed on this product list, because there are no clear guidelines as to what the AG is looking for, what they will allow to have, and what they want us to do to play nicely. This is basically a pay to play. If you have the money, you can get in. This bill is a direct attack on this industry. It strips away the biggest competition for big tobacco and enhance the industry right back to them. This is the same bill that we've always seen. It's just written a little bit differently. And every year you see these people at this table here again. We are the industry. We are the people that know the industry, and we've never had a seat at the table to explain where we are and explain to y'all how we can help you. Because our goal is to help you. But if we don't have a voice, we can't help. And that's what we're here to do. Thank you for your time.
Thank you, Colin. Melissa, I just want to respond to you about something.
Yeah.
The ATCC, the bill I had earlier today, is really about enforcement.
I'm all about it.
And they've added 100 contract people to enforce.
I hope
and
so.
And my issue is really about the young people. So
I'm about it.
Hopefully they're going to start checking that.
I hope so. Honestly, I hope they do. Matt gets checked a lot.
All the time.
And I've never been checked. And I'm just like, how is this happening right now? I'm like, I cannot wait for that person to come into my store.
Well, your dream might come true.
Great, that's awesome.
Okay, do I have any other questions for this panel? I just want to thank you all for being here and for staying till the end, which we had to do, but I'm happy that you did. Thank you.
And Madam Chair, I accidentally referred to you as Chair Wilson in my written testimony, and in 12 years, it's the first time I've ever made that.
Tyler.
I was mortified, and I just wanted to.
It's okay. I get along just fine with Chair Wilson. It's all good. Thank you. Thank you. So this ends this panel. We have one virtual witness, Annie Claycamp, who is an unfavorable. Annie, you want to unmute and go?
Good evening, Madam Chair and Chair members. Thank you for waiting for me. I know it's late. My name is Annie Claycamp. I'm a PhD trained scientist and have studied nicotine and tobacco for the past 23 years. I have no affiliation with the nicotine or tobacco industry. I've also been a Maryland voter and taxpayer for 17 years. I'm here to talk about science and public health and why this bill is not aligned with either. According to science, e-cigarettes are not smoking devices. They do not burn tobacco, contain tobacco, or produce carbon monoxide. As noted by the FDA, they are generally a lower risk alternative for adults who smoke. In addition, the Cochrane collaboration, the gold standard for unbiased scientific analysis, reviewed data from nearly 30,000 people and found that e-cigarettes are more effective than standard quit aids like nicotine patch and gum. A separate Cochrane review found that switching from smoking to e-cigarettes significantly reduces exposure to harmful chemicals. We've known for decades that smoking, not nicotine, is the primary cause of tobacco-related disease. Nicotine is not a direct cause of cancer or respiratory disease. That's why nicotine replacement products like the patch and gum can be bought at your local Target over the counter. Yet, even when combined with behavioral therapy, 85% of people fail to quit with these products. These traditional methods are not sufficient. Smoking rates among middle-aged and older adults in the U.S. and Maryland now exceed those of young adults, and they're rising among those in poverty. 1,000 people die every day from smoking in America, and in Maryland, 1 in 10 people smoke. That's over 600,000 people. E-cigarettes aren't risk-free, but science tells us they are far safer than smoking and can help people quit. If this bill passes, hundreds of thousands of Marylanders who smoke tobacco would lose access to a proven tool that could help them finally stop. I think this bill creates extreme barriers to people obtaining these safer nicotine products and ignores scientific evidence, including that youth vaping are at the lowest levels recorded in 10 years. Thank you.
Thank you very much for your testimony. Did we have any questions for this witness? Seeing no questions, that ends this bill hearing, and it ends our bills for today. Thank you. Committee, stay close. We're going to do a voting session as soon as Tammy gets the system set up. Thank you. Thank you, committee. Today is Thursday, February 27th. You were with the Finance Committee for our voting session, and we're going to start with Senate Bill 26, Senator Kramer. And David, please present.
Okay, Senate Bill 26 was held from last week. If you recall, it creates the Public Employees Safety and Health Unit in the Maryland Occupational Safety Health Program. It adds additional provisions to the law regarding workplace safety for public employees related to workplace violence specifically. The bill establishes penalties for local governments who don't comply with the provisions of the law. You have a thick reprint in front of you, which we went through last week. Most of the sponsor amendments in the reprint address concerns of the Maryland Department of Labor regarding existing authority and an unnecessary assistant commissioner position, and address some of MACO and MML's concerns. MACO's and MML concerns include the fact that they have to notify their employees by email. That was struck from the bill. They can notify their employees in the best way possible. And also there was a reporting requirement, a quarterly reporting requirement. The sponsor struck that requirement also. The only other concern from MML was the amount and extent of the penalties, and I think the sponsor has an answer if he wants to discuss why he wants to leave the penalties where they are.
Penalty provision is necessary for there to be enforcement of the legislation and the law. So I think there was a meeting of the minds with MML and MACO on everything else, but on this one, it would be illogical to take that out. So we're going to move the bill as it exists now.
What are the penalties, David?
Well, there's several. There's civil citations and there's criminal penalties. They're all in the back of the reprint.
And that's for knowingly.
For knowingly violating the law. There's penalties for government representatives who violate the law. Who I think they start on page.
Just tell me what the criminal is.
I think they might be all civil penalties. I'm not sure they're. Yeah.
And it's knowingly. I move favorable, Madam Chair.
Well, there is a criminal penalty on page 15 of 17. A person who holds a political office in the state, whether elected or appointed, is guilty of a misdemeanor and conviction subject to a fine not exceeding $20,000. There's that penalty there. If a person who holds is guilty of a person who holds political office in the state, whether elected or appointed, or any other position of profit or trust in the government of or in the administration of the business of the state or county, municipality, or other political subdivision that violates any provision of subsection A, which is a person may not knowingly make a false certification, false representation, or false statement of an application, plan, record, report, or other document that is required to be filed under this title.
Oh, so if you knowingly submit.
That's a criminal penalty. They're guilty of a misdemeanor.
And you'd have to prove knowingly in a court of law, correct? Yes. Not just like, oh, they knew, oh no, I didn't know, right? It's got to be, it'd be a criminal proceeding in a court of law.
Mm-hmm.
Seems highly unlikely that would ever be a case that's brought, but
And
yeah.
that has to be in there. We have to keep the criminal penalty in there, Senator Kramer.
Well, there's currently a criminal penalty in that section. This just adds to what is existing. And again, it is specifically knowingly making a false certification, knowingly making a false representation, or knowingly making a false statement in an application. So I think it's pretty
I'd probably
clear.
Okay.
Just saying it's stuff.
All right, so Senator Kramer moved favorable. Do I have a second? Senator Lamb seconded. I think we better do a roll call. What do you think?
I think we're there.
You think you're good? Okay. All in favor of Senate Bill 26? We have a unanimous vote. Thank you.
Okay, the next bill on the list is Senate Bill 445. This transfers the Federal Commodity Supplemental Fund Program from the Department of Aging to the Family Investment Program in the Department of Human Services. There was no opposition from either agency to this transfer, and the House bill is already in the Finance Committee.
Can I have a favorable motion? Senator Gall and Senator Lamb, all in favor of Senate Bill 445. Have a unanimous vote. Thank you.
The next bill was held from last week also. This concerns the law that deals with appeals and grievances and adverse decisions made by carriers. It's Senate Bill 474. You have a reprint in front of you. It establishes additional reporting by carriers to the Maryland Insurance Administration under the appeals and grievances law for a type of service a grievance has grown by 10% over a year or 25% over the preceding 3 years. You have you have a reprint in front of you which adds additional language from that part of the law that concerns the disclosure to a member, the required disclosure to a member of the name of the person with the carrier who made the decision to deny coverage. So it takes the name out as a result, and this is in response to some of the issues that occurred a couple months ago with the insurance executive. So under current law, the name of the person who makes the decision to deny has to be given to the member or the member's representative. It strikes that requirement and says instead it includes a unique identifier for and the business address and business telephone number of the carrier, if the carrier is a health maintenance organization, the medical director or the medical director or associate medical director who made the decision. So the name no longer can be disclosed to the member, but a unique identifier developed by the insurance administration. And there's 2 instances where this will occur in the law.
The insurance commissioner helped with that amendment. So, the fear is retribution to someone who denies a claim, but she'll know who it is, and you'll have all the information to contact someone to appeal.
Move favorable.
There's an additional amendment.
As amended.
If you go to page 2 of the reprint, or no, I'm sorry, yeah. If you go to, it's further in the reprint. It's the second from the last page of the reprint. This is where the information is that's required for additional reporting, and the insurance administration again had additional requests asking for additional information from the carrier regarding the number of appeals or the increase in appeals. Their efforts to address these increased appeals, these increased denials.
That's how the reporting.
Yeah.
Senator Kramer moved favorable. Do I have a second? Senator Mount seconded. He beat you to it. All in favor of this Senate Bill 474? Unanimous vote. Thank you.
Okay.
Okay.
Okay, so the next bill, this is Senate Bill 576, and it specifies that if an employer has a meeting where political matters or religious matters are discussed, the employee may not have to attend this meeting or can walk out on the meeting, and the employer may not be able to retaliate against that employee.
Move favorable.
Second. We have a motion and a second. All in favor of Senate Bill 576? We need to call the roll. Thank you, Madam.
Senate Bill 576, favorable. Vice Chair Hayes.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
People need to hear more about faith, so I'm going to say no.
No. Senator Ellis.
Yes.
Yes. Senator Mount.
No.
No. Senator Jackson.
Yes.
Yes. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hershey.
No.
No. Madam Chair.
Yes.
Yes. 7-3, the bill passes.
Okay, the next bill on the list is Senate Bill 785. This deals with the existing unpaid parental leave program of state government. I'm somewhat familiar with this because I drafted it. It's meant to be a, not this bill, but the program from several years ago. What it did was it brought the elements of the Federal Family Leave Act onto the state government. The federal, if you all know that the FMLA only applies to employers 50 or greater. This would allow unpaid parental leave from employers of 25 to 49. Otherwise, you'd be covered by the FMLA. What this does is specify that if you're covered by the Maryland Parental Leave Act, you can't be covered by the Federal Family and Medical Leave Act at the same time, because it's possible that folks could take twice as much unpaid leave.
Hold on.
You can stack it.
Right, but I thought FMLA was just like a protection, it's not actual leave.
It's
It has
unpaid
nothing to do
leave.
with pay.
No, you can take up to I think 45 days of unpaid leave under FMLA. This allows the same amount of leave.
But you just can't combine the two.
You can't be subject, yeah, because sometimes, I guess, the testimony is that employers can change size over if you're at that margin.
Yeah, you jump up over the size and then so it changes and it's confusing as to whether.
Oh, when you were talking about 50 or whatever, you were talking about the size.
Yeah.
Got it. All right, thanks.
Can I have a motion favorable, please?
Move favorable on my very
Senator, Senator Reed, you said?
Oh.
Senator Jackson.
Can you say what the age range was for the FMLA and then the unpaid leave?
Number of employees.
It's the number of employees, it's not age, yeah.
Okay, and what is that?
It's 50 or greater
For
is
the
FMLA. And this particular leave program is, I believe, 25 to 49.
I think it's 18 to 49, but I'm not sure.
18 employees? It might, it's less.
So how would they be able to use both if they're two? Yeah, they're two different ranges.
If you were one size company for a period of time in the year and then you become a larger company, you get bumped up. But the way the bill was written, the way our law was written and the regs came out, the regs took years to come out for some reason. It's confusing to employers that if you change sizes of your company in the middle of the year, basically.
It's 15 to 49, sorry.
Yeah, 15 to 49. Yeah.
So this only applies if you grew within the year or something?
Right. Right.
Yeah, right.
There are companies who go, and this is about unpaid leave. This isn't about paid leave.
Right. Okay. I'm just.
Employees at least 15, but not more than 49 individuals in the state.
It was parental, it was written, it was designed, as you passed it, it was designed to provide parental leave, which is an element of family and medical leave, but only parental leave for smaller employers that aren't covered by the FMLA.
Okay. All right, I had a motion. Senator Reedy motion. Did I have a second? Senator Hershey seconded. All in favor of Senate Bill 785? Unanimous vote. Thank you.
Okay, moving down the list. I don't know if, these are some of Amber's bills. I don't think I'm ready to provide any information on Senate Bill 49. I know there's amendments out there, so you might want to hold this one. Or unless you.
I mean, can I just say, I know that Senator Mounts had offered an amendment to the trial period from, it's currently the 7 days, and he proposed 31 days. I hate that expression. I was just going to say split the baby, but we're not going to use that word. Let's go with, we decided, agreed upon 14 days, Madam Chair. And I'm fine with that. What he's proposed is that amendment for 14 days.
Okay. Do we want to do a verbal amendment?
Well, I think there might be, I thought, if I recall, there might be.
There's a whole bunch of amendments.
I thought there were other amendments also that were going to be worked on, and
You're more comfortable holding it? Is that what you're
I can't speak to anything that was going on with this bill.
saying? So David's going to ask to hold it. Okay. I don't know, we've never had a roll on that.
That's reasonable.
Okay.
Okay, well, considering the condition.
Okay. Yeah. Okay, so the next bill on your list is your second on. This bill was voted on by Triple E unanimously. It's one of Senator Simonair's good veteran bills. And what it does is it, under current law for cemeteries, if there's, or crematoriums, if there's unclaimed cremains, it specifies additional processes if no veteran organization claims the unclaimed cremains. So it establishes a process by which these cremains will be dealt with and ultimately, what's the word I'm looking for? Not disposed, but anyway. It creates a process, and the reason you are second on this is because it deals with cemeteries and,
And it already passed EE.
It's already passed EE with no amendments.
Senator Gall moved favorable. Who seconded? Senator Lamb seconded. All in favor of Senate Bill 57 that has already been passed by EEE? Unanimous vote. Thank you.
Okay, the next, if you flip your page over, we're on another bill that was in EEE, and you are second on. And this concerns authorizing the Maryland Department of Labor to establish certain processes to include a notation of veteran status on all the occupational licensing boards that fall under the Maryland Department of Labor. You're second on this because you have the appraisers and home inspectors board, but most of these boards fall under EHE. And it requires that they put a special notice on each license that they're veterans. There's an amendment that was adopted by Triple E in the reprint in front of you. If you go to page 2, there was additional requirements for these boards to follow to assist in determining eligibility for state and federal veterans benefits. That's been struck, and instead it just leaves it that they have to establish a process to include a notation indicating veteran status on each license issued by the department.
Do they take this to the floor?
They take this to the floor.
Move favorable. As
All right,
amended.
Senator Kramer and Senator Lamb made the motion. Yes, sir.
What's this bill do? I mean, just, you stick your veteran status on a license and what? What does it do?
Yes, there's some sort of identifier on a license issued by any of the regulatory boards that fall under the Department of Labor, the engineers, plumbers, or whatever, that they have to know that they're a veteran.
I understand that, but what does it do? I mean,
Does it reduce their fees?
does it do anything? I mean, is there a
Can I
benefit?
just, I think that if you are eligible for certain benefits, like for example, if you, loans list, all the work you've done for entrepreneurship and for veteran-owned businesses, it's that designation that kind of gives some verification that you are indeed a veteran. That's
Right.
that's my understanding of it.
Yeah, and that's what, that's what it does, but, I mean, just put a veteran in another bill. I mean, veterans are kind of upset that, people say thank you for your service and there's nothing behind it. So this is a bill that's just sticking veteran status on a license, and what does it do? I mean, in my opinion, doesn't really create any kind of advantage or preference or, I mean, it's just,
Entitled to benefits, this shows as a verification. Like if you have your military ID card, for example, it's shown as like that you're eligible. Like if you wanted to go to the commissary, whatever, NEX, it shows that your verification that you are a veteran. So I think if they wanted to establish that they are indeed a veteran, it just shows that they are a veteran and they're entitled to certain benefits. It's just a verification.
Yeah, I understand that. Yeah, I
Okay.
understand that. But I have a military ID card and I use it to go. Just today, I went to the naval base and went to the commissary. You can do that. That has a purpose, a benefit to it. But I'm just saying, I've heard from a lot of veterans that we pass these bills and we put, say, veterans on it, and it doesn't help them do anything as far as just, okay, veteran, okay, congratulations. And this seems like one of those empty bills that just say, okay, you're a veteran. When we as a state could really do something, say there is a veteran's preference, if you are a plumber and to get a contract with such and such a state agency. There is a, like federal government, 5% preference, whatever. But we do these empty bills and we feel good about it, saying that, oh yeah, we're looking out for the veterans, when it absolutely does nothing for the community at all. And it's just kind of like a, use it. I mean, I'm sorry?
You want to hold it to talk to labor?
Talk to labor?
What you wanted to do?
Well, I don't want it to do anything, but because it does nothing. I mean,
Some people want to do business with veterans, and they'll advertise and say, I'm a veteran's business. So there's proof, like your plumber's license, your electrical license, whatever, would say that you are a veteran, and it would be confirm it. So you're not just people out there saying, oh, you're doing business with a veteran.
Okay.
Yeah. I mean, I'm just kind of offended. I mean, it can go through. It doesn't hurt. Doesn't, in my opinion, help. But I mean, a lot of my colleagues, my comrades, are just offended that we pass all these bills, and it's like we pass bills for these benefits. It's authorize the county to do something, but we don't really do it, and so they have to go through another hoop to really get these benefits, appeal to more politicians. And I just hear that a lot from my comrades when I go to meetings. We're doing all these bills, which doesn't help the community at all, but it just makes us, I guess, give us political firepower to say we're helping veterans, but we're really
We
not.
have two choices.
Yeah,
EE's already passed it.
they're passed.
We are
Yeah.
second. We can vote and pass it because the EE already did, or you can hold it and talk to the Department of Labor. That's the two choices.
Okay, so I can hold it and talk to the
Okay,
Department
you
of
can
Labor.
hold it.
And
Thank
so,
you.
I like getting involved with that.
Okay.
Okay, the next bill is, I can relate to this one. This is Senate Bill 215. If you recall, when you enacted or passed legislation establishing a cannabis industry a couple years ago, you also established a provision for on-site consumption facilities, licenses for on-site consumption. What this bill, but the ability to issue those licenses was delayed. Now you're coming up to the time when you're going to, the state consider license applications for on-site consumption. The bill in front of you is a departmental bill that makes certain changes to the on-site consumption license provisions to more reflect what is happening now with the industry. And it also had events in there, but before you get into the event end of things, that's all struck from the reprint in front of you. So there are no provisions at all for cannabis events in this bill anymore. But we can go through the reprint rather quickly at this point. Okay. Okay, the first thing is on page 2. You'll see a definition of cannabinoid beverage. This will be added as to one of the legal cannabis products available in the state. These are also subject to the laboratory and testing procedures of all other cannabis projects in the state. If you go to the next page, there's another definition, a single-serving product. This is related to on-site consumption. It's going to be defined here. Then in the middle of the page, there's an additional amendment in here. Because of it's taking longer to get the micro licenses up, which are the folks are going to be delivering cannabis. It extends the delivery of medical cannabis 1 year to 2026. You established that provision 2 years ago, and it extends that to 2026. So that's in the middle of the page. Now we get to the bottom for the provisions that relate to on-site consumption licenses. And it just adds cannabis or cannabis products in here. If you go to the next page, some of the changes also include allowing on-site consumption to repackage for single-serving product only for on-site consumption. You can't do it anywhere else. You can't carry this out again. The whole purpose of on-site consumption is you consume cannabis there, and that's it. If you go to the bottom, there's additional requirements. Initially, you didn't have authorization for food to be served at these places. This goes into more detail about what kind of food and what kind of requirements are going to be required for an on-site consumption facility to serve food. They have to comply with all restaurant requirements. That's the amendment there. And if you continue on in a reprint, there's nothing here that is amended. And then we go to page 6 to 10 of the reprint, and this is a new language I think the chair would like to take up separately from the rest of the amendments, which would be, which are just modifying the on-site consumption provisions of the law. But what, I don't know if you want to discuss this now, Madam Chair, or if you want to wait till we go through the rest of the amendments that deal with on-site consumption.
Well, I'm okay with on-site consumption, but we added some other things that I wanted to get to.
Okay, that's what's on page 6.
Okay.
Down at the bottom?
Down at the bottom, yes. And that's actually on page 7 too. So those are the things you're adding. Everything else concerns modifying the on-site consumption provisions. And then the rest of the bill just strikes events.
Okay, so what we did at the bottom of page 6, there have been some requests for people that already had their cannabis license like 5 years, they converted and they got a whole new 5 years. This is saying they've served their time. If they had it for 5 years before conversion, they're now eligible to sell. And I don't know how it's going to go in the House, I didn't ask. But the other issue is there is one company that wants to have an ESOP with their employees. Their employees will buy the business. Oh, yeah. So I thought that was that story down in South County.
That's on the next page.
So, you know, this has been a request from a lot of the owners of the businesses, and it's up to all of you.
Yeah.
Senator Ellis?
So this, you're saying this is that your amendment that will allow these cannabis business to be sold?
Yes.
Because the original bill, which we passed a couple years ago, put what time limit
Whole
on
new
it?
5 years.
5 years.
Yeah.
So your amendment will change it to?
If they've already had 5 years, they were in business before, they converted, and now they've had a full 5 years already,
Okay.
they can sell.
Okay, yeah, great, thank you.
Okay? Okay?
Yeah.
Senator Craig?
Yeah, thank you, Madam Chair. David, do I recall, this is the bill that a number of public health organizations expressed concern that, A, you could be consuming cannabis on site, not knowing exactly the level of what it is you're consuming or the customer might be consuming, because it takes a while depending on how the product is consumed before they start to get the high. And even though it said each like gummy or whatever it is has to be limited in some kind of a quantity, they could take 10 of them. Do I recall that correctly? And this is the one where there's concern about leaving the facility, getting behind the wheel of a car, and the risks associated with that.
There was a lot of concern at the hearing. I did sit in on the hearing, and I think a lot of that had to deal with the events.
It did.
And because it would be much harder to control people walking around in open space and whether they can come and go, what they can bring in with them. Those concerns about, the latent effect of gummies you probably would have had those same concerns 2 years ago when you passed on-site consumption. So I don't know if anything has changed regarding that. All you've done here is got a little more specific about what these facilities can do, but you're not really changing much about anything else. The government still have to say, yes, there can't be any on-site consumption license awarded by the administration unless the local government approves.
And this is the one I think I asked the question that, did they actually trust the state that we're not going to pull the rug out from under them like we did previously, and said you all get to control the zoning, and then, oops, never mind, you don't.
Well, this isn't anything about zoning, so we're not going there. But
Okay.
the top of page 3 does say, a single serving product means an edible cannabis that is individually packaged, does not exceed the serving limits established by the regulations of this administration, and is intended for immediate consumption. So that's where it's addressed.
And the original statement that you were talking about. That was a concern that was raised at the hearing, but it was raised in the context of doing events. Because there was no way to check to see who was circulating what at the event and what the,
That was all taken
what the
out.
level was.
All right,
That was all removed.
Just so you know, I'll be voting against.
We
I
figured
know.
as much.
I know.
Tried to throw that poison pill up in
Have a
there.
drink, right?
Okay.
Okay,
Yep. Yeah,
so, do we have a motion?
Senator Lamb has a question.
Senator Lamb, I'm sorry.
Yeah, so can I ask who took out the event provisions?
I did.
You did.
After the discussion of, and you agree, after all the discussion of, you could be in an event and this booth could be selling alcohol and this booth could be selling cannabis, and the counties didn't like it, they didn't feel like they could enforce it, and it just, it complicated the bill.
Yeah, I mean, I get the complications. I have a large event space in my district that was
Yes.
keyed in on this. So is it possible to have a courtesy hold for a week? I just want to check in with them. Okay.
Courtesy hold it for a couple of weeks.
Can I ask a question? Just a quick question. If I remember, so you can smoke cannabis in these on-site consumption areas, right? Or
No,
No,
not smoke.
no, that's not changed.
Single serving.
You told me yes. I listened to my colleague
that
down
was
here,
Senator
Big
Lamb's-
Tobacco.
In their act.
Yeah, okay, good.
Did your colleague do?
I said, can you smoke in there? And she said, yes.
No, I.
You can vape is cool.
I can't believe everything your colleague said.
She's so into making sure everybody can smoke around here, I guess. All right, thank you very much, then. I feel better.
Okay, so you're gonna hold that one for?
I guess we're holding it,
So Senator Lamb can check with his, okay.
He represent very well.
That's Guy Zoning, actually. I don't know, maybe he's talking about a different place.
Okay.
Senator Lamb, what's in your district? I thought that was in Gazoni's district. That's in yours?
In her district?
No, in Gazoning. I thought it was in Gazoni's.
no, it's in mine.
Okay.
Okay.
All right, so holding it for you to check again.
I will tell you, if you're going to talk with them, my concern is if they're going to serve cannabis, they only serve cannabis. If they're going to serve beer, they only serve beer and wine. They don't serve both. So that's my problem.
Yeah, and I get it.
You can't mix them.
It's a weird place to be for a public health person.
Hello?
I just want to.
Okay, that's fine. Okay.
But also, there wasn't as much vetting around the idea
Okay.
of doing events as it was with on-site consumption.
I don't think Senate Bill 357 is ready.
No.
Senate Bill 373 is a bill that would authorize binding arbitration for the firemen at BWI. Currently, they have access to the same dispute resolution that other state employees have, fact-finding, but this for only the firefighters at BWI would give them binding arbitration in the event of impasse. There's an amendment. There's a reprint and there's an amendment offered by the chair that says any decision of the arbitrator under this paragraph related to wages, it's on page 4 of the reprint. If you go to page 4, any decision of an arbitrator relating to wages is subject to the limitations of the state budget.
And they were fine. The firefighters were fine with that.
The wisdom of Solomon.
I just have a question, Madam Chair.
Yes.
And I appreciate that effort of what that is, the limitation of state budget. This money is from MMA, or Maryland Aviation, MAA, right? Out of the Transportation
Well, I
Trust
mean,
Fund.
that's where they work. They work at the airport.
Right, but it's being paid out of the Transportation Trust
Technically,
Fund?
the airport money all goes to the general fund, and then it gets paid back out. In other words, they're making money for the state. They don't get to keep their money in a little
Yeah,
pot.
but I thought it went to the Transportation Trust Fund.
Well, I don't think so. But, I mean,
MAA?
they were, they are like the number one economic driver for the state. They make a lot of money. And our public safety in all the counties surrounding where they have memorandums of understanding all have binding arbitration.
Yeah, no, I mean, again, I don't necessarily like the bill necessarily, but I do appreciate the limitations of the state budget saying, I mean, I'd like to see that on every collective bargaining bill that we come forward with now. Might be the
Yeah,
case.
technically
the case, so.
The arbitrator really does have to.
Okay, yeah,
It's
they're
fronted from the
TTF.
TTF.
Yeah,
So
they're in transportation, so they're TTF. yes.
Okay, so is state budget and TTF the same?
Yes.
You guys are comfortable with that?
I've checked with
Okay.
guide zoning and budget and tax, and it was fine.
That's all. Okay, thank you.
Have a motion? Senator Kramer motioned. Do I have a second? Senator Ellis seconded. All in favor of, what bill was that? Senate Bill 373. You better call the roll, Madam Manager.
How many firefighters in
100. It's 100 firefighters.
Senate Bill 373, favorable with amendment. Vice Chair Hayes.
Pass.
Pass. Senator Kramer.
Yes.
Yes. Senator Reedy.
Pass.
Pass. Senator Ellis. Senator Ellis.
Yes.
Thank you,
Yes.
Senator Ellis.
Senator Mounts.
Yes.
Yes. Senator
He
Jackson.
made up for you.
Yes. Senator Guile.
Yes.
Yes. Senator Lamb. Yes. Senator Hershey.
Public safety.
Under the limitations of the state budget, I'll say yes.
Yes.
No, that is a good one. That's a good one.
I just wanted to be sure you weren't left all alone.
Thank you.
That's why I'm asking.
Senator Reedy.
I will vote yes.
Yes.
Good bill with this excellent amendment.
Vice Chair Hayes.
Sure.
Yes. Madam Chair.
Yes.
Yes. Unanimous.
Man, I was
Bill
getting
passes.
worried. When the vice chair passed, I thought, jeez.
Okay, the next bill is Senate Bill 439. I think you might want to hold that one too, because I'm not prepared to discuss that one. Senate Bill 734, I don't know very much about either, but the chair does.
Actually, we have checked with everybody, the comptroller, and everybody's fine with it. You know, they're just, it's the license that's issued for storage warehouse.
734.
Yeah,
Move. Second.
okay. Senator Mounts and Senator Hayes, all in favor of 734? Unanimous vote, thank you.
And then the last bill that's not withdrawn is Senate Bill 754, and I believe it's passed this committee several times, and Senator Kramer can opine or comment on it if he wants.
If anybody has any questions, my thanks to the committee for having passed this unanimously at least a couple of years now. And as I said, we'll just see if we can keep it on Main Street when it crosses over. So move favorable, Madam Chair.
I have a favorable from Senator Kramer. Senator Ellis seconded. All in favor of Senate Bill 754? Unanimous vote.
Okay.
We held it because Amber's not here.
Yeah, not, I
I can speak to it. We were almost ready.
Okay, go ahead. Senate Bill 439.
This came out of an audit from joint audits previously where they were looking at these high impact economic development entities that were attached to our higher education institutions. There are a few of them in the state. These HIDAs have certain special designations, including the ability to sole source. And I think that was a concern. There was also concern with OLA being able to audit the funds that go to these HIDAs. And when we checked with OLA can actually audit the funds. And what the conflict there was that the HIDAs kept saying, no, you can't. And OLA didn't press them on it, that they could have probably sued or taken them to court or something, or maybe the AG could have sued them to actually access the books to be able to audit state funds, because it says in state law that state funds designated to any entity can and is auditable.
Senator Lamb, is this a good bill?
And it did.
It's a good bill.
Move favorable.
And then Senator Ellis was doing some.
So I had the question about the audit. And so the point, I was waiting for the answer, so thank you for that, Senator Lamb. So why, I mean, the requirement is not in the bill that they be audited. Could we make it clear, put amendment in that they are subject to audit? And
It's in another part of the statute.
Question.
It's in the part of the statute that deals with OLA. That OLA has the ability to go audit any state funds or entities that are recipient of state funds.
Okay, but they, under the testimony that they had, when there's a bill here, they're saying that the entity, High Impact, said, oh, we're not subject to audit. And the auditor said, okay, and they didn't.
The auditors, if you read the audit, they said that like they don't believe they have that authority, but OLA didn't push them to take them to court.
So we now know that they do.
Now they've agreed to it anyway, but now.
Right, now they've agreed to it
The
anyway.
law says they have to.
Yeah,
so.
and the law, existing law says that they have the ability to do that. OLA, I think, was just a little bit light-footed when they were, going in. They could have probably pressed the issue and taken them to court, but they didn't.
So you think they know now that they have the authority, so on the next.
OLA knows that they have the authority. They just didn't like press it through or have the AG's office sue on their behalf.
So they don't need our help to remind them they have the authority? Is that what you're saying?
Oh, they have the.
Well, he's off the committee.
It's in statute that they have that
It's a statute,
authority.
yeah.
And in this instance, the HIDA has agreed to open up their books now. They want to.
Okay, so we don't need any action here.
I don't think we need any
Because it's
additional.
already in statute that they're subject to audit.
Yeah.
So there were no amendments on the bill,
No.
Okay.
and it's just this question.
Yeah, it was just this
You okay
question
now,
from last
Senator
time.
Ellis, are you okay with it?
Well, I mean, if it's in there, I'm okay with the bill. I mean, I was just concerned, there was a troubling bill here where they're an agency that takes, created by the state, gets state money. They took up 25 million, said, hey, you can't audit us, and the auditors went away. I was really troubled with that. And
You want
so,
to wait and talk to the auditors and just confirm, or maybe Senator Lamb, you can find where that is in the
Yeah, I mean,
code and show it to.
Can we move the bill and then we'll follow up?
Yeah, Senator Ellis is a
Yeah.
CPA, and he
Yeah,
has
no,
a
I
concern
get
that I
that,
think we
yeah.
need to address.
yeah. And so, yeah, did we get a letter from the auditors? Is that what you're saying, Madam Chair, to get?
The OLA doesn't take official positions on bills.
Well, we don't want a
But they-
position, we want
But they can.
information.
It's in the statute.
Yeah, it's in the
Find
statute.
it in the statute, show it to Senator
Yeah,
Ellis.
could you, yeah.
Okay.
And that's what I was waiting for when I asked for the home.
Okay.
Sure.
So let's hold it until we know for sure. Okay.
And,
We'll get you a copy.
Somebody's going to find, when Amber comes back, she'll find it in the statute.
Okay. Okay, so the last things on your list are several withdrawals, including the constitutional amendment about tipped workers.
I've got the motion.
There's another bill, though, right?
Yes, there's another bill. There's the bill that actually, that's. No, there's the other bill, which is still next week, yes.
So I'm going to ask for a motion unfavorable withdrawn for Senate Bill 809, Senate Bill 986, and one more that we added, Senate Bill 973, Senator Lamb's bill on aviation oversight. So all right, so we got Senator Ellis moved and Senator, what's your name, Hayes, seconded.
That guy right there, that guy.
Thank you all.
Thank you.
Some of you will be here.